Court officer. Court officer. Court officer.
ಹೇಳಿ ಸರ್.
Serial number 65, page number ಎಷ್ಟಾಗತ್ತೆ?
ಸರ್.
ಪೇಜ್ ನಂಬರ್ 18 ಫಸ್ಟ್ ಮೆನ್ಷನಿಂಗ್ ಇದೆ ಅಲ್ಲ?
ಪೇಜ್ ವೈಸ್ ಕರಿತೀನಿ.
18ನೇ ಪೇಜಾ?
ಹೌದು ಸರ್.
65 ಆರ್ ಗೋಪಾಲ್ ಡಿ ಸಿದ್ದರಾಮಯ್ಯ.
ಇದನ್ನೇ ಹೋಲ್ಡ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ದೆ, ಸ್ವಿಚ್ ಆಫ್ ಆಗ್ಬಿಡುತ್ತೆ
ಸರ್. ಸ್ವಿಚ್ ಆಫ್ ಆಗ್ಬಿಡ ಮತ್ತೆ ಮಾಡಿ ಸರ್. ಆನ್ ಆಗಿದ ತಕ್ಷಣ ಬೇಕು. ಇದು ಒನ್ನಿಗೆ ಆಗಿತ್ತು ಸರ್.
ಇದು ಒನ್ಗೆ ಆಗಬೇಕು ಸರ್. ಒನ್ಗೆ ಇವಾಗ ಪ್ರಶ್ನೆ ಇಟ್ಕೊಂಡ್ರೆ ಪೇರ್ ಆಗಬೇಕು. ಇವಾಗ ಹೋಗ್ತಾ ಇದೆ.
ನಲ್ ಮ್ಯಾಟ್ರ್ ಸಾಧನ ಮೆಮೊ ಕೊಟ್ರೆ 26 ಕೊಡಿ ಪರ್ಮೇಲಿ. ಮಂಡೆಗೆ ಯಾವ್ದು ಕೊಡ್ಬೇಕು? 83 ಆಗ ಹೋಗ್ತಿದೆ. ಕೊಡಿ ಕೊಡಿ.
ಹೌದು ಸರ್. ಇಲ್ಲ ಇಲ್ಲಿ ಇದು ಸ್ಟೇಬಲ್ ಆಗುತ್ತೆ.
ಸ್ಟೇಬಲ್
ಸ್ವಿಚ್ ಆಫ್ ಮಾಡೋ ಎರಡು ಒಟ್ಟಿಗೆ ಆನ್ ಮಾಡಿ. ಈ ಮೋಡ್ ಬಂದ್ಬಿಡ್ತಾ ಇದೆ ಆಕ್ಚುಲಿ. ಇವನು ಸರ್ಚಿಂಗ್ ಮಾಡ್ಬೋದು. ಸರ್ಚ್ ಮಾಡ್ದ ಅನ್ನೋ ವೈನ ಇದು ಬ್ಯಾಕ್ ಆಗ್ತದೆ ಅಂತ. ವರ್ಷನ್ ಬೇರೆ ಇದ್ರೆ ಆಗಲ್ಲ. ಏನೆಲ್ಲ ಒಂದೇ ವರ್ಷ
ಸರ್.
ಅದನ್ನು ಟ್ರೈ ಮಾಡ್ತಾರೆ. ಡಿಟೆಕ್ಟ್ ಆಗ್ತದೆ. ಇಲ್ಲಿ ಡಿಟೆಕ್ಟ್ ಆಗ್ತದೆ. ಇದು ಬಟನ್ ಅಂತ
Ten minutes late, sir. 10 minutes late. 10 minutes late. Late.
ಓಕೆ.
ಸರ್ ಹೇಳಿ ಸರ್, 10 ನಿಮಿಷ ಲೇಟ್.
ಓಕೆ.
ಅದು ಮೆಮೋಸ್ ಎಲ್ಲ ಫ್ರೈಡೆಗೆ, ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ. GKB ಅವೆಲ್ಲ 28 ಬೇಡ, 27 ಬೇಡ. ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಡೇಟ್. 27, 64 ಇದೆ ಆಲ್ರೆಡಿ. 64 ಮ್ಯಾಟ್ರ್ ಇದೆ. ಯಾವ್ದು ಇಲ್ಲ ವೈಟ್ ಇದು ಮಾಡೋದ್ರಲ್ಲ For adjournments, page number 13, seal number 35 to 41.
Mela. Serial
Only after compliance of the mandate.
number 24, Mela.
27.
I appear for the applicant on behalf of Geeta Menon Myla. In this case, respondent number 3 to 9 has not made a
Yes,
separate
madam.
28.
We are the children and grandchildren of the appellant minor, and our 7 to 9, we are not seeking any.
Page number 13, seal number 35 to 41.
30. 33.
Self-sufficient.
Realist.
28.
Realist.
Trade rating. Not abandoned to pass title. Is accepted.
Realist.
So it can be granted minor.
Subsection in that regard is
Page number 14, seal number 42 to 48.
Realist. Goes along with so and so on.
Page number 15. Page number 15, seal number 49 to 52.
Please inform them. Realist.
Page number 16, seal number 53 to 60.
Realist.
Page number 17, seal number 61 to 64. Page number 18, seal number 65 to 67.
Please wait, 2013. Please wait. Is to read the name of Shri Vinay Vasmat is appearing with the petitioner since Shri D.S. Vasmat is no more. Released after 2 weeks only.
5th July. Page number 19, C number 68 to 70.
Please wait, 2015, please wait. Please wait, let us see.
Page number 20, C number 71 to 75. List number 2 for non-compliance of office objection, first time matters, serial number 1 to 6.
18. As requested in the memo, criminal petition is dismissed as not pressed. 2 weeks. 1 to 6, 2 weeks.
Second time matter, serial number 7 to 12.
Serial number. Petitioner submits that the petition may be dismissed as not pressed. Accordingly, petition is dismissed as not pressed. They have dismissed it already. 7 to 12, 2 weeks, failing which petition stands dismissed. 2 weeks. You madli landre vacha vidate.
What is that? Third time matter, serial number 13 to 15.
1 week, failing which petition dismissed.
Fourth time matter, serial number 16 to 7.
2 weeks. Execution. Criminal petition.
Still a second list. Fourth time matter, 16 and 17.
Despite grant of 4 opportunities, office objection not complied with. Petition is therefore dismissed on prosecution.
16 CH Ramakrishna, party in person.
17 and 19 same was.
For fifth time matter, serial number 20. Should we know this?
Same, despite 5 opportunities.
List number 1, fresh matters, serial number 1, Sri Manjunath MB.
My lord, in this case, I undertake to file wakalat on behalf of BESCOM, my lord.
This one so accepts notice on behalf of Indra Reddy. Respondents 2 to 6 2 to 4. Issue notice to R5 to R7. HCGB to take notice for R1. Relist on. I can't by an intermodal disconnect madakagala or barli amel no.
5th July.
Much.
Serial number 2, Sri Bharat K.
What are you seeking for consideration? For what? The petitioner has sought for a mandamus to direct the third respondent to consider and dispose of his representation dated 22/4/2024, 29/4/2024, and 24/5/2024. With these representations, the petitioner is seeking for a change of his location from the existing license premises. In view of the fact that the petitioner is seeking for transfer of the location of his business, it will be appropriate to direct the respondent, third respondent, to consider the receipt representations and pass an order in accordance with law within a period of 2 months. ಎಷ್ಟು ದಿನ ಇದೆ? ಒಂದು ವಾರದಲ್ಲಿ ಮಾಡಕ್ಕಾಗತ್ತಾ ಅವ್ರ ಕೈಲಿ? ಒಂದು ವಾರದಲ್ಲಿ ಮಾಡಕ್ಕಾಗತ್ತಾ? Agatha, madam? Can you do it before? No, can you do it before the 30th of June? On or before 30th of June, 2024.
For preliminary hearing, seal number 3, Sri N. Suresha. Sri N. Suresh.
Today also there is no representation. So the matter was adjourned to today as a last chance. The place of petition not interested in prosecuting the matter. Hence petition is dismissed, non-prosecution.
Seal number 4, Sri Nagendra Kumar.
Realist.
28. Seal number 5, Sri Nandesh Gowda GB.
CGP to accept notice for R1 to R3. PPTC. With Rakshita to take notice for R4 and R5, relist on 5th.
Seal number 6.
Let him reconsider. In Prakash, 2 years. True. That means you should have been more diligent, isn't it? For 2 years, if you don't take any action, for how long can the magistrate wait? He says 2015, the B report was filed. When was the B report filed? So you took 2 years to file your protest petition, and for 1 year thereafter you did not take any steps. The fact that you don't take any action for 3 years goes to show you're not interested. But I believe you should have been careful, isn't it? Where has he explained? Prakash, the complainant's bank advocates had lost track of the case and he did not follow up. The lawyer, if he loses track of the case, it's obviously because the client has lost track of the case. I will not be enamored with that 4 crores. If you show so much of disinterest in prosecuting a case involving 4 crores, why should anybody be generous to you? Fine. 1 lakh. 1 lakh bank tane. Take 50,000. Fight. Take 50,000. You are getting 50,000 free. The trial court by the impugned order has accepted the B report since the complainant and his counsel were continuously absent. Next, learned counsel for the petitioner contents that the complaint involves a total value of rupees 4 crores, and if the bank is not permitted to prosecute its protest petition filed to the B report, severe prejudice will be caused. Though there is no justification for the non-appearance of the complainant or his counsel, in my view, in the larger interest of justice, it would be appropriate to give one final opportunity to the petitioner to prosecute his objections to his its protest petition to the B report. However, this shall be subject to the condition that the petitioner deposits a sum of 50,000 payable to second respondent, payable to respondents 2 and 3 within a period of 2 weeks from today. 4 weeks. Consequently, the impediment order is set aside. The matter is restored on the file of the 4th additional chief metropolitan magistrate, and the magistrate is directed to give one final opportunity to the petitioner to prosecute its protest petition to the B report. So it is made clear that if there is any attempt to delay the proceedings further, the magistrate would be at liberty to accept the B report. So, petition is accordingly allowed.
See number 7, 4 weeks.
Well, this is the case where the petitioner has filed. Lordship able to hear me, my lord? Your Lordship is able to hear me, my lord? My lord, the petitioner before Lordship, my lord, the subsequent purchaser. The petitioner herein, my lord, the respondent is filed the application for vacating. He purchased the property, my lord, in the year 2018. The kata was made in his name then my lord, kata was made in his name in 2021. He has paid the tax up to date. The encumbrance stands in his name. There is a building, my lord, the sale deed itself. Building was constructed in the year 2015. My lord, then after purchasing, my lord, he made an application for plan. Plan was also sanctioned. My lord, he dug the borewell. At that time, my lord, the respondent, the petitioner herein, he has come and demolished the building. That is the case of the petitioner, my lord. What your lordship will have to see is whether 482 is available. Only, my lord, what your lordship will have to see is only the complaints, averments. This is all the averments, my lord. In view of the Bhajanlal's case, my lord, the parameters have been laid down by Bhajanlal. My lord, only the 8 parameters have laid down. Only in those circumstances, my lord, the 482 can be passed. Now the respondent, the petition before your lordship comes up before your lordship in view of the subsequent events, and that the suit was filed and the injunction was refused and appeal was confirmed. That cannot be looked into by your lordship, because what was there on the date of the commission of the offence is the only thing that has to be looked into. And in view of the 1992 Supreme Court 604 mela, the government in the complaint shows there is an ingredient and trespass is there, building is admitted demolished. Well, even if he has got any case, he has to appear before the investigation. Investigation has not yet been done. The moment the complaint is filed, he has come before this court. Well, it's premature. What your lord, he may be directed to appear before the magistrate on cooperating the investigation. And whatever he wants to say, he can say before the investigation officer. Nothing, whatever the case of the respondent or the accused, who is the petitioner before lordship, which has occurred subsequently, cannot be looked into by your lordship. That's what I wanted to submit before lordship, my lord. And the 482 is not maintainable. That's my submission, my lord.
When was the suit filed?
Well, a suit was filed subsequent to filing of the complaint. Subsequent to filing of the complaint.
Suit for? TA refused or granted? TA? 22. Appeal. Appeal. MFA. 724. What? Dismissed on. Very much. The petitioner is before this court challenging the registration of a crime for offences under section 427, 506, 341, 504, 143, 149 and 448 of the APC. It was the contention of the second respondent complainant that she was the owner of a property bearing number 525 situated at Remco Cooperative Society, Patangere Village, Kengeri Hobli, having purchased it under a sale deed dated 25/10/2018. She stated that her vendor was the originality from the society, and pursuant to the sale deed, she was in possession and enjoyment of the said property. She stated at the time of purchasing the property itself, there was in existence a residential house with asbestos roof sheet, and it also had water and electricity connection. She stated that after she purchased the property, the water, electricity connections, and so also the Kata were transferred in her name. She stated that in order to put up a residential building, she had also applied for and secured an approved plan from VVM. However, on 13/8/2021, she also submitted on 13/8/2021, she had also sunk a borewell. And on that day, the petitioner herein had lodged a complaint against her, stating that he was the owner and had requested the police to ensure that the borewell was not sunk. But the police, after being satisfied that she was the owner of the property, had allowed her to carry on with the drilling work. And she had completed the drilling of the sinking of the borewell as well. She stated that about 13 days thereafter, on 27/8/2021, when she and her husband were sitting inside the house, suddenly the petitioners, along with 15 to 20 people, trespassed into their house and picked up a quarrel with her and her husband and abused them. She therefore stated that the petitioner had committed a criminal offence for which he was required to be prosecuted. The police, on receipt of the said complaint, proceed to register an FIR on 27/8/2021. Next, Learned Counsel for the petitioner contends that about a month after the filing of this complaint, the second respondent had instituted a suit for injunction in OS number. What's the number? And in the said suit, the prayer of the second respondent for injunction was refused by an order dated 16/7/2022. He submits that an appeal filed against the said order in MFA 7241 of 2022 was also dismissed by this court on 15/3/2022. He therefore submits that, in essence, the second respondent was attempting to convert a civil dispute into a criminal prosecution solely with the intent of harassing the petitioners. Next, Learned Senior Counsel appearing for the petitioner contended that so long as the complaint contained the ingredients of an offence, the registration of FIR is mandatory and the same cannot be interfered under section 482 of the CRPC. Next, it is to be stated at the very outset that if any attempt is made by any litigant to convert a civil dispute into a criminal prosecution, that would clearly tantamount to an abuse of the process of the court, and it becomes incumbent upon the High Court to invoke its power under section 482 and quash the proceedings. In the instant case, a complete reading of the complaint would indicate that the essential dispute between the parties is regarding the alleged possession over a site. So both the parties claim title over the said property. The fact that the second respondent has already instituted a suit seeking for an injunction, in which her prayer for interim order is refused and confirmed by this court, Also establish the fact that this is a clear case of a civil dispute and there is no criminality involved in the case. And therefore, of the view that this is a fit case to invoke section 482 and quash the proceedings. Consequently, the proceedings shall stand quashed. Petition is allowed.
Seal number 8, Shri M. Ramaya, party in person. M. Ramaya. Michael Magan. Mike,
ಅದನ್ನ ತಗೊಂಬರಕ್ಕೆ ನಿಮ್ಗೆ ನಂಗೆ ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ ಅಂದೆ. ನಮ್ಮ ಮಗ ಡ್ರೈವರ್ ಅವ್ನು ಕರ್ಕೊಂಬರಕ್ ಆಗಲ್ಲ, ಅವ್ನು 4-5 ದಿನ ಆಗೋಯ್ತು ಹೋದ್ರೆ ಟೂರ್.
ಏನಿದು?
ಪ್ರೈವೇಟ್ ಬಸ್ ಕಾರ್ ಡ್ರೈವರ್ ನೋಡಿ ಎಂತ ರೆಕಾರ್ಡ್ 14 ರೂಪಾಯಿ ಸೀಲು ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. ಬರೀ 4,000 ರೂಪಾಯಿ ಅಂತ ಸುಳ್ಳು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಕಸ್ಟಮರ್ ಈ ತರ ದುಡ್ಡಿದೆ, ನಾವೇನ್ ಸ್ವಾಮಿ ಮಾಡೋದು? 7 ವರ್ಷ ಆಯ್ತು. 14,000 ರೂಪಾಯಿಗೆ ಸೀಲು ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ ನೀವು ಎಂಟೈರ್ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದೆ. ಆ ಕೋರ್ಟ್ ಒಂದು ಕೊಡೋದು ಲೇಟ್ ಮಾಡ್ಬಿಟ್ಟು 2-3 ತಿಂಗಳು ಮಾಡ್ಬಿಟ್ರು. ಮೊನ್ನೆ ಕೊಟ್ಟರು, ಅದನ್ನ ಸಬ್ಮಿಟ್ ಮಾಡಕ್ಕೆ ನಾವು ರೀಕಾಲ್ ಮಾಡಿಸಿ 14,000 ರೂಪಾಯಿ ತಗೊಂಡ್ರೆ ನಿಜ 7 ವರ್ಷ ಆಯ್ತು. 3-4-17ರಲ್ಲಿ ಇನ್ವಾಯ್ಸ್ ಎಲ್ಲ ಇದೆ ಸ್ವಾಮಿ, ರಸೀತಿ ಎಲ್ಲ ಇದೆ. ಅಲ್ಲಿ ನೋಡಿ ಪ್ರೂಫ್ ಮಾಡಿ ಸ್ವಾಮಿ, ಅಷ್ಟೇ ನಾನು ಕೇಳಿರೋದು.
I see no reasons to recall the order. Application is dismissed.
Seal number 9, Shri N. Krishna Swami. Shri Vivek Holla for respondent.
Now what happened?
ಮೇಡಮ್ ಏನಿದೆ?
Where is he?
Last time direction is presented.
Where is he? Was asked to be present today. Asor ಮಾಡಲ 2:30 ಕರೀತೀರಾ? Asor.
Seal number 10, Shri V. Vachan.
That's for petitioners in 10.1, my lords. Notice is awaited to R2.
Who's R2?
Complaining.
DVRಗೆ? Respondent. Okay. Who's the second respondent?
Allowed.
Or address ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ?
But one Mr. Yogananda came, lords, in Yelahanka.
ಏನಂತ ವಾಪಸ್ ಬಂದ ನೋಡಿ. ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಇದೆ.
Lords, we have taken steps, my lords, but it was returned.
Then take out paper publication, that is all. A week's time is granted to take steps for effecting service on R2 by substituted service.
Weeks.
Carry out the implement.
Party ಮಾಡಿಲ್ವಾ ಅದರಲ್ಲಿ?
ಇಲ್ಲ, ACB was a party. No.
In
Now
view of
that
the
is
subsequent
resolved.
events, the Lokayukta shall be pleaded as the third respondent. The
Has to
substitution
be amended, my lords. I will carry on.
La connected metal ಕೇಳ್ತಿರೋದವರು 10.1 ಅಲ್ಲಿ.
ಹೌದು, I appear in 10.1.
ಅದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು?
ಅಲ್ಲ, my lords, it was ACB, my lords. Now that it's to dissolve, now it has to be changed to local.
Lokayukta is pleaded as the third respondent. Copies ಕೊಡಿ ಅವ್ರಿಗೆ.
Seal number 11.
I am for the petitioner in this case, my lord.
I don't want to call them here. If you want, if you're forcing me, I'll issue an order. When the CGP submits that the sketch was ordered to be prepared, is in the process of being prepared and seeks for some time. Relist on so and so, by which time the order dated 7/6/24 should be completed. Exactly, first sketch clear.
28. Seal number 12. Hey, Ganapati Narayan Bhatt.
Who's the respondent?
My lord, 1 week time is,
Who's the respondent?
respondent is Baji Saab.
Private respondent.
Private respondent.
In dispute,
Dispute ಅದೇ ಇದ್ರದ್ದು
Compensation.
ROW ಇದ್ರಲ್ಲಿ ಹೋಗಿದೆ. They are asking for some
Weeks time is current.
Seal number 13. Shri Balagangadhar JS.
My lord, I pray for 2 weeks' time to take steps and to file objections to these applications, my lord.
ನಿಮ್ದೇ ಅಲ್ವಾ LRs of disease P2.
ಅದಾಗಿದೆ. Again, my lord, respondent number 11 is reported to be dead.
IA2 allow ಮಾಡದ ಬೇಡ.
IA2, my lord, this already petitioner number 2 allow ಆಗಿದೆ.
ಯಾವತ್ತಾಗಿದೆ?
ಅದು earlier ಮಾಡಿದ್ದಾರೆ. It was considered. Second petitioner is dead, my lord. No, it's still pending, I beg your pardon.
Allow ಆಗಿಲ್ಲ. The application.
I have made 2 applications.
Second petition on record. IA2 by 2023 is allowed.
Please.
Stated to be amended.
Madam, I have made 2 applications, but I am appearing for R5 to 10 and 12 to 24. But I made 2 applications. One is for direction and another one is for police help. Because this is under KVO, my lord. I have purchased the property in 1963. But it is excluded from this rights and in terms of the Syed Bashir Ahmed full bench decision. My property sale transaction is stay, but it is feeder of grant of estoppel, my lord. That is the principle involved. But I am in possession now. They are by virtue of this interim order, they are disturbing.
No, my lord.
And
I will file my objections detailed because
date.
on the earlier date, my lord, they filed an application for modification.
Yes,
Only, my lord, standing crops should not be disturbed. That was recorded by your lordship earlier.
my lord.
And my lord, the matter was remanded long back, my lord. Your lordship directed to Tahsildar to pass an order immediately.
My lord, 6 December.
I will file my detailed objections, my lord.
No issue, my lord. Let him lodge me. And whatever time. My lord, 6 December 23.
This, my lord, I will
Pass
file
an order.
place necessary records, my lord.
My lord, I am in possession and cultivating the crops. Some disturbance because of this interim order, some
Cannot be, my
confusion.
lord. Now, my lord, the matter is pending before the district judge, my lord.
What is the direction they are now seeking for?
One is not to disturb my cultivation of the land, but in which I am 1 acre of land I am cultivating out of 4 acre 28, which I purchased in 1963. And another one is because frequent, the FIR has also been registered. And in spite of that, they are disturbing.
If you had made a statement that he
Yes.
can cultivate, he can harvest the standing
Yes.
sugarcane crops.
Yes.
No,
Can you prevent him from cultivating?
no, my lord. That was only an interim measurement. Your lordship may kindly appreciate, my lord.
This. Can you interpose?
No, please, my lord. My humble submission is, my lord, now, my lord, these 2 applications are misconceived. Now, your lordship may kindly appreciate, there was a stay order by the district court in against the orders of the Tahsildar re-granting the land.
What is the order?
Now, my lord, MA is pending, my lord.
What is the order that you have impugned here?
My lord, the interim order granted by the district court, my lord.
Where is the impugned order?
Yes. The annexure A, my lord.
What was the order of the Tahsildar?
My lord, we were the earlier entitled for the land.
What was the order of the Tahsildar?
My lord, we were petitioners. Your lordship, my lord, that was early.
The order of the Tahsildar?
Please.
Yes, my lord, annexure F.
Next year?
Annexure F. Page 53.
This was considered 53, my lord. My lord, that was not considered earlier. Before that, my lord, kindly peruse, my lord, annexure E, my lord. There was a direction by your lordship to pass an order immediately. They kept quiet for 10 years. Then, my lord, the Tahsildar considered all these aspects.
An order of re-grant you challenged.
Yes, my lord.
Now there's an interim order of stay of this.
Yes, that was stayed by this honorable court.
And it is.
And
Against the matter is pending before the district court, my lord. Still. This is, my lord.
I will direct the district court to dispose of the appeal Until then,
Yes.
their possession should be.
No, no, my lord,
Date of
definitely, I will
purchase,
be, my lord, I will be, I had the benefit of an interim order.
No, no.
No, no, my lord,
Then
kindly
here.
appreciate, my lord.
If you, Bal Gangadhar, if you had said that they can
My lord,
harvest
that-
sugarcane crop.
My lord, that was only one for one, that occasion, because, my lord, what has happened?
Can't
The
use it.
position was, kindly, my lord, RTCs are in my favor. I will file my
No, no.
detailed objections, my lord.
After the
Kindly, my
order, he
lord,
has
this
got
will,
it.
my lord, this will lead to lot of confusion at the spot.
You are creating this.
No, no, my lord. No, no, my lord. I will place all records, my lord. Kindly, one opportunity, may
In one
kindly.
breath, you say that they had raised sugarcane
No.
crops.
My lord,
Can harvest it.
RTC is in my name.
After harvest, you are saying, no, no, nobody should enter into.
No, my lord, what has happened? Now, my lord, the crops are grown by me. They are disturbing my
No,
position.
how it could be.
Sorry, my lord.
No, no.
I will produce all the necessary documents.
In possession.
My lord, immediately after that.
No.
They say that, my lord, only to a certain extent.
But
RTCs
63, I am
are in my
possession.
favor, my lord. My lord, I will
63.
place all the necessary documents. Kindly, my lord, one opportunity may kindly be granted. Because, my lord, if they take that,
Used it.
Lord,
my lord,
where
no,
is
my
the-
lord, a week, 2 weeks time, because I have to take steps for respondent, my
But
lord.
order ಮಾಡಿ created one chance ಇದಕ್ಕೆ ನಾನು Tuesday ಅಂತ ಅಂದೆ.
Lord, may
ಅಲ್ಲಲ್ಲ ಹಾಗಲ್ಲ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ದೇ ಹ್ಯಾವ್ ದಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮೈ ಲಾರ್ಡ್ ವಾಸ್ ಸ್ಟೇಡ್ ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್
Tuesday,
ಕನ್ಸಿಡರಿಂಗ್ ಆಲ್ ಮೈ ಪ್ರೇಯರ್ ಮೈ ಲಾರ್ಡ್
Tuesday.
ಐ ವಿಲ್ ಫೈಲ್ ಮೈ ಅಬ್ಜೆಕ್ಷನ್ಸ್
Number 14.
ಏನ್ clubbing ಏನು?
my lord one more submission with one respondent is dead my lord I have to take steps my lord that's the no problem I may face
ಅವ್ರೇನ್ contesting ಏನಲ್ಲ ತಾನೆ.
ಇದರ ಅವ್ರ ಕಂಟೆಸ್ಟಿಂಗ್ ಅವ್ರ ಕಡೆನೆ ಅವ್ರ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅವ್ರ ಅದಕ್ಕೆ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ
ಮಂಗಳವಾರ ಮಾಡಿ ಬನ್ನಿ.
ಆಯ್ತು.
The respondent also filed a writ petition in WP 3122/2024.
WP 3122/2024 along with this writ petition. On
28. Number 15. Timothy Sudati.
who's R1 and R2?
I will have to is KSBCL and report manager, my lords.
Sir
The
ಮಾಡಿದ್ರು.
vehicle is, I have already served and I have filed acknowledgement also.
ಯಾರಿಗೆ ಸರ್ ಮಾಡಿದ್ರು?
Department, my lords.
ಅವ್ರಿಗೆ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ?
There is no standing council, my lords. That's why we served through hand.
ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟಿದ್ರೆ ಕೊಟ್ಟಿಲ್ವಾ? I said you should do both.
No, my lords. The offense is already compounded, my lords. They have paid the penalty amount also.
ಏನ್ ಮೇಡಮ್ ಕೇಸ್ ಬಿಲ್ is not going to come? Released next Thursday.
Please, my
Please
lords.
ask him to come and enter appearance. Government company ತಾನೆ?
28.
Please, my lords.
For hearing on IA. Silver 16. Shri Jai Prakash Reddy.
The impleading applicants. The impleading applicant.
Who's for the petitioner?
Shri Jai Prakash Reddy.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ.
Please, my lords.
See number 17. Shri R.
Contempt on substitute.
Then SCGP produces the copy of the order dated 19th of June 2024, whereby the government has accorded approval to the appointment of the petitioner. It is therefore clear that the order passed by this court on so and so is complied with
1512.
and no further orders are required.
I've asked him.
Application pending ಇದೆ ನಿಮ್ದು?
ಹೌದು. Application ಹಾಕಿದೆ.
The application filed by the institution
Respond 7.
seeking for favor of the cost that has been imposed, stating that it has complied with the direction and submitted a proposal within 1 week is accepted. The order directing payment of cost only shall stand record.
For admission, seal number 18, Shri Rupesh Abhi. Shri Rupesh Abhi. Number 19.
ಏನಾಯ್ತು ರೂಪೇಶ್?
Number 18.
ಐ ಸ್ಪೋಕನ್ ಟು ಮೈ ಕ್ಲೈಮ್. ಅವರು 10 ಲಕ್ಷಕ್ಕೆ ಎಂಟೈರ್ ಎಲ್ಲ ಸೆಟ್ಲ್ಮೆಂಟ್ಗೆ ಒಪ್ಕೊಂಡಿದ್ರಂತ ಅವ್ರ ಅವಾಗ್ಲೇನೆ. ದಟ್ ವಾಸ್ ನಾಟ್ ಪಾಸಿಬಲ್, ಅದಾಗಿರ್ಲಿಲ್ಲ ಅದು. ಈಗ ಅವರು ಜಾಸ್ತಿ ಕೇಳ್ತಾ ಇದಾರೆ.
ಅಲ್ಲ ನಿಮ್ಮ ಮಗು ಹೆಸರಲ್ಲಿ ಹಿಡಿತೀರಾ 10 ಲಕ್ಷ?
ಅಲ್ಲ, ಒಬ್ರಿಗೆ ಅಂತಂದ್ರೆ ಕಷ್ಟ ಅಂತ ಹೇಳ್ತೀವಿ.
ಯಾರು ನಿಮ್ಮ ಮಗನಿಗೆ ತಾನೇ ಕೊಡ್ತಿರೋದು ನೀವು?
ಅದಕ್ಕೇನೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು.
ನೀವು ಇದನ್ನೇ ಮಗುನ ಇಟ್ಕೊಂಡು ನೀವು
ಅಲ್ಲ ಬೇಡ, ಇಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು, ಮಗುಗೆ ಮಂತ್ಲಿ ಇಷ್ಟು ಅಂತ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ರೆ ಕೊಟ್ಬಿಡ್ತೇನೆ.
ನೀವು 10 ಲಕ್ಷ ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಮಗು ಹೆಸರಲ್ಲಿ, ನೀವು
10 ಲಕ್ಷ ಆದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ನಿಮ್ದು ಜಾಯಿಂಟ್ ಹೆಸರು ಇರುತ್ತೆ, ನಾನು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವಾಶ್ ಮಾಡ್ತೀನಿ.
ಜಾಯಿಂಟ್ ಹೆಸರಲ್ಲಿ
ಇಲ್ಲಾಂದ್ರೆ ಇದು ಮಗುನ ಹಾಳು ಮಾಡ್ತಾರೆ ಇಬ್ರು ಸೇರ್ಕೊಂಡು.
ನಂದು ಮತ್ತು ಮಗು ಜಾಯಿಂಟ್ ಹೆಸರಲ್ಲಿ.
ಅವ್ರಿಗೇನ್ ಕೊಡಕ್ ಹೋಗ್ಬೇಡಿ.
10 ಲಕ್ಷ ಆಗಲ್ಲ, ಸ್ವಲ್ಪ
ಅದ್ರಲ್ಲಿ ಏನ್ ಬಾರ್ಗೇನ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ.
ಮಂಡೆ ಹಾಕಲಿ ಸ್ವಾಮಿ.
ಮಂಡೆ. You are giving the money to your own son, so I think you should not.
My lord advised him, but he is not ready. ಮದರ್ ಏನಾಗಿದ್ದಾರೆ, ಅವ್ರು ಅವಾಗ್ಲಿಂದ ಊರಲ್ಲೇ ಇದ್ದಾರೆ, ಇವ್ರ ಜೊತೆನೇ ಇಲ್ಲ.
ಅದೆಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬೇರೆ. ಮಗು ನೋಡ್ಕೊಳ್ಳಿ ನೀವು, ಮಿಕ್ಕಿದ್ ನಾನು
ಕೇಳ್ತೀನಿ.
Number 20, sorry, number 19. Srimati Vijaya ML.
For petitioner, my lord.
Your lordship may kindly see that page 155. This is your lordship in the partnership firms. Several times it was
125.
155. The retirement and reconstitution deed of partnership.
Where is the complaint?
Complaint, I will show you. Your lordship kindly see this page 155. Next page, your lordship will see 156. Last para 3. 156. Para 3.
Yes.
Last tell. That the parties year of 3 to 8 have retired and withdrawn from the partnership firm as on 1/10/1999.
Page 156.
Howdo?
Third paragraph.
Third para.
Whereas now the parties here to the third part, Sri S.V. Mrutyunjayappa and the
How? Taking the following sums as under.
115. Retired and withdrawn from the partnership from 1/10/1999.
Please. Then your lordship can see after this, then one Mallikarjun, one of the retired partner, has filed in a PCR in number 86 of 2013. Then it is referred to the police under 156(3). B report has been filed. They have not filed any protest memo, ended in a finality. That is on 28/6/2016. Then after completion of this, one more partner, that retired partner, one more PCR is filed on 8/2/2017.
Partner would file that PCR.
First filed on SP Mallikarjun, serial number 4.
Sixth part, SP Mallikarjun.
Please, Mallikarjun. PCR number 86 of 2013.
ಏನಂತ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು?
This allegation is, this is created fraudulently, that we have not signed this document. Section 418, 419, 420, 465, 468 was registered. Then on 28/6/2016, B report filed. They have not filed any protest memo. Then it came finality.
B report ಹಾಕಿದ್ಯಾ ಅವಾಗ?
Accepted on 28/6/2016.
Yes.
The second partner, Satish, who passed away, then his wife has lodged a complaint on 8/2/2017 in PCR number 23 of 2017. 8/2/2017. After filing of the B report in the first case.
SP Satish's wife.
Wife. That also for the same offences.
PCR number?
PCR number 23 of 2017. That is also on 14/2/2017. B report is filed. It was accepted.
14/2 na?
14/2 na?
6 ಹಾಕ್ಬಿಟ್ಟ.
14/2 ಅಂತ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ. 14/2/2017.
Their complaint date ತಪ್ಪಿರ್ಬೇಕು. ಆರರಿಂದ
That I will verify. That also B report has filed.
accept ಆಗಿದೆಯಾ ಅದು?
Accept ಆಗುತ್ತೆ.
ಯಾವತ್ತಾಯ್ತು?
ಯಾವುದು? ಇದ?
23/17.
Sorry, my lord, 1/1/2022.
1/1/2022. ಕಂಪ್ಲೇಂಟ್ ಡೇಟ್ ಯಾವತ್ತು?
Complaint 17.
5 ವರ್ಷ ತಗೊಂಡ್ರೆ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಕ್ಕೆ.
ಹಾಕಿದೆ.
Then
Your lordship can see S.V. Mrutyunjayappa. That one first partner.
third.
He filed a PCR in 69 of 2017.
This year
Number 69 of 2017 for the same offences.
ಯಾವಾಗ?
8/9/2017. Then on 4/7/2022, B report has filed. The same was accepted. In all these three cases, your lordship can see they have not filed protest petition.
ಸತೀಶ್ wife, ಮಲ್ಲಿಕಾರ್ಜುನ and ಮೃತ್ಯುಂಜಯಪ್ಪ.
Mrutyunjayappa.
ಇವಾಗ ಯಾರು ಹಾಕಿದ್ದಾರೆ?
In Yuru, that Karibasappa. Karibasappa lodged a complaint to the police.
ಯಾವಾಗ?
That is on 25/8/2016.
ಅಂದ್ರೆ prior to these two people.
No, these two. The first was B report was filed on 28/6/16. Then on 25/8/16, the file.
First complaint 2013
Complaint is 13.
by Mallikarjun.
Please, ma'am.
This B report is accepted in 16.
Correct. Then Karibasappa on 25/8/16 lodged a complaint. And they filed a charge sheet.
When?
Charge sheet filed.
25/8.
Allah. Charge sheet.
-19.
29/8/2019.
All this was given to the same police station? All this was referred to the same police station?
Same police station. Same police station. Here your lordship can see,
And the contents of the complaint are the same?
same. All have taken a contention that this document is created. Then your lordship can see, against this PCR, my lord, even before filing of the charge sheet, they have filed a petition. ಯಾವ್ಯಾವ್ದು? ಯಾವ್ದು? 482 petitions. 3 petitions have been filed against these 3 PCRs. Because in view of the B report filed, that become infractious, connected matters. 5718.
571.
ಈ ಮೂರು infractions,
5718, 5719
we had infractions.
infractions.
Senate Council.
Then this is the charge sheet against the charge sheet, my lord.
Senate Council submits that 2 petitions. The police have filed a B report. And hence the petition would not survive for consideration. According to its statement, these 2 criminal petitions are disposed of as when become infractions.
ಅದು ಎಲ್ಲಿದೆ? ಇದರಲ್ಲಿ ಎಲ್ಲಿದೆ?
So all that remains is 25/8/2016.
Yes, 2065 is filed against the charge sheet is filed in CC number.
Complaint of Karibasappa.
Please,
There is a complaint. Complaint.
please. Page number, complaint is page number 18, that is typed copy at page 20. May I read, Mala?
Yes.
ಅದೇ ಮೇಲೆ 10/10/99 ಇಸ್ವಿಯಲ್ಲಿ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ಗಳನ್ನು ನಕಲಿ ಸಹಿ ಮಾಡಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫ್ ಫರ್ಮ್ ಇವರಲ್ಲಿ 12/4/13 ನೋಂದಣಿ ಮಾಡಿಸಿರುತ್ತಾರೆ ಅಂತ.
The original partners were. When was this partnership from constituted originally?
1971.
First is 1971. Thereafter, so many members or partners have died, and subsequently several partnerships, the reconstituted
This-
partnership.
Under this 10/2/92,
Please,
which of the partners got out?
10/2/1992, reconstituted deed, death of T.D. Basuraj and his wife, Sulochana was included.
ಇವೆಲ್ಲ ಯಾರ್ಯಾರು ಹೋದ್ರ ಆಚೆ ಯಾರು ಬಂದ್ರ ಅದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ
ಈ ಕಂಪ್ಲೇನೆಂಟ್ ಇದ್ರ ಆಚೆ ಬಂದ್ರ ಅದರಲ್ಲಿ? ಬಿಕಾಸ್ ದೇರ್ ಸೇಯಿಂಗ್ ಅನುಪಮ ಇವರು ಉಳಿದ ಪಾಲುದಾರರ ನಮ್ಮ ಗಮನಕ್ಕೆ ಬಾರದಂತೆ ನಮಗೆ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ದಿನಾಂಕ 10/12/92 ಮತ್ತು 10/10/99 ಇಸ್ವಿಯಲ್ಲಿ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ಗಳನ್ನು ನಕಲಿ ಸಹಿ ಮಾಡಿ ರಿಜಿಸ್ಟರ್ ಆಫ್ ಫರ್ಮ್ಸ್ ಅಲ್ಲಿ. ಸೊ ದೇರ್ ಆರ್ 2 deeds under which the firm is reconstituted, and it's not very clear as which of the partners went out.
ಇದರಲ್ಲಿ your lordship can say the first deed, 7 members were there. On 4/10/86, S.V. Puttappa and Mallikarjuna died.
ಈ 10/2/92 ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ಇದೆಯಾ ಇಲ್ಲಿ? ಪೇಜ್ ನಂಬರ್?
Page number 147.
147. Relevant page is at page 115. 150. S.V. Mallikarjunappa, T.D. Sulochana, S.M. Siddhalingappa, S.P. Satish, Karibasappa, Veena and S.P. Mallikarjuna. That Veena and Mallikarjuna have not filed any complaints. ಅಲ್ಲ ಯಾರು ಲಾಸ್ಟ್ ಮಾಡಲಿಲ್ಲ ಅಲ್ಲ, ವೀರಣ್ಣ ಮತ್ತೆ ಇನ್ನೊಬ್ರು ಮಾಡಿಲ್ಲ, ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ನೋಡು. ಸುಲೋಚನಾ ಮತ್ತು ವೀರಣ್ಣ. ಇದರಲ್ಲಿ ಸುಲೋಚನಾ and ವೀರಣ್ಣ have not filed any complaint.
So under this 10/2/1992,
Please,
Sulochanamma was inducted.
Yes, sir.
That is the only reconstitution.
Her husband was passed away, Basurajappa.
That is the only reconstitution, only one.
Yes, yes, sir.
Then what is the other next?
Next on 1/10/1999. Some of the partners were retired. Because of that reason, Anupama. Siddhalingappa retired, Satodra. Siddhalingappa different,
husband.
ಅವ್ರಿಬ್ರು ಆದ್ರ. ಆಮೇಲೆ ಸಿದ್ಧಲಿಂಗಪ್ಪ ಸತ್ತೋದ್ರು.
Siddhalingappa 1/10/2012.
After the 1/10/1999.
1990.
ನಿಜ ಆಗೋದ 12/4/13. ರಿಟೈರ್ಡ್ ಆಗಿದೆ ಇವಾಗ.
ಯಾರು ರಿಟೈರ್ಡ್ ಆಗಿದ್ರು?
ಎಲ್ಲರೂ ರಿಟೈರ್ಡ್ ಆಗೋದು.
1/10/1990.
And who else remains now?
Remains only is petitioner
ಹೆಸರು?
and ಸಿದ್ಧಲಿಂಗಪ್ಪ.
ಹೆಸರೇನು?
ಹೌದು.
ಅನುಪಮ.
Anupama and her husband Sidlingappa.
Anupama and
Sidlingappa.
1 and 2.
Ah. Then your lordship, Sidlingappa died on 14/10/2012.
12.
14/10/2012.
2012.
Please. Now Anupama is only the
And when this complaint was lodged in 16.
2013. First complaint.
ಇವಾಗ ಕರಿಬಸಪ್ಪನ ಒಂದೇ ದಿನ ಉಳ್ಕೊಂಡ್ರು.
ಹೌದು ಕರಿಬಸಪ್ಪದ ಅವ್ರು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ಬಿಟ್ರು ಕರಿಬಸಪ್ಪದ ಒಂದು ಉಳ್ಕೊಂಡಿದೆ. ಈಗ after lapse of several years from the date of filing of this B report, though they have not filed a protect petition, writ petition is filed. That is also connected.
Writ petition by?
Filed by 3 members.
Complaints against whom the B report. ಯಾರು? ಹೆಸರು?
Please, your lordship, kindly see the party's name. Kavita, Sheila, and Vinay.
LRs of whom?
Kavita is the LR of Satish. Kavita.
ಯಾವ ಕಂಪ್ಲೇಂಟ್?
Kavita is the LR of Satish. PCR number 23 of 2017.
8 to 17 complaint.
8 to 17 complaint.
WP 22665.
Then Sheila and this
Petition 23 challenging the B report of 14/1/2022. Correct? ಒಂದೇ ನಿಮ್ಮ ಸತೀಶ್ ಹಾಕಿದ್ರ ಮೇಲೆ ಹಾಕಿರೋದು ನೀವು. Satish's wife had filed the PCR.
B report ಯಾವಾಗ ಬರೆದಿದ್ದ?
That is on 8/2/17, 14/1/22 is the B report. You have filed WP 22665/2023.
ಹೌದು. ಇದರಲ್ಲಿ what happened, your lordship gets Sheila and Vinaya Surugalli Mrutyunjayappa. They are the LRs of Mrutyunjayappa.
PCR 23, PCR 86, 69.
PCR 86 was challenged by this person. They are not the complainants.
ನಾನು ಹೇಳಿದ್ದು ಸತೀಶ್ ಹೆಂಡತಿ ಶೀಲಾ ತಾನೆ?
Sheila, Allah, Kavita Satish Shanti. Then second petitioner in writ petition.
ಕವಿತಾ ಹಾಕಿದ ಕಂಪ್ಲೇಂಟ್ PCR 23/2017. ಅದು ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರೋದ್ರಿಂದ ಇವಾಗ WP ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
ಈ ಮೃತ್ಯುಂಜಯಪ್ಪ ಹಾಕಿದ್ದು PCR 69/17.
PCR 69/17 ನ
ಇದರದ B report ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಅದನ್ನ ಇವ್ರು ಹಾಕಿದ್ದಾರೆ. ಶೀಲಾ ಅಂಡ್ ದಿ ಥರ್ಡ್ ಪಿಟಿಷನರ್.
ಅದೇ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲ?
ಹೌದು, ಅದೇ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲೇ ಮೂವರು ಸೇರಿ ಚಾಲೆಂಜಿಂಗ್ ದಿ ಬಿ ರಿಪೋರ್ಟ್ ಡೇಟೆಡ್ 4/7/2022 in PCR number 69 of 2017.
Petition is in respect of the B reports filed in all the 3 complaints.
Yes, because
the 2013 complaint, the 2017 complaint, ಮೂರು ಸೇರ್ ಹಾಕಿರೋದು.
ಹೌದು, ಮೂರು ಸೇರ್ ಹಾಕೋದಕ್ಕೆ ಇವ್ರು ಮಲ್ಲಿಕಾರ್ಜುನ್ ಹಾಕಿಲ್ಲ.
ಅದೇ 2013 ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಹಾಕಿಲ್ಲ.
2030 PCR number 86 of 2013 ನ
ನೀವು ಹೇಳಿದ ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಮಲ್ಲಿಕಾರ್ಜುನಪ್ಪ.
ಹೌದು, ಅವ್ರು ಹಾಕಿಲ್ಲ.
2013
ಅದು ಅವ್ರು ಹಾಕಿಲ್ಲ, ಇವ್ರು ಹಾಕಿದ್ದಾರೆ.
2013 ಅವ್ರು PCR ಹಾಕಿದ್ರು. ಅದ್ರ B report ಆಗಿದ್ದು 28/6/2013. This has not been challenged anywhere.
Now it is challenged under the writ petition that by those the other petitioners, not the aggrieved party.
So this petition challenges all the 3 reports.
All 3.
Appear, my lord, petitioners. Last session I have produced
ನಿಮ್ದಲ್ಲ ಸರ್.
sorry, sir.
Yes. In all the complaints, it is identical.
Please, all the complaints are identical.
That the signatures are forged.
Their claiming signatures are forged.
What does the investigation reveal?
Investigations charge sheet does not say that these signatures are forged.
Where's the charge sheet?
Page 103. ಅಲ್ಲ ಬಿ ರಿಪೋರ್ಟ್ ಎಲ್ಲಾದ್ರಲ್ಲ ಹಾಕಿದ ಮೇಲೆ
ಚಾರ್ಜ್ ಶೀಟ್ ಏನ್ ಬರೆದಿದೆ?
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ ಹೇಳ್ತಾರೆ. Page 103 ನಲ್ಲಿ
ಇಲ್ಲ, what is a charge sheet?
Page 31, column 7.
page 31.
31.
ಮಾಡಿದಾರೆ ಅಂತ ಬರ್ತಾನೆ. ಅಲ್ಲ ಇದೆಯಾ ಈ ಒಪಿನಿಯನ್ ಎಲ್ಲ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿರ್ತೀನಿ.
What is the material to show that there is forgery?
Forensic report. Page 103.
Produced by means of imitation for certified. These are in Xerox copies.
Materials examined. Page 103 ನಲ್ಲಿ. All the Xerox copies have
There is a forensic report saying that it is a forgery.
Hello, Your Lordship, can you see these, what the documents are examined, material examined. Xerox copies, how can they identify the signatures? Materials examined, one, the forum number fee, the Indian Partnership Act so and so, in respect of registration number so and so, dated 1/10/19, in which the Xerox copies of signatures in the enclosed portion are marked, 2D1 so and so.
The second one original,
ಇಲ್ಲ ಯಾವುದು ಒರಿಜಿನಲ್ ಇಲ್ಲ.
serial number 2.
2, dissolution of the firm in respect of registration number so and so, dated 13/6/1991, it with the signature and enclosed portion.
ಮಿಕ್ಕಿದೆಲ್ಲ original ಇದ್ದಂಗಿದೆ ಅಲ್ವಾ, except the first one. The other
ಅಲ್ಲ
form
ಒರಿಜಿನಲ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
ಅಲ್ಲಿ ಬರ್ದಿದಾರಲ್ಲ, materials examined, first one ಬಿಡಿ photocopied ಅಂತ ಅಂತಾರೆ, second one. One form number 5, notice of change in respect of registration number 188 of 73.
The second one,
dated 13/6/1991, in which signature is enclosed portion marked as so. Administration is enclosed portion. ಒಂದು ಇದೆಯಲ್ಲ, original ಇದೆಯಲ್ಲ.
original. Hello,
There is material as against the form number 5.
how can they examine, they find out the signatures on the Xerox copy, all the Xerox.
Not a Xerox copy, serial number 2 and 3 are originals.
Serial number 2 is also, it is with me also. It is with me, now itself it is with me. They have not collected the document, original is with me only.
One notice you also give to the firm, that is also an original.
All originals are with the.
The notice that you give of a change in the constitution of the firm is submitted to the register of firms. It is always available there.
Original is not available.
Not with you, it's always with them. You give notice of the change. It is with the register of firms.
Even they are
with you. You may keep a copy.
Photocopies na collect ಮಾಡ್ಕೊಂಡು examine ಮಾಡಿ opinion ತಗೊಂಡಿದ್ದಾರೆ. ಯಾವುದು original produce ಮಾಡಿ.
2 and 3 original.
ಅದು ಕೂಡ ಅಷ್ಟೇ.
All these documents collected by the registrar, only Xerox copies, not originals.
The forensic report does not indicate that. ನೀವು ಹೇಳೋದಕ್ಕೆ on what basis are you saying that?
ಅಲ್ಲ, for that your, even the suit has been filed. So Lordship can see wherein issue number 3.
ಯಾರು ಸೂಟ್ ಹಾಕಿದ್ರು?
ಅವರೇ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಕರಿಬಸಪ್ಪ, this the complaint we lodged in suit in voice number 27 of 2015.
For what?
For dissolution of partnership firm.
Resolution
of partnership firm. Wherein your Lordship can see issue number 3.
Resolution accounts,
ಹೌದು.
Hey, Karibasappa.
Karibasappa, Mallikarjuna, and Elas of Mallikarjuna.
In this suit also, they've taken up the contention that there is no reconstitution and that's a forged document.
Yes. Even your lordship can see, the issue number 3 is whether the defendant number 2 proves that a retirement and reconstituting deed was entered into between the partners as per deed dated 110.
What has happened to this suit?
Suit dismissed. Issue number 3,
Suit is dismissed.
please, ma'am.
Yavaga?
Issue number 3,
How dismissed date?
dismissed on 25th March 2023.
March,
23, ma'am.
appeal?
Really?
RE is pending, RE 19 of 2023.
Only after dismissal of
RE 19 of 23.
What is the finding on issue number 3?
issue number 3, your lordship will see issue number 3, whether the defendant number 2,
What is the finding?
finding is of affirmative. Whether the defendant number 2 proves that a retirement and reconstitution deed was entered into between the partners as per deed dated 1/10/1999 as pleaded in the written statement, it is given in the affirmative.
The trial court is going to finding that they did sign the
Yes.
reconstitution deed.
Then your lordship again see, after dismissal of the suit only this complaint is filed by Karibasappa. Writ petition, sorry, ma'am, writ petition is filed.
After the suit was filed, he filed the complaint.
Yes,
Suit is
15, how
2015.
15,
Thereafter, you file a complaint.
complaint.
In that, a charge sheet is filed. But the civil court has given a finding that you did enter into the reconstitution, whereby you retired from the firm.
But what happened is, these documents were not, placed on record. Now we filed application.
What should happen to the finding of the trial court?
Appellate court, we have filed applications, not producing the document to show that it's a forgery, and you have pleaded.
No, if you had filed
An
the,
application.
if you had filed the complaint after the suit has been filed, then what is the, you can understand you doing it simultaneously. This particular reconstitution of the year 92-99. There are 3 complaints filed.
Yes.
Yours is the last of the complaint, and that too it is filed 1 year after the suit is filed. And in the civil court, you allowed a decree to be passed holding that that you have in fact executed the partnership deed. Then what is the point in this criminal proceeding?
We have filed application in the appellate court, producing the additional documents and also
Pursue remedy there. Why should the criminal proceedings go on?
this is where the prima facie, the materials are there, now it is a matter for trial.
You took a chance by coming to the criminal court after you filed the suit.
The others also here, the other complaint.
Well, let's say other side deal.
Only 1 minute.
Other side deal, you cannot come to the court as and when you choose. The reports were filed when.
The reports are filed, in a different context. So in one case, they say it is in the nature of civil case. And before the notices were served, it was closed. And in one
Either way,
they say.
either way, they are also parties in the civil suit, isn't it? The complainants in of 8 to 17, 8, 9, 17, all of them are before the court. They must be defendants.
The only thing is this, the kindly see why the B reports are filed. One is stating that this petition,
I will say the question of this is left open to be adjudicated in the appeal that is pending.
Then your lordship again see the page 178, my lord.
How it has been transferred and date of event. Lordship may have it,
Your lordship again see
You
the,
have gone, your lordship may pass.
You have gone to the civil court, the same pleading. Suffered a finding against yourself.
We will place it on record.
For what? You tell me, how can you get over that finding now?
We have challenged it. The appeal is
Alright.
pending. It is a continuation of the proceeding.
In the appeal, if it's allowed, lend you to your benefit, why should the criminal prosecution go on?
There is a prima facie material, it is parallelly, possible to, continue.
So I'll be disrespecting the order of the civil court. If I were to accept your contention.
There is an appeal pending. Appeal is under adjudication.
That's why I said I leave that question open to decide by the appellate court.
I request this,
Your lordship-
on record, your lordship will take this. Monday kindly have it.
your lordship kindly page 178, my lord.
In the next petition, all other victims are before lordship seeking further investigation. And the B reports are filed,
If I were to hold in the charge sheet that is filed, that it is bad because of this decree, B reports that are filed have become inconsequential.
My lord, we will, my lord, place the application file also, my lord, the decree also, my lord.
I will be giving you that liberty. That question decided by the appellate court.
I will place it on record, then your lordship will be.
Your lordship, may kindly see.
I will place, my lord, even chart also, my lord, the date of event. No,
Yeah, what is wrong in whatever he has given? I think I have all the dates now. There's no difficulty in the dates.
But the order of, my lord, the B reports, my lord, wherever the order is accepted.
If the charge sheet goes, if the charge sheet is based on Xerox copies and the FSL report is of the year 2019.
But so far as other victims' rights are concerned, my lord, they are also similarly ignored, but they have not filed this suit. But they are before the.
If they had filed a complaint in 2013-17 and kept quiet for years on end.
But B report notice was not served. That is my.
It is served,
Therefore, my lord, we filed a writ petition.
You should have taken some steps having filed a
The steps, my lord, exactly we have taken by way of. a writ.
PCR ಹಾಕ್ಬಿಟ್ಟು ನೀವು 5 ವರ್ಷ ಸುಮ್ಮನೆ ಏನು ಮಾಡಿದ್ರೆ ಇದ್ರೆ.
That was referred for investigation. It was pending, my lord. During that, my lord, one of the complainant passed away. That has been recorded by the judge, my lord. Kindly see the. Your lordship may kindly see the next year A1. Kindly see, my lord. How this next year A2, my lord.
ಬಿಡಿ ಶ್ಯಾಮ್ ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೋತಾದ್ಮೇಲೆ
Final writ petition.
ಸಿವಿಲ್ ಕೋರ್ಟ್ ಸೋತಾದ್ಮೇಲೆ ಬಿಡಿ ಸಾಕು.
Only one second, your lordship, may kindly see.
My lord, cast prejudice in the civil suit also.
I will, that's why I said I will keep that open.
May not, my lord.
Notwithstanding the disposal of these proceedings,
Your lordship
which
may
are
kindly
only
see,
regarding
my
the criminality of the
lord.
case.
Page 53 of my writ petition. Kindly see. Page 53. My lord, despite of the service of the notice, complainant none appears before the court. It is reported that the complainant has died. My lord, how can he appear? My lord, a person died.
So what should the
And
magistrate
his death
do?
certificate is filed.
No,
No
what
steps taken.
If the complainant is
No,
dead,
no steps taken by the.
if the complainant is dead, what is the magistrate expected to do in under the CRPC?
My lord. Complainant has died.
So therefore,
That is during
it
the
must
time
end in
that
an
the B
acquittal.
report was filed.
It must end in an acquittal.
What happened is, the B report was filed. At that moment, complainant has passed away. But therefore.
The effect of the death
He
of-
could not file the petition.
The effect of the death of the,
Thereafter, my lord, the family members are before lord.
the effect of the death of a complainant is what? Acquittal. There's no question of LRs coming and challenging it.
Abated, my lord. Cannot be acquitted. It is only abated.
256 not,
My lord, it is abated.
256 not acquittal ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
Your lordship, may kindly, one moment, my lord.
But my lord,
Page
my lord, the
178, your
LRs
lordship.
Because their interest, their stakes are there.
You
It's
do
a
not-
partnership firm. The proceeds of the partnership has to be, my lord, benefited to the
Not
heirs.
256. ಇದೆಯಾ? Clause 2. So even if as a reason of his death, he does not appear, the effect is that of acquittal under 256(1).
That says, my lord, the provisions of subsection 1 shall, so far as may be, apply also to the case where non-appearance of the complaint is due to death. Not the notice.
So if the complainant is dead,
Yes, sir. Now the LRs are before your lordship, my lord, because there was no notice to them. And without their notice, this has been passed.
civil court ಮಾಡಿ ಶ್ಯಾಮ್ ಸುಮ್ಮನೆ ಯಾಕಿಲ್ಲ.
My lord,
For that, your lordship, may kindly see the page 178, my lord.
Lord, if anything, my lord, adverse order is passed, and if the proceedings are started, that will affect my civil right also.
I will make it clear,
No,
I will make it clear that the execution of these two deeds of reconstitution shall be investigated or considered independently of the criminal proceedings by the appellate court, if it so desires. If you have not laid any evidence in the trial court regarding this forgery, in the appellate court, you can't create fresh evidence.
we have filed, my lord, the documents and my lord also sought for evidence.
ಅದು order 4127.
The proceedings first appeal.
Order 4127 ಬೇರೆ. If in the suit, you have not adduced any evidence to indicate or to substantiate your contention that you have not executed those two reconstitution deeds, there is a consequence to it. Having failed that, you cannot come to the criminal court and try to establish that in the criminal court. You should have chosen one of them or at least simultaneously and then ask the civil court to await the decision of this particular criminal court.
In the meantime, your lordship may kindly say,
There are so many victims. We will
What difference does it make? I'm not deciding anything.
Your lordship may give some time, Monday, your lordship.
page 178, the Karibasappa was filed a complaint before the police. He himself has made a statement before the police stating that he received the money and retired. Page 178.
Cannot be. It is not evidence in the court or.
178.
ಇದು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿರೋದಲ್ಲ
ಹೌದು.
ಬಿ ರಿಪೋರ್ಟ್ ದಟ್ ಇಸ್ ಫೈಲ್ಡ್.
ಅದರಲ್ಲಿ fourth para, third para.
Monday.
ತಂದಿದ್ದೆ ನೋಡಿ.
For further consideration, bill number 20, H.N. Basavaraja. Pastor Millard,
Please, please.
Bill number 21, Shri Ranganath Joyce.
The state in the matter.
What happened?
Only I need to argue, I think. My learned senior friend, Jagdish sir has already.
Jaydeva.
Yes, Manoj, Jaydeva. There's only three issues, Manoj, with regarding to the regularization. We have come out with or a suggestion rather to the Jaydeva Institute to see if we can they can impress upon my lords to increase the pay so that it comes more or less in par with the regular staff. But the court, honorable court was pleased to ask the question whether what happens to their services put in for all these years. And subsequent to their superannuation, what are the benefits they are going to? Ultimately, my lords, it is the Jaydeva which has to answer. The financial burden, my lords, is more on the Jaydeva because it is there.
Jaydeva is saying if you were to approve.
That's the reason I wanted to clarify that to my lords. Ultimately, my lords, it's an autonomous institution which is run by them. Walk-in interviews were called by them.
Chairman of the governing council happens with the CM.
Yes, my
And
lords.
you're not washing of your hands saying that it
No,
is.
my lords, I'm not washing my hands at all. All I'm saying is they have come out, my lords, may kindly come to a memo which they have filed.
They are at best saying that they are going to offer some amount, which according to them may be in parameter. They are not very sure. I asked them as to what is the salary that regular nurses get.
Today they're been served with a copy.
What is the difference?
Madam, memo have given the judgment of the Supreme Court, my lord, equal pay for equal work, and 5 orders of persons similarly situated who have been regularized. I have produced already 1 order. 5 more orders I have produced saying that similarly.
I had asked Mr. Jagdish to furnish the
Ashte, admitted.
PC meeting dated 14/11/2005 and the salary that regular
Yes,
nurse
my lords.
gets.
Today they are producing one memo.
ಎಷ್ಟು ಬರ್ ಸಂಬಳ
90,000 70,000 ಚಿಲ್ಲರೆ ಇದೆ.
ಇವರಿಗೆ 46,000 ಕೊಡ್ತಿದ್ರು.
46,000. 40% is the deficit.
And in the counter that you had filed earlier, you said that both of them discharge the same work.
Please, my lords, there's no dispute on that.
How can you give them 46,000? When you're extending the same work.
My lords, in the last occasion, my lords, there was an affidavit filed by the erstwhile director, my lords, which indicates that they are now coming with a module which says that they are, may I just read this, my lords?
No, this is an half measure just to continue the same practice.
Lords, we are not resorting to that under any circumstances.
For 23 years, if you keep them in contract.
Means that's a prima facie mistake, my lords. The unfortunate issue is even today around 800 people are there who are working only on the contract basis.
Therefore, I'll pass an order regularizing them.
My lords, my only thing is, my lords, it is their own submission before my lords to say that it is their own, internal resources is what they are generating the
It
funds.
is for the purpose of increasing their pay.
Yes, my lords, of course.
What is the prayer regarding regularization?
No, my lords.
And they have produced these OMs
Please, my lords.
in which on 14/11/2005, the governing council had decided to regularize similarly situated separate.
3 years to 5 years in a criteria, they have already done in
23 ವರ್ಷ ಕೆಲಸ ಮಾಡಿ
2020.
regularize ಮಾಡಲ್ಲ 3 ವರ್ಷ ಮಾಡಿದ್ರೆ ಏನ್ ಅರ್ಥ ಹಂಗಾರೆ?
Please, my lords, they are losing out in the other way. 20 ವರ್ಷ ಕೆಲಸ ಮಾಡಿರೋರು, even though they are seniors, people would have only put in for in their wisdom. I don't know what happened, why they wanted to regularize only a certain number of people.
Yeah, it's obvious why.
I don't want to say that, Manoj, but otherwise, the bigger thing what we were able to not digest is the fact that while doing the walk-in interview, none of the other criteria or parameters have been met in.
The walk-in interview was notified.
Yes, Manoj, it was.
Only the eligible nurses were recruited.
Please.
There was no attempt to get them through the back door. Then how can you say that the recruitment is irregular? And even according to your governments in the petition, they are sanctioned stipendary
Of course,
nurses. You have sanctioned those posts.
Please.
They work for 23 years.
What would happen is they would ask for us to say that we are taking in so and so for whatever exigencies we have.
Consistently for 23 years, you have.
They have been doing it, Manoj. I must admit that they have been doing it, Manoj. Initially, as the annexure R1, which I produced along with the statement.
You will come out with something saying that.
I'm trying my level best. Manoj, what would happen is whenever.
I was hoping that you would say, don't give them any retrospective financial benefits. We'll regularize
even I would make that statement today, Manoj. The finance secretary is yet to come and meet my advocate general, Manoj. We will make one last ditching effort. It may be had 2-3 days later. By Monday or Tuesday, I'll come out with some response. Some response in the sense to say that.
You regularize their services. Financial benefits, I will
not give them the, not consider the thing of retrospective thing, please.
Something like that, we'll work out.
Please, by Tuesday, Wednesday, my lords may have. I will
Or
also.
else if you don't agree.
We are losing out on the entire hand totally, my lords. I do understand that they are also have to be protected.
At least after the completion of 10 years.
Please, my lords.
From that day, at least you regularize them for the ultimate pension and all that. In the meantime, we'll.
Yes, my lords. My lords may have it on Wednesday, my lords. By then I will get back.
Wednesday. In Karnataka, you were regularized.
Recently, you were lordship as an expressive view in a same set of facts. What I noticed is a recent regulation of the lordship. And I hope the government.
See, this resolution, the GC after detailed discussion decided to regularize the services of those stipend nurses who have put in totally 5 years and above satisfactory service at SJSC as decided by the finance committee. So if 5 years is the benchmark.
20 years they've already.
Yes, Mayor.
I understand. Not to call it on Wednesday.
I'll make it 10 years. From 5 years,
I'll put
grant
it
them some benefit.
I'll put it.
Wednesday.
Public.
You will be forced me to pass an order which may have a ripple effect in other cases.
I'll make my effort to ensure that there is some.
I'm putting you on
response
notice.
that the government gives.
Any order that I pass here. will have a binding effect on several other.
I know, we have 11 other institutions.
Number 22, Srimati Anusha N.
From who will serve another court. There has been progress. The petitioner has been reinstated at least with regard to Mr. Ram Gopal. He's been reinstated and has reported for duty. Now the process of payment is still ongoing. My lord gives us another week. I think we should be able to make the money. Yeah, many weeks have gone by. Yes, my lord, I accept wholeheartedly. But if another week is given, finally we'll process the payment.
You can ask that secretary to be here.
Maybe by the
to hasten the process.
I mean, maybe not for the next date, my lord. If it's not done by the next date, then thereafter, perhaps, my lord. But at least give us 1 week. We'll process the payment.
Lord, in my petition, Lord, 9058. Last time I made a mention. I would be reaching the age of superannuation of 62 years. The Maharani 62 years. The Maharani's cluster. The eating more but page.
ಸಂಬಳ ಬರ್ತಾ ಇದೆ ಅಲ್ವಾ?
ಸಂಬಳ ಬರ್ತಾ ಇದೆ. Now, my lord, now as per the amendment, my lord, which has been brought to the act, cluster university age of superannuation is as per the UGC guidelines. It is 65.
Now the prayer in this petition is rather limited. I have to expand this more now.
No, this is the main prayer itself is, my lord.
No, next week I'll decide. Next week.
28.
Attending for respondent number 3, madam.
All right, next week.
28.
Interim Missionarity case and.
May request, my lord, at least on 28th, the matter may be considered for interim order.
Told him. 28th, I'll take it up one way or the other.
At page 46, the age of
Ask them
superannuation.
to be ready on this issue also. That they want to continue till they attain the age of 65.
Section 40T.
Whether that apply or not, ask him to be ready on that.
Okay, on the 28th, yes.
Lord, in Krishna Reddy case, my lord, we prepared the synopsis and we will file it in the counter. Great. Great.
I am appearing for the respondent number 3.
28 Gajan.
Yes,
For
madam.
hearing D group, C number 23. Dinesh Krishna.
For the petitioner, madam.
C number 24. The Venkateshulu.
See number 24, my lord.
24, madam.
My lord, appellant 2 and 3 are dead, my lord, to bring the LRs on record. Both of them are. Appellant number 2 and 3 are dead.
Petitioners, huh?
Sorry, petitioners. Petitioners.
When did they die?
My lord, last week I'm told, my lord, I got the phone call that both of them are dead. I'll bring the, your also give me 2 weeks time, I'll produce the death certificate and also file the application.
Senior counsel submits that the petitioners, both the petitioners are no more. And she seeks for a week's time to take steps. Relist on.
28. C number 25.
For appellants and a week's time may be granted. Get prepared.
2015, it's, I've adjourned the matter on the last occasion.
Yes,
also.
madam.
Then,
Just 2 days, madam. Monday or Tuesday, madam. I'll just,
for how long can I keep adjourning this?
there is some, and Tahsildar records also should be called.
If I
for.
don't put pressure on you, you will not go on.
No, my lord. I'm half-handed. I'm ready.
We are concerned, madam, we are ready because your lordship.
ಅವ್ರನ್ನ ಕೇಳ್ತೀನಿ ಬಿಡಿ ಹಂಗಾರೆ ಬೇರೆ ಅವ್ರ ಪಿಟಿಷನ್ ತಾನೆ
ಅಲ್ಲ ಎರಡಿದೆ ಒಂದು ನಂದಿದೆ ಎರಡು ಅವ್ರದಿದೆ
ಮತ್ತೆ ಅವ್ರು ಇಬ್ರು ಇದಾರಲ್ಲ ಮೆಜಾರಿಟಿ ಬರ್ತಾರಲ್ಲ ಅವರೇ I will hear them. Suppose he succeeds, you also succeed. Is it?
Grateful. Allah. They are my opponents, my lord.
Rival claimants, of course, my lord, their claim is based on the will. That has been negative.
ನೀವಿಬ್ರು rival claimants ತಾನೆ.
ಹೌದು ಮೂರು ಇದೀವಿ ಬಟ್ ಇವ್ರದ್ದು they are claiming on the basis of the will. They have filed a suit and they have lost up to this court.
When? What is the order that you are challenging?
First petition is.
Next year, Gene, huh? Nimdi other petition?
My petition is 32257.
32257. 25.2. 25.1 alone, you? Sir? 25.1 ತಾನೆ ನಿಮ್ದು?
First 14256.
ಯಾರು ಫಸ್ಟ್ ಮಾಡ್ತೀರಾ ಆರ್ಗ್ಯುಮೆಂಟ್? ನೀವೇ ಮಾಡ್ತೀರಾ? Next year, G is the order.
G and
Page. Page.
55.
ಇಲ್ಲ district judge order ಇದೆ. Next F is the order of the Tahsildar. In appeal, it is confirmed or reversed?
It's confirmed.
Let's read the order of the appellate court. ನೀವು ಯಾರು ಚಿಕ್ಕಮುನಿಯಪ್ಪನ ಒಕ್ರಂಬಿ
ಅವ್ರ MA 19 of 2008.
MA 19 ತಾನೆ ಅವರು?
ಅವ್ರ MA 19.
ನೀವು?
ನಾವು MA 22.
ನಿಮ್ WP ನಂಬರ್ ಎಷ್ಟು? ನಿಮ್ WP ನಂಬರ್? ನಿಮ್ WP
14911 of 2015 ನಮ್ದು.
14911. ನಿಮ್ದು?
32257.
MA 17. ನಿಮ್ದು ಯಾವ್ದು? MA
17.
17. 2008.
ಚಿಕ್ಕಮುನಿಯಪ್ಪ.
Yes.
What is the land bearing survey number?
There are 4 survey numbers.
278.
298.
298. 319, 320.
All three of you made the application for re-grant.
Yes.
That is Chikmuniappa.
ಚಾಲೆಂಜ್ ಮಾಡಿ
ಇಲ್ಲ, re-grant ಯಾರ application ಹಾಕೋದು?
Re-grant Millards,
ಹೆಸರು ಹೇಳಿ. ಕುಟುಂಬಿ ಆಮೇಲೆ ಇಬ್ರು ಹಾಕಿದ್ರ?
that is Nirganti Narsimaya Sellars.
ಗಂಗಮ್ಮ. ಇವರು ಎಲ್ಲಾರ್ಸ್ ಆಫ್ ನೀರ್ಗಂಟಿ ನರಸಿಂಹಯ್ಯ.
Yes, ma'am. Yes.
ಚಿಕ್ಕಮುನಿಯಪ್ಪ, ಆವುಕೊಂಡಪ್ಪ, ಅದೆಲ್ಲ ಸಾಫ್
ಚಿಕ್ಕಮುನಿಯಪ್ಪ,
ಆವುಕೊಂಡಪ್ಪ
and others. They are the LRs of
Munshamappa.
So the village office holders were Munshamappa, Narsimaya
and
Pakrumbi Naik.
ancestors of
Illa.
this petitioner.
Yaar ancestors same. Huh?
Proceedings of and P. Grants.
Pakrudin sab
Proceedings of P. Grants.
and Budan sab.
P. Grants. The husband of the first petitioner and father of the second.
You purchaser ಇಲ್ಲ?
We are the authorized owner of the village office.
Now what did the Tahsildar do?
Tahsildar has re-granted equally
All three.
among the petitioners.
To three applications.
No, not three.
Not three.
Only in favor of these petitioners in 14911 and
ಹೇಳ್ಬಿಟ್ರೆ ಅನುಕೂಲ ನಮ್ಗೆ.
Satunji and
26th March ಅಲ್ವರ್ದು?
house.
26. March 2000.
The regrants to LRs of this Fakrudin sab. Sab?
That is Pakrumbi and Kaspi, the petitioners here.
Fakrudin sab application in year ಆಮೇಲೆ ನೀರು ಕೊಟ್ರು?
ಅವರು Pakrumbiಗೆ ಮತ್ತೆ Kaspi.
ಇಲ್ಲ, ಅದು ಒಂದು ಎಲ್ಲ ಪೂರ್ತಿ ಅವ್ರಿಗೆ ಕೊಟ್ರ?
ಇಲ್ಲ ಇಲ್ಲ, ನಮಗೂ ಅವ್ರಿಗೆ.
ನಿಮ್ಗೆ ಅಂದ್ರೆ LRs of
LRs of ನೀರ್ಗಂಟಿ ನರಸಿಂಹಯ್ಯ. ನರಸಿಂಹಯ್ಯ.
equally.
Equal of half share.
You are not satisfied. You wanted the entire land.
Yes, ma'am. Both of us
wanted the entire.
yes.
And why was his application rejected?
Because he was claiming on the basis of the registered will. Will, my lords,
ಯಾರು ಬರ್ಕೊಟ್ಟಿದ್ದು?
that is by Narsamma. Wife of Marianna. Marianna in favor of Munshamappa.
Executed by
Narsamma.
ಅವ್ರಿಗೇನ್ ಸಂಬಂಧ ಇದಕ್ಕೆ?
Alla, she is also, my lords, originally the office was belonged to one Kadriga alias Kadirappa.
ಯಾರಿಗೆ?
Kadriga, he was the, my lords, Nirganga. Kadriga.
Spelling ಹೇಳಿ?
Kadriga alias Kadirappa ಅನ್ನೋರು, he had, my lords, 3 sons. ಅಲ್ಲ,
First
3,
son.
2 sons and 1 daughter. Narsappa, Marianna and Ramakka.
ನರಸಪ್ಪ,
Marianna and Ramakka.
ರಾಮಣ್ಣನ.
Raman. Narsappa, Marianna and Ramakka.
ಎಣ್ಣೆ and ರಾಮಕ್ಕ.
Yes, ma'am. My lords, we are
ನರಸಿಂಹಯ್ಯ ಇವ್ರೇನು?
Narasimha Ramak, my lords, Ramakka's husband is Narasimhaya.
3 ಜನ ಗಂಡು ಮಕ್ಕಳು.
ಅಲ್ಲ, 3 ಜನ ಅಲ್ಲ, ಇಬ್ರೆ.
ಕದಿರಪ್ಪನ್
ನರಸಪ್ಪ, ಮರಿಯಣ್ಣ, ರಾಮಕ್ಕ.
ಮರಿಯಣ್ಣ.
ಮರಿಯಣ್ಣ, ರಾಮಕ್ಕ.
ಈ
ನರಸಿಂಹಯ್ಯನವ್ರು ರಾಮಕ್ಕನ ಹಸ್ಬೆಂಡ್. ಸಾರಿ, ಸನ್.
ಇವರು ಫಕ್ರುದ್ದೀನ್ ಅವರು independent. He's
they are claiming, he is claiming that he was appointed as Gumasta of that.
Mariannan ಮಕ್ಕಳು ಯಾರಿಲ್ವಾ?
Mariannan ಮಕ್ಕಳು he died issueless, my lord. But ಇವರು ನರಸಮ್ಮ ಹೆಂಡತಿ, ಮರಿಯಣ್ಣನ ಹೆಂಡತಿ ನರಸಮ್ಮ.
ಮರಿಯಪ್ಪ.
ಮರಿಯಣ್ಣ.
So ಈ ಅಮ್ಮ ವಿಲ್ ಬರ್ಕೊಟ್ಲು.
ಹಾ, ನರಸಮ್ಮ ನರಸಮ್ಮ ವಿಲ್ ಮಾಡ್ಕೊಟ್ರು ಅಂತ ಅವ್ರು ಹೇಳೋದು. ನರಸಮ್ಮ ಇನ್ ಫೇವರ್ ಆಫ್ ಮುನ್ಶಾಮಪ್ಪ. ಮರಿಯಣ್ಣನ
ಹೆಂಡತಿ ನರಸಮ್ಮ.
ಹೌದು.
ಈ ನರಸಪ್ಪ ಇದ್ನಲ್ಲ ಮೊದ್ಲೇ ಮಗ.
ಹಾ,
ಅವನು ಏನದ?
ಅಲ್ಲ, ಅವರು ಮೆಲಾಡ್ಸ್ ದೇವ್ ಡೈಡ್ ಇನ್ ಟೆಸ್ಟೇಟ್ ಅಂಡ್ ದೇ ಡಿಡ್ ನಾಟ್ ಕ್ಲೈಮ್ ಎನಿಥಿಂಗ್. ಆದಮ್ಮ ಅವ್ರದ್ದು ಬ್ರಾಂಚ್ ಇಲ್ಲ ಇದರಲ್ಲಿ.
So the fight is between two branches.
Yes, ma'am.
That is one of Narsamma's, that is Marianna's branch and Ramaka's branch.
What?
And he's independent claiming that he is also an authorized office holder.
He says that he has been appointed as Gumasta way back sometime in the year 62, he says. But they are claiming on the basis of the will executed by Narasamma in their favor.
Tahsildar did not accept the will.
My lords, that was initially an order was passed granting the lands in their favor. That was the subject matter of the writ petition before this honorable court. This honorable court held this unless and until they prove the will, they cannot claim the property. But my lords, they have filed the suit. They have lost the matter up to this honorable court, RSA.
So they had filed a suit on the basis of the will. OS number ಏನು?
OS number 74 of 2000.
By Narasamma alva?
By Munshamappa's branch. That is Sikmuniappa and others.
OS 74 of 2000 dismissed.
RA 30/2013. RA 30/2013.
Dismissed.
That was also dismissed.
RSA?
And RSA 2399 of 2017. 399
of
2017, my lord.
This number.
It was dismissed on 7/9/2023.
One more, which was the original order passed in writ petition saying that subject to them proving the will?
Yes, my lord. That was WP 40123/2004. WP 40123/2004, my lord.
Annexure C.
That was on 9/12/2004.
So according to you, because of this order and because of dismissal, their claim goes.
Their claim, my lord, up to this court.
That is
Chikmuniappa and others, my lord.
That is Narasamma's branch goes.
They are claiming on the Narasamma branch. They are claiming on the basis of the will.
Correct. The Narasamma's branch is like Narasamma's claim is gone because the will is not proved.
Yes.
So then if Narasamma's branch is not there, that will come to you.
Yes.
So 2/3 sir ನಿಮಗೆ ಬರಬೇಕು.
ಅಲ್ಲ ನಮ್ಗ
ಪೂರ್ತಿ ಬರ್ಬೇಕು ನಿಮ್ಗೆ.
ಅಲ್ಲ ನಮ್ ಪೂರ್ತಿ ಬರ್ಬೇಕು ಅಂತ my lords, our contention is that yes, definitely dispute is between
ನಿಮ್ದೇನಿಲ್ಲ ಕೇಸ್.
That is the reason, my lords, 2 days accommodation for the only reason is if anything is left out, I understand. I don't have a proper footing here. Lead. By taking some instructions.
ಮನೆಯವರಿಗೆ ಬರುತ್ತಲ್ಲ ಬಿಡಿ, ಯಾಕೆ ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ತೀವಿ? ನಿಮ್ದೇನ್, ವಾಟ್ ಇಸ್ ಯುವರ್ ಬೇಸಿಸ್?
ಅವ್ರು ಬೇರೆ.
Correct. They are essentially claiming Narasamma's right to the will. So will but Narasamman ಭಾಗ ತಾನೇ ಕೇಳ್ತಿರೋದು ಅವರು.
ಅಲ್ಲ ಪೂರ್ತಿ
ನರಸಮ್ಮನ್ ಭಾಗ ಅವಳು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಟ್ಲು.
ಇಲ್ಲ, ಎಂಟೈರ್
either way, if Narasamma's share is determined by virtue of this suit, because will is not proved, ಹೋಯ್ತಲ್ಲ.
ಹೋಯ್ತು. ನರಸಮ್ಮಸ್
ನಿಮ್ದು ಹೇಳಿ.
There are so many proceedings was held and the matter was remanded back.
You're seeking for regrant. What is there to show that you're eligible for regrant?
No, the traditional ancestor, by then Piru Sabi was doing legal thing. Piru Sabi.
You said Fakhruddin Sawal, na?
Piru Sabi.
Piru Saw.
He was working as a legal key of Sagara Kere.
ನೀರ್ಗಂಟಿನ ಇವ್ರು ನೀರ್ಗಂಟೆ ಆಗತ್ತಾ?
My appointment was confirmed by the competent authority. Based on the statement given by the Narsamma, the original Taraga. In fact, in all the records, my name was shown as authorized order of the legislature.
You have the copy of the order of the competent authority appointing you?
In the order, into the order itself, Melody is very clear.
ಇಲ್ಲ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರ ನೀವು? ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕು ತಾನೆ ಆರ್ಡರ್.
Next year,
Next year?
into the order by extract. Portion.
Next year F.
Next year,
ಆ ಪೇಜ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಆಗಿದೆ.
portion is of page 63. 360.
ಎಲ್ಲಿ?
Page 63. ಇದುವರೆಗೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಉಲ್ಲೇಖಿಸಿದ ಕಾನೂನು ಮತ್ತು ನಿಯಮಗಳನ್ನು ಗೌರವಪೂರ್ವಕವಾಗಿ ಗಮನದಲ್ಲಿಟ್ಟುಕೊಂಡು ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಶ್ರೀಮತಿ ನರಸಮ್ಮನವರು ನೀರಗಟ್ಟಿ ನೌಕರಿ ವಾರಸುದಾರರು ಮತ್ತು ಹಕ್ಕುದಾರರು ಎಂಬುದರಲ್ಲಿ ಯಾವುದೇ ಅನುವಾದ ಇರುವುದಿಲ್ಲ. ಆಕೆಗೆ ಮಕ್ಕಳು ಇರುವುದಿಲ್ಲ. ಆಕೆಯು ಸದರಿ ನೀರಗಟ್ಟಿ ನೌಕರಿ ಮಾಡಿಕೊಂಡಿರಲು ಶ್ರೀ ಪಿರು ಸಾಬು ನೇಮಕ ಮಾಡಿದ್ದು ಅದು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಿಂದಲೂ ಅನುಮೋದನೆಯಾಗಿದ್ದು ಆತನೇ ಕೋಟಿ ನೌಕರಿಯನ್ನು ಮುಂದುವರಿಸುತ್ತಿದ್ದರು ಎನ್ನುವುದು ಸಹ ಸ್ಪಷ್ಟ. ಶ್ರೀಮತಿ ನರಸಮ್ಮನವರ ಒಪ್ಪಿಗೆ ಆಧಾರದ ಮೇಲೆ ಸದರಿ ನೇಮಕಾತಿ ಮತ್ತು ಪ್ರಸ್ತುತ ಜಮೀನುಗಳ ಸ್ವಾಧೀನಾಂಶವು ಶ್ರೀ ಪಿರು ಸಾಬು.
What is the basis for this? ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತಿದಾರೆ ಅವರು? That she agreed or she appointed you. ಆಗತ್ತ ಹಂಗೆ? Will you become a authorized order of the village office by somebody?
Section 5 clearly states.
ಕೊಡಿ.
Person who is an authorized order as on the appointed date until 1963. He is entitled.
No, but you refer to some order of the competent authority. Is that order available on record or not?
Based on the records only.
ನಿಮ್ಮ ಹತ್ರ ಆರ್ಡರ್ ಕಾಪಿ ಇದೆಯಾ? ಇಲ್ಲ ನಿಮ್ಮ ಹತ್ರ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ವಾ ನೀವು ಹಂಗಾರೆ ಅದನ್ನ? ತೋರಿಸಿ, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ತೋರಿಸಿ ಯಾವ್ದು ನಿಮ್ ಕಾಂಪೆಂಟ್ ಅಥಾರಿಟಿ. ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಅಪೀಲ್ ಬಂದಿರ್ತಲ್ಲ ಅಲ್ಲಿ, ಇನ್ನೇನು ಅಪೀಲ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ನೋಡಿ, ಅದು ನೋಡಿ.
Order of the records of the Tahsildar are not here.
Then what is there to show that you are the authorized holder? How could Narsamma have Read the definition of authorized holder. There must be a basis for that order, isn't it? ಅಲ್ಲ ಸುಮ್ಮನೆ ಸ್ಪಷ್ಟ ಅಂದ್ರೆ ಯಾವ್ದ್ರಿಂದ ಸ್ಪಷ್ಟ ಅಂತ ಹೇಳ್ಬೇಕು ತಾನೆ ಅವ್ರು. By whom? ಇಲ್ಲ ಕೋರ್ಟ್ ಅಡ್ಮಿಟ್ ಅಲ್ಲ, ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ತಾರ.
No, my lords, we don't admit.
ಮತ್ತೆ ಏನ್ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್ ಹೆಂಗಾಗುತ್ತೆ? ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ. ರೀಡ್ ದಿ ಡೆಫಿನಿಷನ್ ಆಫ್ ಆಥರೈಸ್ಡ್ ಹೋಲ್ಡರ್.
ತನ್ನ ಇಷ್ಟದಂತೆ ಶ್ರೀ ಪೀರು ಸಭೆಯನ್ನು 3 ಗಂಟೆ ನೌಕರಿಯನ್ನು ಮಾಡಲು ನೇಮಕ ಮಾಡಿಕೊಳ್ಳುವುದರಿಂದ ಅವನು ಪ್ರಶ್ನಿಸಿದ್ದಾರೆ. ಇದರ ಸಂಬಂಧ ಶ್ರೀಮತಿ ಆದಮ್ಮ ನರಸಮ್ಮನವರು ದಿನಾಂಕ 21/9/1962 ಮನವಿ ಸಲ್ಲಿಸಿ 7 ಗಂಟೆ ಕೆಲಸಕ್ಕೆ ನೇಮಕ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದು ಪ್ರಕರಣ ಸಂಖ್ಯೆ RIB OC 56 9263 ದಿನಾಂಕ 27/5/2063 ತಾತ್ಕಾಲಿಕ ನೇಮಕ ಇದರ ವಿರುದ್ಧ ಮೇಲ್ಮನವಿ ನಂಬರ್ RIB S Miss 20/62/63 ಆದೇಶ ದಿನಾಂಕ 10/1/1964 ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಪುನರ್ ವಿಚಾರಣೆಗೆ ವಾಪಸ್ ಮಾಡಿದ್ದು ಪ್ರಕರಣ ನಂಬರ್ RIB OC 10/56/62/63 ದಿನಾಂಕ 30/1/1968 ಒಕ್ಕೂರು ಸಭೆ ಮತ್ತು ವಿಧಾನ ಸಭೆಯಲ್ಲಿ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಅವರುಗಳಿಗೆ ಪ್ರಸ್ತುತ ಜಮೀನುಗಳನ್ನು.
This is the proceedings of regrant. I need to see documents to show that you are this village office was conveyed in a manner known to law. ನಿಮ್ claim ಏನ್ ಆಧಾರದ ಮೇಲೆ? Raise your application. The fact that you are claiming under ಯಾರು ಬರ್ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಿ ನೀವು?
ನರಸಮ್ಮ.
That is
Mariana's wife.
So the entitlement of this Ramakka cannot be in dispute now. Because you are claiming under Narsamma, who was the wife of Mariana. So the claim of this Narsimaya can't be disputed. Ramakka's husband can't be disputed.
No part of time Lord
By your own admission, your case is Narsamma's husband Mariana was the village office holder. On his death, Narsamma becomes the village office holder entitled for regrant. If you are claiming that the village office was transferred to you from Narsamma, so the fact that Ramakka, the sister, is entitled to a regrant, you can't dispute.
not entitled.
Yenge?
As of the date of appointed date, I am the Nirgati.
What is there to show?
Section 5 is very clear, my lord.
5 is very clear. What is there to show that you are very clearly the Nirganti as on that date?
The record shows that, madam, as of the date.
Please show me from which record.
Let's go, Jimmy, madam. Please number.
Yes.
Pertaining to regrant proceedings, the order of the state committee dated 31/1968 in case number RIBOC 1056/63. Is carrying out the duties of legal office of Mani Vairasandra Harrison. Inside order is.
Even according to your case, Makrusab was the Gumasta of the Nirgantis. You are not the Nirganti.
His appointment was confirmed.
As a clerk of the Nirganti, you don't hold the village office.
They have given up their hereditary right over the village.
How? By this finding,
Given up their right over.
if you rely upon this finding, you are only a clerk in the village office of Nirganti.
My appointment was confirmed.
As a Gumasta,
Yes, madam. Their
if you are a
case is-
Gumasta, you can't be the village office holder. If she had sold that village office to you, under the existing law, and you become the Nirganti, that is another thing. Then you are the holder of the village office. You are an employee of the village office.
My employment was confirmed by the company.
Aito, even if it is confirmed, you continue to be the employee of the village office.
Employee has given up his right.
Hangagala. If I appoint a clerk,
Employer has given up his right.
if I appoint a clerk, will I stop being the boss?
Employer has given up his right. Right over the hereditary office.
Now, by appointing
Even the
a,
authorized order of.
Yenge hele, by appointing a clerk, has he given up his office?
She has not, she has not.
That is the finding of the,
Appoint ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಅವ್ರನ್ನ appoint ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ನೀವು ಇನ್ನೊಂದ್ಸಲ
ಅವ್ರು ಅದು base of the statement.
ಇನ್ನೊಂದ್ಸಲ ಓದಿ page 113 ಇನ್ನೊಂದ್ಸಲ ಓದಿ. That is the ಇದು.
44.
Was the original in the said order, page 112 last line, in the said order.
Entire
It
para
is found
44.
that Narasamma, wife of Narasamma was the,
Was the son of original Nirganti Pedirappa, had appointed this series of the master of Nirganti of Amani Vairasagara.
There is.
In said proceeding, it is found that original land revenue records will be extract goes to show that the appellant Procedural of is Gumasta Nirganti and he is working as Nirganti ever since the date of death of Procedural, his father-in-law. The same found in the statement recorded by the revenue inspector on 15th. In the order it is secured that the evidence on record goes to show that Srimati Adamma has not actually worked as Nirganti, but other branch. Adamma.
Once he says the records indicate that you are a Gumasta appointed by the Nirganti. When did you become the Nirganti?
By the order of the competent authority.
The competent authority, let's assume it's correct, approved your appointment as a clerk. So how will you become the Nirganti?
It is there in the record, so a record bandra, I will produce it. Forestry committee grant 1 week time.
ನೀವು ಓದಿರೋ ಫೈಂಡಿಂಗ್ ನಿಮ್ಗೆ ಅಗೇನ್ಸ್ಟ್ ಆಗಿ ಬರುತ್ತೆ.
Appointment order there.
What?
Based on the statement given by the Narasamma. My appointment was.
Read the definition of authorized holder.
To be.
2B.
What are the village office or.
2B ಓದಿ. 2B. 2B ಓದಿ 2B.
Authorized order means the person in whose favor land granted or continued in respect of or annexed to the village office by the state or a part thereof has been validly alienated permanently, whether by saying if partition or otherwise under the existing law relating to such village office.
So therefore you have to show under the existing law relating to village offices, this office was alienated to you by way of sale, partition or otherwise. The alienation should be in accordance with the existing law, not by appointing you as the Gumasta.
I am holder of definition 2G.
This finding is that you are appointed as the Gumasta, which was confirmed. You can't claim to be a holder now.
When they have given up their hereditary right over the village.
ಅದೇ ಅವಾಗ it should be in the manner stipulated under annex section 2B.
2G ಬರುತ್ತೆ.
2G holder ಆಗೋದು ನೀವು 2.
Holder means a person having an interest in the village office.
2B, you admit that Narasamma was the holder of the office. If she has validly alienated that as defined under section 2B, then you become a holder. If you don't prove the valid alienation.
She has not alienated, but she has given a.
If she has not alienated, if you are not, she is not alienated, you can never be called an authorized holder or a holder.
We will produce the certificate for you. 1 week time will be given. We will show you. 1 week time will be given.
ಅಷ್ಟೇ ತಾನೇ ಹಂಗೆ ನೀವು ಅದೇನು ಇಲ್ಲ ಅಂದ್ರೆ if you have no document, you go. If you go, only he remains.
Even if it is assumed that he will be only a Gumasta, he cannot become an authorized holder.
Even my client is. Petition, Nirganti, Nasimaya also claiming as Gumasta.
No.
Gumasta Nirganti. In the petition itself, they are claiming.
Since you are claiming under Narasamma,
Yes, madam.
and since Ramakka is a sister-in-law of Narasamma,
Yes, madam.
then if Narasamma had no issues, the will goes,
Yes.
this Gumastagiri goes,
Yes.
then what happens? I am the, as the appointed date, my lord, I am the authorized holder. That, my lord, in the means of this honorable court, my lord, withdraw case. It's clearly held that.
A clerk becomes a authorized holder anta.
It's not. Authorized holder is entitled for reason.
Correct, ಅದೇನು section ಹೇಳುತ್ತಲ್ಲ. ನೀವು authorized holder ಅಂತ.
Date of the appointed, I am the authorized holder.
ಅದೇ ಅದಕ್ಕೆ ತೋರಿಸಿ ಅಂತ ತೋರ್ಸ ಮುಗಿದ್ ಮಾತುಕತೆನೇ ಇರ್ತವೆ. Tuesday. ನಾನೆಲ್ಲ ಮರ್ತು ಬಿಡ್ತೀನಿ.
Next week.
Next week at Tuesday. List.
Number 26.
Yes, I do.
I place the facts. I'll just place the facts, my lord. I cannot dispute the fact, my lord, that the tower has been erected and line has been drawn, my lord.
And they are seeking for.
Wants to make some submission, let him make.
My lord, the petitioner, my lord, is the owner of survey number 10 and 12. My lord of.
What is the prayer in the petition?
My lord, the prayer, my lord, in the first prayer, my lord, can become infructuous, my lord, but insofar as prayer number 2, my lord. The first prayer, my lord, at page 16. Lord, what has happened, my lord? It's a second round of litigation.
What is this order annexure K?
Lord, that is the order, my lord, which they had filed a petition saying, my lord, we are obstructing in erecting the tower. Now, my lord, the tower has been erected. There is no dispute on that. My lord, my only submission is, my lord.
Second prayer is only a consequential prayer.
My lord, the second prayer is this, my lord. That, my lord, I'll just place the map also on record, my lord. My lord, it's a second round litigation, my lord. Your lordship may kindly see page 61. In the first round of litigation, my lord. Page 61, my lord, is the order of this honorable court, my lord. Para 4, my lord.
That's been remanded back to the deputy commissioner.
Lord, if my learned friend permits, my lord, I'll just complete. Para 4, my lord. Thus, page 64, my lord. Thus, the respondent is not justified in drawing the high tension power line over the petitioner's land without the permission of the competent authority. The respondent is restrained from drawing high tension power line over the petitioner's land or installation of the tower in the said land without the permission of the competent authority.
So permission is obtained from the competent.
Please, my lord. Now permission is obtained. Liberty was reserved, my lord, at that stage. And my lord, pursuant to, my lord, during pendency of this writ petition, my lord, there are a couple of orders, my lord, I am permitted to show
No, but
that.
then the matter comes to an end, isn't it? The
Sir, my lord.
earlier order protected you only because they did not have the permission.
Please,
of
my
competent
lord, please,
authority. Once that is obtained,
please, my lord.
then
My lord, my only submission is if your lordships could kindly see the order sheet. My lord, we had requested them to, my lord, shift it because, my lord, if your lordship sees the map, my lord, the tower is placed exactly in between, my lord, in the center of the land. Lord, we had in fact told them, my lord, we are ready to bear the expense also.
Submit on that.
And my lord,
Lord, that order was not.
insofar as the compensation also is concerned, my lord, we have not even taken a single rupee from them. We had told, my lord, we will pay the additional value, whatever the shifting charges are there, and our compensation is also
this is
with
an
them.
agricultural land, isn't it?
My lord, this is an agricultural land, my lord, but what we intend to do is, my lord, we want to construct a school over there. And my lord, an entire line in between, my lord, totally, my lord, the land itself will become useless, my lord. We cannot use it for any purpose, my lord. Now, my lord, on the other side, if your lordship sees, there is a main road.
Submit. This was undertaking given in the year 2018 also.
As to what?
That we are going to bear the cost for shifting charges. Court, this honorable court directs them to which land you are going to identify the land and bring the person who is that landowner and file a necessary affidavit.
It is the same land, isn't it? Survey number 12.
Lord, in the same land, my lord, if they want to erect it, not in somebody else's land, my lord, in the same land, in some corner, my lord, so that at least that portion, my lord.
How it is not feasible, you know, the route has been already charged and energized, and it's already been throughout, it has already been carrying out. If I want to shift it from one place to another, where a tower has to be installed, you know, in order to connect to that particular tower, you know, I have to install another 3 to 3 towers, additional towers. So it will become very difficult because it has already been charged and energized also. Now, a report as a commissioner was appointed by this honorable court, to check whether it has been charged or energized. I'll take your statement that it is charged.
Lord, I am not
But
disputing. that.
I'm not able to understand as to how moving it maybe about 100 feet.
Not 100 feet, no, because from here to, they have to move there, my lord. The line has to be charged to the next, it is level, the next tower, ma'am. Connecting it to the next tower will go. It is a very difficult, no, it is not feasible also. And then, this honorable court, my lord, in the coordinate bench of this court, my lord, in the recently it has held, my lord, 15, the technical aspects of shifting and, of the lines, my lord, it is not.
Where have you said it is technically not possible that this proposal?
But we have already filed my additions.
Have you seen the sketch that he has produced?
Yes, madam, we have seen and we have filed an objections to that, this one also, IA. What they have filed, now, we have filed a counter to that application.
The same application,
Yes, madam, they have filed.
same sketch,
Same sketch, madam, they have produced earlier.
With the
also.
same sketch, Nandish?
They have produced, madam.
same sketch had been filed.
2018 itself they have filed.
Lord, in fact, if your lordship sees, my lord, 15/11/2018 order, my lord, passed by this honorable court. There was a specific direction, my lord, that they cannot precipitate with the matter. Even though, my lord, there was a direction by this honorable court, my lord. My lord, your lordship may kindly see order dated 15/11/2018, my lord.
Thereafter, what has happened is, they are keeping on taking the time and this court didn't,
Since 2018, they are taking time, your lordship.
your lordship can peruse the order sheet, madam. Since 2018.
And the project is already completed in 2018 itself.
18 itself, the
18,
project has been completed, energized.
Then what is this order that you passed saying that you were willing to 29/11/2018? Learned Counsel for Respondent number 1 and Learned AGA for R2 would submit that if the petitioner undertakes for the above, then they would be willing to realign the drawing up of the power lines.
They didn't keep any undertaking that comes, this in
No,
compliance.
this argument of yours now, that technically it is not possible is incorrect now.
No, madam.
Because you made a statement before this court saying that if they bear the cost of,
That point of time, it was not even, it was at the stage of construction. Then we told that it is not,
the very same proposal was put to you.
but they didn't come forward later,
So therefore technically it is possible.
at that point of time. Because look at the order sheet, they took time and they just.
All right, now they will pay for it. They will pay the escalated cost.
Yes, they have taken a time for the.
So now they will pay, the escalated cost, whatever you determine.
My lord, they have around
Technically
48 lakhs
possible.
rupees, my lord, with them.
If it's technically possible, if you have made the statement before,
How it is not possible, because it's already been aligned and charged also, throughout the line it has been charged.
I don't know, once you make a statement, you can realign it. You are not being fair to the court. Once you are saying it is technically not possible,
At that point of time, during the state of construction, we have made a statement. But now this construction has been done and it has been charged also already.
even if it is charged, you will draw a parallel line and then fix up the lines and then recharge it again.
Get some additional towers in the neighboring lands.
No,
So
no,
then it
You
will
were,
make
you
it
were
a-
aware of this when you made the statement.
At that point of time, they only showed before, made a submission before this court, they're going to get the consent of the neighboring landowner.
My lord, in our land only, my lord, let them lay the line.
Do you have a copy of the order? Survey number 13. Who's 13?
Neighboring landowner, they didn't come forward.
My lord, my submission is this, my lord, in our land only, let them erect the tower in one corner, my lord. I have already, my lord, in the map, your lordship may kindly see, my lord. No, in the map, your lordship may kindly see, my lord, it is permissible. If it is made in one corner, my lord, I will block that and I'll utilize the entire land, my lord. That is the only submission. And they have 42 lakhs, my lord, they have been kept, it is pending with them from 2014, my lord. They can utilize that amount and additionally, I'm willing to pay. We've been telling this, my lord, from the time, your lordship may kindly see 15/11/2018 order, my lord. There is an order not to precipitate. The very same day, they enter upon my land and during pendency of the writ petition itself, they erect the.
During that, not to precipitate the matter, thereafter the matter was listed on the next, on 4/11. There, since then, they are keep on taking the time without going ahead. And since this honorable court felt that since it's the public purpose, they didn't extend.
Where is the
No, there's
affidavit
no
that you
question
filed
of
saying it is not
extension, my lord,
possible
it
to
is
realign?
a.
Which is the affidavit that you filed saying that it is not possible to realign? I think both of you are sitting on ego.
No, but it's not a question of.
Think so?
File has already been charged. That is the only.
Show me the affidavit where you have said it's not possible to realign.
Lord, affidavit, my lord, 15/11/2018. That time.
ಏನ್ ನೀವು ಇರೋ
It's the
ಎಕ್ಸಿಸ್ಟ್
same day, my lord.
ಇಲ್ಲ ಎಕ್ಸಿಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ ಇದ್ರು ನೀವು ಮಾಡ್ಕೋಬಹುದು ಅಲ್ಲಿ ಏನಾದ್ರು ಪ್ಲೇ ಗ್ರೌಂಡ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಆಯ್ತು ಅದೇನೋ.
My lord, if
Carry-
they will not permit it, my lord. Even the buffer zone, my lord, they draw a buffer
You have a
zone.
large parcel of land.
My lord, because my lord, children will be there and because of the buffer zone, my lord, I will not be able to utilize. that.
Don't build a building, you can use the corridor portion
My lord, I
for
don't
your,
think it is permitted, my lord, because of the buffer zone, my lord, and the high tension wire.
you can have it as a playground or you can do something else with that land. It's not like as if it becomes totally useless. You have such a vast space of land, you can have the building on this corner and still enjoy the land. Why are you sitting on?
Lord, but if it is permissible, my lord, if they, in our land only, my lord, not in the
Which
adjacent
affidavit
land
have you
also.
filed?
Was filed on. Objections to the application that I filed. The paragraph number 8 here. Paragraph number 7 and 8. The chosen objections to the application, what they have filed, 9/11/18. 9/11/18 application objections. Our application is 9/11/18 for consideration of anything fair.
9/11?
I have a copy of it. Filing open. 9/11/18 on application.
ನೀವು ಹಾಕಿರೋದು 14/11 ನಾ? 14/11.
14/11. In that matter, paragraph number 7, 8 matter.
No, this you are saying it's already late, therefore you won't do it. You are not saying technically it is not feasible.
We are saying that preceding towers has been laid. The alignment has to be changed, entire alignment.
No, if you have to realign the whole thing, you'll pay the entire cost. ಒಂದು ಎಸ್ಟಿಮೇಟ್ ಕೊಡಿ 2 ಕೋಟಿ ಆಗುತ್ತೆ ಅಂತ ಅವರೇ ಬೇಡ ಅಂದ್ಬಿಡ್ತಾರೆ. That is all. That's the best way of.
My lord, last time an estimation.
Therefore, if you give an, as it is, your estimate will be exaggerated. Say it's going to cost you 2 crores, you'll say, all right, do whatever you want to do and take that 42 lakhs. That is all that will happen. Why do you want to fight this?
It's already completed and charged, my lord. That's
Correct
it.
country, you make an exorbitant claim now.
No,
if-
my lord, that's also they will come and say that.
Then I'll close him, it will be before me, isn't it? Then I'll hold that he made a wrong submission that he'll be willing to undertake and is not coming forward. Therefore, I'll dismiss the petition with costs.
They are undertaking, this undertaking was they are giving. 18.
You can, if you give me an estimate as to how much it will cost to realign this. Give an exorbitant sum, it doesn't matter. Let us see if he'll pay or not. Either way, his argument is 500 crore is with you. He is prepared to pay another half.
Taking the component.
He is prepared to pay another 500 crore to you to realign this. So you'll virtually get this land free.
I'll see.
And he will not claim any compensation for this particular land that you are going to lay. I'll record that and then close it. He will lose.
I have to see.
You will lose the compensation that is already paid and also pay some more money to get it shifted.
Then I have to see this, because how many towers it has to be changed.
See, let us see if there's a possibility. Maybe then he'll back out if the figure is too much. Nandish will simply say it will become infructuous. Maybe a better way of.
So that
ಆಗತ್ತೆ ನಿಮ್ಗೆ ಕೊಡಕ್ಕೆ.
I have taken instructions till my lord, 500 crore, 50 lakhs to 60 lakhs we are willing to pay.
ಅವರು ಇವಾಗ ಗೊತ್ತಾಯ್ತಲ್ಲ ಅವರು ಜಾಸ್ತಿ ಮಾಡೇ ಮಾಡ್ತಾರೆ.
Lord, on the SR value, they will have to give. my lord.
ಅದೆಲ್ಲ ನೀವು, it's not for you to question.
Please, I understand that. Let them come up with the,
if I want to shift it to the neighboring land, they have to.
my lord,
Not the neighboring
not
land.
the neighboring land, my lord.
Take a sketch, he's asking it in his own land. Instead of being in the center of the land, he's saying, put it to a corner.
Possible you would have erected at that point of time itself. It is not.
From the arguments that I'm hearing, it looks like more reason of opposing for the sake of opposing rather than for helping him.
No, no, it's not like that because now corner ಹಾಕ್ಬೇಕು ಹೋದ್ರೆ ಈ ಕಡೆ towards alignment ಹೋಗುತ್ತೆ.
Who is the engineer who's to decide this? Who is the engineer to decide this? Feasibility?
Feasibility is a expects engineers to do it.
ಯಾರು? Name him, I'll ask him to be present and ask him to fill an affidavit.
I will ask him because I will ascertain who is because technical feasibility engineer who is
I'm not passing any order now, but you will ask from the engineer. If I doubt you, I'll ask him to be present for the court and ask him to fill an affidavit. Be careful.
regard to the feasibility.
Realignments. If I find anything hanky-panky, I'll ask somebody else to do the inspection and tell me whether it's feasible or not.
Very well.
Be
Because,
careful.
this route alignment is running from Dharmapuri Nagar. That's what I am saying. It is
Realist.
from Dharmapuri-
I've told you, I've put you on notice as to what I propose to do. If you, I think you are acting smart.
No, but it's not like actually smart because it's the route alignment is from the Dharmapuri to.
Next Thursday, please.
Obliged.
Don't get your hopes high. No. It's a
My lord,
small
we are in
tax
their
that is-
hands, my lord, I know it, but my lord, we are willing to pay the cost. My lord. Adon corner hodre, we'll utilize the entire land. Please, obliged.
Seal number 27 adjourned. Seal number 28, Sri Suyogi Herale.
No, the only thing is whether it can be shifted to within their property.
But I appear for the petitioner.
Do you have a copy of the sketch that he has given you? That's all.
The society.
He has shown the existing power line and the proposal. If that can be done, what is the cost?
Matter may be passed over. my lord.
Seal number 28.
Instead of passing it over, my lord, the matter on the criminal side, civil suit was there. Civil suit was decreed for specific performance. Appeals are pending in this honorable court.
Please, my lord,
Therefore,
maybe passed over. Senior is held up in another court.
therefore may be adjourned by 3 weeks. In the meantime, RSS are
What
disposed.
is the complaint about?
Complaint is about 420 in respect of a particular property.
You are the seller.
Yeah, agreement to sell.
You are the seller and he is the
Yes,
purchaser.
agreement to sell. Yes,
What happened to the suit?
suit is decreed, specific performance.
And you are in appeal.
Some of the parties are in appeal. Who are there?
The purchaser is in appeal. Who is in appeal?
Purchaser in appeal.
You have not challenged it.
I have not challenged it.
I have closed the proceedings either way since you have succeeded.
Kindly have it. Maybe.
Afternoon ಬೇಡ.
Pass
ಇನ್ನೊಂದು
over.
ದಿವಸಕ್ಕೆ ಹೋಗ್ಲಿ. ಪಾಸ್ ಓವರ್ ಅಂತ ಹೇಳಿದ್ರೆ ಅದೇ ಗತಿ.
I'll seek instructions.
Realist.
Second,
Adjourned.
second. Seal number 29, Sri Sarvana S.
But this issue is covered by division bench of this honorable court notes. Along with a memo, notes 21/2022. I have filed the judgment of the division bench. Now, this matter pertains to the power purchase agreement. Initially, my lords, without show cause notice, the power purchase agreement came to be,
ಯಾವತ್ ಮೆಮೊ ಹಾಕಿದ್ರೆ?
notes, 20th January 2022.
It's covered.
22, it's filed, my lord.
Is it covered?
Yes, my lord.
Same issue. 6
Not-
months time was.
6 months time, my lord, was to be, my lord, granted. But from that date, my lord, it's more than it's 4 years, my lord, because the writ petition is filed in 2018.
It's from para 9 to 11, my lords, and para 14. Exact same facts, similar facts.
ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ರ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ, ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ರು. ಅಲ್ಲ initially what happened, without show cause notice, agreement came to be rejected. We approached this honorable court.
ಡಿಸೆಂಬರ್ 2018 ಇಂದ ಅದೇ 4 ವರ್ಷ ಆಗೋಯ್ತು.
ಅಲ್ಲ, ನನಗೆ agreement reject ಆಗಿರೋದ್ರಿಂದ ನಾನು ಏನು ಮಾಡಕ್ ಆಗಿಲ್ಲ. I was before this honorable court and there was an interim order, not to 6 months.
Same order.
Please.
It is not in dispute that the subject matter of this writ petition is covered.
It's even otherwise.
The decision rendered
It's not, memo
by
is filed in
division bench of this
2022,
court.
my lord. From then, they had not more than
In writ of
years
number
time.
so and so disposed of on 12th of December 2018. Whereby the division bench had ordered the GESCOM to grant the petitioners 6 months' time to complete the construction of the buildings and then carry out an inspection and examine as to whether they would meet the conditions prescribed and agreed to under the subject agreements. And if so, proceed further. In the rate of the above. The respondent Neville.
I am respond number.
Third respondent.
Third respondent.
3 and 4.
Directed 3 and
Third, second.
2 no barತಾರೆ.
2 and 3.
Respondents 2 and 3
2 and 3.
are directed to grant 6 months' time to the petitioners to complete the construction of the buildings and thereafter carry out the inspection and examine as to whether the petitioners have met the conditions prescribed and agreed to under the agreements. ಸಾಕಲ್ವಾ ಅಷ್ಟು?
Number 30, Shri Saurabar.
For the petitioners comes. ನಾನು ಫ್ಯಾಕ್ಟ್ಸ್ ಅಷ್ಟು ಹೇಳೋದು ಮುಗಿಸ್ಬಿಡ್ತೇನೆ so that according to me other things may not be necessary to be gone into. Just give me 3 minutes. Under inamabilition, this thing, applications were made for regrant under KVO Act. Under KVO Act, applications were made for regrant. Respondents 3 to 8 claimed to be rival claimants. There was an order of regrant in my favor under Annexure C dated 5/2/2010. That was challenged by respondents 3 to 8 by filing a miscellaneous appeal before the district court. Under Annexure D, an order was passed. Regrant order in my favor was set aside. At the same time, respondents 3 to 8 who were the appellants were directed to approach the civil court to establish their claim that they are legal representatives of one of the Barwardar. That was the order. That was to be done within 3 months. They should approach the civil court within 3 months. If they don't approach, I am at liberty to move the Tahsildar for considering the application of fresh was the order. They preferred a writ petition against that. In fact, I had also filed a writ petition against the remanding of the matter. In their writ petition, the order of remand was confirmed with a direction that as directed by the in MA, they should approach the civil court. Again, fresh 3 months time was granted. Against that, they preferred a writ appeal. Writ appeal was dismissed, but time was extended.
Who did not file a writ appeal?
I did not file any writ appeal. In the extended time also, they did not file the suit. Therefore, I made an application before the Tahsildar under Annexure G, page 110.
Seeking for enforcing.
To take up the case in view of the fact that they have not filed the civil suit. This application was filed on 13/11/2014.
Yes.
Matter was lying like that. In the meanwhile, they filed a SLP and SLP was rejected.
So their requirement to go to civil court is become final.
No, in the SLP again time was extended to go to civil court. As I was not knowing about the SLP, I filed application saying they have not gone to civil court. Please take up the matter.
Suit hakadra in the extended time.
When the SLP was rejected, again extending the time, they filed suit OS number 16 of 2015. The 161 of 2015.
That is still pending.
that is still pending. I made an application before the representation before the Tahsildar. In the meanwhile, one other development. As Tahsildar did not take up the matter, I had approached this court for a writ of mandamus. When I came to know that in the SLP time is extended and suit is filed, I did not press the writ petition. I made a representation before the Tahsildar saying, now that the suit is filed, as per the order of the High Court earlier order, please defer the application filed by me. That is annexure L at page 149.
What is it done?
Somehow, Tahsildar did not take note of that. We have made some personal allegation against him that may not be necessary to be gone into. In spite of bringing to his notice that suit has been filed, he has now passed an order. Of course, rejecting my claim, granting them, etc. This was done according to us after transfer, but anyway, that may not be necessary to be gone into. My only case now is there is an order by the High Court that if they approach the civil court, after finishing that, matter will have to be taken up.
ಇದ್ರ ಮೇಲೆ appeal ಹಾಕ್ಲಿಲ್ಲ ನೀವು?
ಇದ್ರ ಮೇಲೆ appeal ಹಾಕ್ಲಿಲ್ಲ, ನಾನು direct ಇಲ್ಲಿಗೆ ಬಂದೆ. As the direction by this court was, after the civil suit, it should be taken up. I have directly come here.
Where is the order of the division bench?
Please,
Or the-
madam.
Or the writ petition asking them to go to civil court?
That is page 101. Last paragraph ನೋಡ್ಬೇಕು. In the light of the order dated 8/2/2011 in WP so and so, staying until further orders, the direction issued by district judge in so and so to the petitioners therein to approach the civil court in respect of legal heirship, learned counsel for the petitioner submits that petitioners would approach the civil court within 3 months from today, and on failure, learned counsel for the petitioners in so and so submits that those petitioners would comply with the order in MEA 26.
But this court did not state that the Tahsildar should stay his hands till the disposal of the suit.
Para 5 ದಲ್ಲಿ. Learned counsel for the parties are unable to get over the principle of law laid down in the aforesaid decision. Writ petitions devoid of merits are dismissed. The entries in the revenue records are directed to be maintained without effecting any change until disposal of the dispute over legal heirship as between the petitioners.
ಇಲ್ಲ ಅದುವರೆಗೂ
ಅಲ್ಲ MEAದಲ್ಲೇ ಆರ್ಡರ್ ಇದೆ. ಅವರು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ he should await. That's an order in the page 84. Of course, ಏನೇನೋ wordings repeat ಮಾಡಿದ್ದಾರೆ. But in effect, it is that. Kindly go to page 84. In the middle, in the event, your lordship's got it, Mala. In the event of failure of the appellants to approach the competent civil court as stipulated above, they lose all their alleged legal rights in respect of the scheduled lands. In the event of non-approaching of the present appellants to the civil court as stipulated above, the present respondents are at liberty to move the learned Tahsildar seeking required relief.
ಇದರಲ್ಲಿ there is no reference to the filing of the suit ಇಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಅಲ್ಲೇನೆ ಫಸ್ಟ್ ಟೈಮ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದು ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ರಿ ಅಂತ.
The impugned order annexed.
ಇಲ್ಲ, ಇವರು ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ಅವರ್ ರಿಪ್ರೆಸೆಂಟೇಶನ್ ಇಟ್ಸ್ ನಾಟ್ ದಟ್. It's only on that ground we have said matter will have to, the order will have to be set aside, matter will remain with the Tahsildar till the disposal of their suit. Writ appeal nalli same order was confirmed, extending the time.
Get your senior, madam. Get your senior. First.
May I make a submission, my lord? Respond number 2, my lord. Tahsildar who passed the order has been made as a party in individual capacity. In view of the submission made by the senior counsel that need not to go into that matter, my lord, some allegations are made. Maybe, my lord, my name may be deleted.
Let us see. Suppose you were transferred and thereafter you pass the order from the records. Why should I let you go?
It is not so, my lord. It's not so.
It is.
They simply say that they come to know by sources that I have received some money, my lord. That is the allegations, my lord.
If you have not even noticed the order of the district judge.
No, there
The
is,
writ
I have not
petition,
noticed.
the writ appeal and the SLP.
No, there is one more writ petition, my lord. That I have.
You were basically complying with the order of the district judge.
Yes.
If you have not even noticed that,
No,
have you
there
even
is-
stated that suit was filed or not filed?
My lord, what happened, my lord? The Tahsildar has, my lord, there is a judgment by the Honorable Court, my lord. Can you-
ಏನಂತ ಹೇಳಿ ಏನಂತ ಹೇಳಿ ಸರ್?
There is a direction, my lord. My lord, it seems, my lord, he has, my lord, sees, kindly, my lord, I will read, my
You
lord.
just tell me what it is.
There is a direction, my lord, which says in that case, my lord, the petitioners filed a memo, my lord, the Karnataka Council for the seventh respondent is taken on record. Writ petitions are dismissed as having become infructuous with liberty to the petitioners to approach the Tahsildar as and when he review the proceedings. That has been taken.
He is bound to look at the order of the district judge. He was basically to comply with the order of the district judge. If there's no finding at all as to whether a suit was filed or not filed, then the entire order is bad.
Yes, my lord, but the Tahsildar records that there is the direction by the High Court. That's why, my lord, I have taken the matter for.
Maybe some costs because you will have to reimburse the money that you have taken.
No, my lord, there is no source. My lord, baseless allegations.
ಇಲ್ಲಿ ಜಮೀನು ಇರೋದಿಲ್ಲಿ
ಜಮೀನ್ ಇರೋದು ಇದು ಅನೇಕ.
ಕೂಡ್ಲು ವಿಲೇಜ್.
There are no.
ಎಷ್ಟು ಎಕರೆ ಇದೆ?
3 ಎಕರೆ. Eight acre, 29 guntas. But there are no, my lord, not to, my lord, no.
Legal Service Authority, I'll ask you to deposit 8 lakhs.
There are no such.
ನೀವು ಅದೇ ರೇಟ್ ಮಾತಾಡಿರ್ತೀರಲ್ವ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾರೆ ಎಕರೆಗೆ ಎಷ್ಟು ಅಂತ.
I request not to presume, my lord, when there are no evidence, my lord.
Consider that to the State Legal Service Authority or to the
Yeah, I
Clerk
can-
Association. How can you not even look at the order of the district judge?
No, can we see the order, my lord? Can we see the order? What the Tahsildar records?
Order of remand was made asking you to consider the applications for regrant.
But
That was the basic order for
yes,
you.
my lord, my humble
If the
submission.
order said one of the parties are to go to the civil court to obtain their determination of the rights as a legal representative, without even considering that particular factum, how can you pass an order?
My lord, the Tahsildar, my lord, presume that, my lord, there was a direction by the High Court to consider, my lord.
All right.
That was, my lord.
You are right. Tahsildar, the High Court directed you to consider. Consider what? The order of the district judge.
To review the
So the
matter.
order for review required you to verify whether they had a legal right to make an application or not.
Yes, my lord. But that is only, my lord, misunderstanding, my lord, not to.
ನೀವೇ ಡಿಟರ್ಮಿನ್ ಮಾಡಿ ಎಷ್ಟು ಕಾಸ್ಟ್ ಅಂತ ಐಲ್ ಆಸ್ಕ್ ಯು ಟು ಡೆಪಾಸಿಟ್ ಟು ದಿ ಸ್ಟೇಟ್ ಅವ್ರು ಕೊಡಲ್ಲ ಸ್ಟೇಟ್ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ.
There are no, my lord. I request, my lord, not to presume, my lord.
8 acres you will not have done it for a cheap price.
It
ನೀವೇ
requires,
ಡಿಸೈಡ್ ಮಾಡಿ ನೀವೇ ಡಿಸೈಡ್ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ನೀವೇ
request,
ಹೇಳಿ
my lord,
ಎಷ್ಟು
remind,
ಕಾಸ್ಟ್
my
ಅಂತ.
lord, anyway, my lord, there is a order, my lord. There is civil, my lord, dispute pending, my lord.
ಇಲ್ಲ ಅದೆಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗ್ಲಿ ನಿಮ್ಮ ಮೇಲೆ ಹೇಳ್ತಿರೋದು.
Lord, there, my submission only my lord, the Tahsildar has misread the judgment, but
I am putting you on notice. This is what I propose to do. I am giving that liberty to choose the price. As a council, ನೀವು ಎಷ್ಟು ಹೇಳ್ತೀರೋ ಅಷ್ಟು ಕೊಡ್ತೀನಿ. ಪಾಸ್ವರ್ಡ್.
Number 31, Shri Amrutesh NP. Number 31.
kindly see the prayer, my lord. Page 15. These may not survive for consideration. Seeking to restrain the police from arrest.
Who are the petitioners?
Petitioners are not. Or accused in Gauri Lankesh case. Charge sheet is filed. Now, the prayer is, none of these prayers are maintainable, either maintainable nor survive for consideration.
DNP ಮಾಡೋಣ ಬಂದಿಲ್ವಲ್ಲ. ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ರೆ ಆಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಲಿ ನೋಡೋಣ. There is no appearance on behalf of the petitioners. In my view, there is no justification to adjourn the matter. Let petition set for dismissal on first.
Bill number 32, Shri Ashok P. Patil. Bill number 32.
Sir, dismiss ಮಾಡಿದ್ರ?
Bill number 32, Ashok P. Patil. Refer to complainant.
Yes.
What compromise on, what you can recommend us to the mediation center cycle?
498 A, your lords.
What's your name?
Dominic Avinash.
Accused, sole accused. Petitioner.
You are the petitioner.
Yes.
You don't have a counsel.
Just gave, she said it won't take it, he just gave me the no change certificate this morning. Don't have a counsel right now. This morning gave me no change.
NOC ಕೊಟ್ಟಿದ್ದಾರೆ.
Compromise ಏನು ಆಗಿಲ್ಲ.
ಅಲ್ಲ, NOC
He says he is taken an NOC.
Given an apostille. Want to recommend it to the mediation center. For mediation. The way it talks, but failed, talks failed.
ಯಾವತ್ತು ಮದುವೆ ಆಗಿದ್ದ?
2016.
What is the compromise that you propose? Any children?
Your Honor,
Any children?
I just have a son, Your Honor. Just want visitation rights with him, that's about it, nothing else.
Maintenance claim ಏನಾರು ಇದೆಯಾ ನಿಮ್ದು?
No, nothing. There was cases filed on them, on me, and me on them, and a divorce petition was filed in the family court. We went through mediation, she agreed to all the terms and conditions of everything. The mediation report was signed, it came to the court, and in court, she refused to give the agree for the divorce. And whatever case I had found, I withdrawn from them. As per the agreement of the mediation, she had to withdraw this case, which is still not yet withdrawn. I have withdrawn all the cases. Right now, we have agreed upon.
Mediation ಹೋಗಿತ್ತು. When was it sent to mediation? Mediation was sent in the family court?
Yes, sir. Even order, the judge, my lawyer has not got the order copy yet. I just want, I just spoke.
I'll adjourn it to another day, get everything ready.
Yes, sir.
The party appears in person, the petitioner appears in person and seeks for time to engage another counsel. On the ground that he has obtained NOC from Ashok P. Patil. Relist zones.
28. 28.
This month, 28. Thank you.
Bill number 33. Venkatesh Kumar Reddy.
Petitioner. The commutation order, my lord, remitting the sentence, remission order, my lord, is under challenge. Petitioner's parents were murdered, my lord. Both the parents were murdered. And
challenging annexure R1.
R1 is the new guidelines which are framed, my lord, for releasing of the prisoners, which they have produced along with the statement of objection. That is also under challenge. Basically, I am challenging annexure A, my lords. The order of the state government, my lord, by which page number 14, my lord. That relevant portion is page 15. Total 17 life convicts were released on by remission, my lords. Names of the concerned prisoners.
ಸನ್ನಡತೆ ಅಂದ್ರೆ ಏನು? ಸನ್ನಡತೆ ಆಧಾರ ಅಂದ್ರೆ ಏನು?
ಸನ್ನಡತೆ ಗುಡ್ ಸನ್ನಡತೆ ಗುಡ್ ಕಾಂಡಕ್ಟ್ ಸನ್ನಡತೆ ಆಧಾರದ ಮೇಲೆ ಅವಧಿ ಪೂರ್ವ ಬಿಡುಗಡೆ ಮಾಡಿ ಆದೇಶಿಸಿದೆ. ಸನ್ನಡತೆಯ ಆಧಾರದ ಮೇಲೆ ಅವಧಿ ಪೂರ್ವ ಬಿಡುಗಡೆ ಅಂಗೀಕರಿಸಿದ ಬಂಧಿಗಳ ವಿವರ. List of convicted prisoners, my lords. There, kindly be pleased to turn to page 17, my lords.
Good behavior during their
ಸನ್ನಡ
period of sentence. My lord, Bilkis Banu's case and Swami Shraddhananda's case could be applied, and therefore, my lord, if based on that, my lord, based on the judgment by the Supreme Court, the latest one being Bilkis Banu's case, not it could be disposed of. Not we will have it some other day, my lord.
Relist.
Please.
The
My contention is.
parameters are laid down in that case.
My lord and friend is very much right, my lord. Parameters laid down. My lord, Sannadate means good conduct.
Good
There are, when they were, came out after conviction, they came out on parole, my lords. At that time, criminal cases were registered, complaints were registered, and district superintendent of police said, don't release them. This, of course, was not considered. It was not kept before the concerned committee. This material, my lord, registration of criminal cases and threats during their parole. So after conviction also, they indulged in.
What is the term that you're serving?
No, my lord, I am for the first in petitioner, I am for the petitioner.
He's the victim.
Who is the victim?
Victim's brother.
Both my parents are murdered, my lords. I am the victim. My parents are murdered by these respondents, my lords.
And you are seeking for their release.
Cancellation.
No,
I
he's
am-
challenging the remission order granted by the government.
Please, respond number 1 and 2.
Release
I'm sorry.
No,
No. This is a peculiar case, my lord. At the time when my parents were murdered, I was.
Who's released Parameshan Siddharaj?
Chandrakant is before.
Not after 14 years.
ಇಲ್ಲ 14 ಆಗಿಲ್ಲ
Yeah,
sir.
sorry,
ಅಲ್ಲ
14
ಅದು
ಆಗಿಲ್ಲ.
ಅದು ಒಂದು ಕಂಟೆನ್ಷನ್ ನಮ್ದು 14 ಮಿನಿಮಮ್ ಆಗ್ಲೇಬೇಕು 433A CRPC ಅಲ್ಲಿ 12 ವರ್ಷ ಆದಾಗ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಎರಡನೇದು ಈವನ್ ಅದರ್ವೈಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಸನ್ನಡತೆ ಏನು ಕೊಡ್ಬೇಕಾದ್ರೆ ಸನ್ನಡತೆ ಇರಬೇಕಲ್ಲ.
For 6 years they are outside.
Yes, that's why it was outside, my lords, because R1 and R2 came repeatedly short time before this honorable court. Repeatedly. Then they remained absent. Now 3-4 hearing dates, nobody is representing R1 and R2. They feel that now that the time is already 6 years, they are outside. 2018 onwards.
Hearing that.
Continuously they are absent. Yeah, they are continuously absent. Before your lordship may kindly be pleased to see the this honorable court was pleased to note it. Continuously they were.
This writ petition pertains to the release of R1 and R2 for good behavior by remitting their sentences. It is noticed that the matters of the year 2018 and therefore request to be disposed of at the earliest. Counsel for the respondent number 1 and 2 is however not present. As a last chance for the appearance of R1 and R2. Post on. Inform him.
2nd July. Please. Grateful.
ನಮ್ಮ ಏನೋ ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದೀವಿ ಇದ್ದಾರೆ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ರೀಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ.
Serial number
35 ಮೇಲೆ ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ 82 ಇಂದ ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ದೇರ್ ಇಸ್ ಎನಿ ಚಾನ್ಸ್ ಆಫ್ ಸೆಟಲ್ಮೆಂಟ್ ಮೇಲೆ ವಿ ವಿಲ್
ಆಗುತ್ತಾ?
ಅದೇ ಅಮೌಂಟ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಇದಿದೆ.
Relist.
28.
ಬಂದಿದ್ದಾರೆ. Explain the problem to him. ಆ ಪ್ರಾಬ್ಲಮ್ ಅರ್ಥ ಆಯ್ತಾ ನಿಮ್ಗೆ? ಇಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಚಲನ್ ಕಟ್ಟಿದ್ರೆ ಆ ಕೇಸ್ ನಂಬರ್ ಬರೆಯಕ್ಕಾಗಲ್ವ ಅಂತ ಹೇಳಿದ್ರೆ ಆ ಕೇಸ್ ನಂಬರ್ ಬರೆಯಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ ಯಾವ ಕೇಸ್ ರಿಲೇಟ್ ಆಗುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ನಮ್ಗೆ. ಯಾರನ್ನ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾರೆ? ಯಾವ ಕ್ರಮ ಬರ್ತೀರ? ನೀವು ಕಮಿಷನರಾ? ಕಮಿಷನರ್ ಬರ್ಬೇಕಿತ್ತಾನೆ. The deputy director of Treasury is present and submits that he will get the technical person involved to attempt to resolve the issues raised in the petition. Relist on so and so. Date could
28. Wednesday.
28.
Could it be little earlier?
ಇನ್ನು ಬೇಗ ಆಗುತ್ತಾ? Monday.
24. I'm appearing for the respondent in this. Some inconvenience.
2014.
ಇಲ್ಲ. Malars, I am not seeking. I was ready last occasion, Malar. Next week ಅಲ್ಲಿ ಯಾವ್ದೊಂದು 28.
ಅಯ್ಯೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ನಿಮ್ಮ ಅಯ್ಯೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ಅಲ್ಲ ಸಾಹೇಬ್ರ ಅದೇ ನೋಡೋಣ ಅಯ್ಯೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ನಿಮ್ಮ ಅಯ್ಯೇ.
ರೀಚ್ ಆಗ್ತದೆ. ಇಟ್ಸ್ ಮೇ ರೀಚ್.
ವಾಪಸ್ ಬೇಕಾ ನಿಮ್ಗೆ? ಆಮೇಲೆ ಬನ್ನಿ 2:15 ಕರೆಸ್ತೀನಿ. ಅಲ್ಲ ಫೈಲ್ ಅಲ್ಲಿ ಹೋಗಿದೆ ತರಿಸ್ತೀನಿ. ಹಾ ಇದೆ ರವರ್ ತೋರಿಸಿದೆ ಈ ಒಂದು ಇದೆ ಯಾವುದು ಅಲ್ಲ ಇದೆ ಅದು ಅದೇ ಧಾರವಾಡ ಗುಲ್ಬರ್ಗ ಇದೆ ಅದಾದ್ಮೇಲೆ ಹೊಸಪೇಟೆ. ಯಾವುದು ಇದೆ ಅದೇ ಅದಾದ್ರೆ ರೀಚ್ ಆಗುತ್ತೆ. ಅದೇ ಪಾಸ್ವರ್ಡ್ ಒಂದು 4 ಇದೆ. ಅವ್ರ ಅಡ್ವೊಕೇಟ್ಸ್ ಗೊತ್ತಾ?
ಯಾರು ಬಂದಿದ್ರು ನಮ್ಮ ಅಪ್ರೋಚ್ ಮಾಡಿಲ್ಲ ಬಟ್ ಇಬ್ರು ವಾಪಸ್ ಆಗಿದ್ದಾರೆ 18 ಗೆ ಬೇರೆ ಪರ್ಫಾರ್ಮ್ ಇದೆ 22 ಗೆ ಬೇರೆ ಪರ್ಫಾರ್ಮ್ ಇದೆ ಡಿಗ್ರಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ ಸರ್.
65 ಗೋಪಾಲ್ ಅಡ್ವೊಕೇಟ್ದು
ಸರ್ ಅಜ್ಜನ್ ಮಾಡಿಲ್ಲ ಸಾಹೇಬ್ರದು.
ಅಲ್ಲ ಮಾಡಿಲ್ಲ, ಬಟ್ ತಗೋತಾರ, ರೀಚ್ ಆಗತ್ತಾ?
ಸರ್ ಗೊತ್ತಿಲ್ಲ ಸರ್, ತಗೊಂತಾರೆ.
ಅಲ್ಲ ಬಿ ಗ್ರೂಪ್ ಹೋಗುತ್ತಾ ಈಗ 2:30ಗೆ ಹಿಯರಿಂಗ್ ಮತ್ತೆ?
ಸರ್ ಇಲ್ಲ, ಒಂದು ಕಲಬುರ್ಗಿದಿದೆ, ಧಾರವಾಡದಿದೆ, ಅದಾದ್ಮೇಲೆ ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಒಂದು 4 ಇದೆ, ಅದಾದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್.
ಹೌದಾ? ಹಾಗಾದ್ರೆ ನಾಟ್ ಲೈಕ್ಲಿ ಆಗಾರೆ. ಓಕೆ ಬರ್ತೀವಿ, ನೋಡೋಣ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Lose motion.
ಆಯ್ತು ಆಯ್ತು ಕಡ ಮಾಡ್ಕೊಂಬ. ಹಾ ಹಾ. ಆತಾ ಹಾ ಆತಾ.
ಸರ್ ಗೋಪಾಲ್ ಸರ್, ವಿಡಿಯೋ ಇದು ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಓಕೆ ಓಕೆ. ಸಾರಿ ಸಾರಿ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆಯ್ತು ಬೆಳಗ್ಗೆ ಆಯ್ತು. ಧಾರವಾಡ ಕಲಬುರಗಿ ಆಮೇಲೆ ಧಾರವಾಡದ ಕಲಬುರಗಿ ಆದ್ಮೇಲೆ. First list.
Yes. What's in? What's in 53? Senior is there. Mr. Naik is appearing for the petitioners. I'm appearing for the state. Can Thursday, next Thursday, can it be taken? Joint request.
Next Thursday, I called in.
I have some difficulty on Thursday. Could it be on first, second, third, or any day of that week?
Any day.
All right.
Could you lots have it on second, Lords? It's pending for a long time, Lords. There is some urgency in the matter.
Fifth is okay, Alva?
Second, Lords, could it come on second, third, or fourth, Lords?
Second.
Lordship, please play it for me.
There's one more request at 64. There was one more excess matter. Lords, we had served a copy of the objections, but there were some changes we had to make and it is yet to be filed. If it is taken up next Thursday, my Lords, 64.
28. Dharwad bench matters. Seal number 1, Shri S.L. Matti.
List 1.
Yes.
In that matter, SPP had to appear in the matter, Your Lordship. They had been taking time.
I have dismissed the non-prosecution. See, you didn't come.
Your Lordship. What delayed, Your Lordship? That's why in the morning I tried to take time, Your Lordship. SPP has to appear in the matter.
He appeared. You did not appear. Therefore, I dismissed you.
We will post it on first week of July, Your Lordship. Senior is not in.
Second.
Please inform Mr. Baliappa.
Yes, I will inform. Much obliged.
Dharwad bench matters. Seal number 1, Shri S.L. Matti.
Please, madam, I appear on behalf of the respondent number statement.
Short time within 3 months. The elections came by yesterday and told all the documents are submitted, the government has to now approve. For the formation of the sites, we have also in principle agreed that all these persons, whoever the lands that we got, everybody will be accommodated is my instruction. So part of the 3 months maybe in the Monday.
You file a statement, then I'll accept it, file a memo or something.
If I had a Monday notes, I'll file a response to that.
Monday.
24th. Seal number 2.
Wednesday is what? If I had a Wednesday note.
26th. Seal number 2, Shri Sachin C. Angadi.
Please, madam, I appear on behalf of the respondent statement.
The offense punishable under section, your lordship, section 9, 39, 40, 44, includes 48, A, 49B, 51 of the Wildlife Protection Act, your lordship. Yes, your lordship, the state has, in a complaint, your lordship, the state has filed, first, your lordship, they are registered the FO, your lordship. And afterwards, your lordship, they are filed the private complaint, your lordship, before the private complaint. And your lordship,
I have passed a similar order, I have passed an order in a similar crime.
ಅದರಲ್ಲಿ as per co-op statement ಪ್ರಕಾರ possible.
Same crime number,
Yes,
same crime.
Same crime. The accused number 1.
You are which accused?
Accused number 1, your lordship.
ಇದೇಂಗ ಅಪ್ಲೈ ಆಗಲ್ಲಲ್ವಾ ನಿಮ್ಗೆ? Accused number 1, how will this order benefit you? How will this order benefit you?
Not benefited to me, your lordship.
Then
Your lordship, the one coordinate bench judgment, your lordship. One coordinate bench judgment, your lordship. Ready, I have filed in counter also, your lordship. In this case, your lordship, for filing the complaint, your lordship, para number 6, your lordship. Can I read your number 6?
yes.
So the London HCGP has brought to the notice of this court decision reported in ILR KR 1892 between yes Blaya versus State of Banneraghatta Police, wherein pair number 6, the court has referred to the notification number ASD 104 FLW 73 dated 16/10/1973, wherein government had authorized to following the person to take note of various offenders can only file complaint in the court of the law. Surplus of the forest officer of the above the rank of the forest officer. In our case, range forest officer has filed the complaint. Same set of facts.
Rank of a range forest officer is above forester alva.
Yes, above range, usually not for the judgment only. Swami and other sources, range forest officer, forest mobile squad.
ಇಲ್ಲ. ಇವಾಗ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ all the officers, all the forest officers of and above the rank of a forester.
Forest.
Who is the complainant here?
Complaint here is range forest officer.
Is he not superior to him?
No.
My lord, as per the submission made by on behalf of the petitioner, range officer is the competent authority who has the power to file complaint. On that basis, my lord, he has filed a private complaint. And one more submission that, my lord, simultaneously during the proceedings pending, he has filed an application for discharge, wherein, my lord, and at a simultaneously he files a petition before this honorable court seeking quashing of the entire proceedings. That is part of the record.
Withdraw this petition and pursue the discharge application.
Even though cognizance are not taken.
Then why did you ask for discharge there?
Yes, prosecuting on both courts, before High Court as well as before the Sessions Court.
You can't have both ways ತಾನೆ. ಏನ್ ಮಾಡ್ಲಿ?
Cognizance are not taken.
Then why did you seek for discharge then?
My lord, cognizance is taken, CC, it is numbered at CC and he is seeking for quashing of that proceedings by filing an application for discharge.
At page number 16, your lordship, order, type the order.
I'll dismiss it only on the ground that you are seeking for discharge there.
That is, may I take your lordship at page number 29, my lord. Hearing on discharge. It is on 5/9/2022. In the mind, my lord, on 16/5/2022, this honorable court has granted the stay. So that, my lord, the proceedings are not gone there.
ಏನ್ ಮಾಡ್ತೀರಾ?
I think instruction because he has filed.
I'll vacate the interim order.
Once of the password because A1 and A2 present, KVP filed application.
I will not permit you to prosecute this petition when you file an application of discharge. That is all. Withdraw this petition and pursue that.
Kindly pass out the material. I will take instruction whether he filed or another applicant.
C number 3, government advocate.
Please, bro. In this my lord, learned AG appears also.
ಏನ್ ಆರ್ಡರ್ ರಿವ್ಯೂ ಕೇಳ್ತಿದ್ದೀರಾ?
ಅಲ್ಲ ಇದು ರಿಗಾರ್ಡಿಂಗ್ ದಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ this court has accepted the calculation made by the assistant registrar, sorry, additional registrar, madam.
Yes.
That the calculation sheet is produced at page 30, madam. Only to start extent this review petition is filed, madam. The interest is levied on the interest, madam. The till column number 7, madam, there is no problem, madam. It is perfectly correct. After the column number 7, madam, at page 30, madam.
Yes.
ಅಲ್ಲಿ 10,29,098,502 ಮಾಡಿದ್ದಾರೆ. From that date, we are already paid some interest. For that amount, the interest is calculated. Only to that extent, madam. Because if this calculation is accepted, madam, it have a larger repercussion, madam. The interest is charged on the interest. Till up to 7, madam, absolutely we agree with this thing, madam. There is no issue. But only to the extent of column 8, that amount of 10,29 lakhs.
ಯಾವ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಹಾಕಿರೋದು?
ಇದು ತಾವು ಈ ಆರ್ಡರ್ ಮೇಲೆ GMCPC ಆರ್ಡರ್ ಮೇಲೆ ರಿವ್ಯೂ ಹಾಕಿದ್ವಿ. ಆರ್ಡರ್ ಅಟ್ page 18. Being agreed by the calculation made by the executing court, my lord, they filed a writ petition before this honorable court. My lord was pleased to direct the registry to make a calculation. The registry has done the calculation, my lord. The only thing is that, my lord, the interest is charged on the interest, my lord. The 10 crore component also include the interest, my lord.
Come to column number 8.
Column number 8 ತನಕ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಕಾಲಮ್ ನಂಬರ್ 7 ತನಕ. ಕಾಲಮ್ ನಂಬರ್ 7 and 8 ಸ್ವಾಮಿ 10,29,000 10 crores 29 lakhs 98,502 rupees is also include the interest component, madam.
ನಿಮ್ಮ ಮುಂದೆ ಯಾವ RP ಇರೋದು?
ನನ್ನ ಮುಂದೆ
89
89, madam.
Because ನಂತರ ಪೇಜ್ ನಂಬರ್ 29 ಅಲ್ಲಿ
ಅಲ್ಲ ತಾವು 30 ಬರೀತೀವಿ 30 calculation made by the registry, madam.
Serial number 13, 14, 15.
ಅದು paragraph 16
ಇಲ್ಲ ಹಂಗಾರೆ ಯಾವ್ದೋ ಬೇರೆ ತಪ್ಪಿದೆ ಫೈಲ್. I only have up to 15.
ಅಲ್ಲ 1,89,000 madam RP.
ಇಲ್ಲ. There's some confusion.
80.
I have RP 100089 by 2024.
ಹೌದು ಹೌದು ಸರ್ ಅದೇ ಸರ್.
This is in respect of WP 102584 by 2022.
ಹೌದು ಸರ್ 102582 by 2020 correct sir. The
page number 30, internal page 14.
ತಾವು internal page 13 ಬಂದ ಸರ್. Internal page 13 13. ಅಲ್ಲಿ ಸಮೀ ಕಾಲಮ್ ನಂಬರ್ 8 ತನಕ
column number 8 15% interest from 2013.
That amount is 10 crore 29 lakh rupees. This amount include the interest amount, madam.
No, this is on 2 crores alwa, 2 crores 37 lakhs.
That is the amount which will come, madam. That is the amount which will come. The interest, if the interest on the 10 crore rupees, the amount will come to 2 crore 83 lakh rupees, madam. ಮುಂದಿನ ಕಾಲಮ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ 10,29,98,000ಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಈ ಡೇಸ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ ಇಟ್ ವಿಲ್ ಕಮ್ ಟು 2 crores 83 lakhs. Correct, madam. But only our argument is the portion of the 10 crore 29,98,000 include the interest amount which was already paid. ಇದರಲ್ಲಿ 3 crore rupees ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಆಲ್ರೆಡಿ, ಅದು ಡಿಡಕ್ಟ್ ಆಗಬೇಕಾಗಿತ್ತು.
Take out notice, let us see what they'll say.
One more submission I wanted to make, madam.
Respondents.
Against this order, we have prepared an SLP before the Supreme Court, madam. That is dismissed by the honorable Supreme Court.
How can I review now?
No, only, even there are some judgment, my lord, even after dismissing also, if the review scope is still available for calculation and all those things, it can be entertained. And another ground, my lord, in this case, the beneficiary is not made as a party, my lord. Now we are faced.
SLP is dismissed.
SLP is dismissed.
I will not allow you to argue that ground.
Actually.
You should have raised that ground before the SLP.
No, that maybe that I don't.
Mathematical mistake antra, I will issue notice to him. Let us see what he'll come and say.
Please, please.
SS party to take notice for the respondent. Relist on.
Next Friday, I will serve the copy on him.
Next
28.
Please, grateful.
All the best.
All the cases same.
Seal number 7.
Please.
Shri Ravi Hegde.
Please, appearing for petitioner, but there is no progress in the writ appeal, which is filed by the management.
Where is the Prashant?
Prashant is not in online mode.
Who should consider the representation?
My lord, consider.
Second
Respondent number 1, my lord.
This court, by disposing of the petition 8th of February 2024, had directed the respondents to consider the representation and pass an appropriate order within a period of 1 month. This court had also directed the matter be listed on 11/3/2024 for reporting complaints. Learned counsel, the petitioner submits that the respondents not considered the representation as ordered despite the lapse of more than 3 months. In view of the above, the first respondent, tane?
Yes, madam.
Please, first respondent.
Shall be personally present before the court on next Friday.
28.
Please inform Prashant.
Please, I will inform.
For further consideration, seal number 8. Ravi
I am
Hegde.
appearing for petitioner, my lord.
ಏನಾಯ್ತು ಇದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ ಏನು ಆಗಿಲ್ಲ. Page number 14, annexure B is the order passed by this honorable court in earlier occasion. There are 4, my lord.
Please.
Who's this Manju Bairal?
I had to ascertain and make submission.
AGN ಅವರು?
Alla. Manju.
Illa, AGL, before lordship in principal bench, they have to undertake to file wakala.
Can't you get hold of this administrator of this Murugarajendra Vidyapita? Ravi was an administrator is appointed.
Yes, ma'am.
Pursuant to the order of honorable apex court.
Can't you ask him to appear? Yaar administrator yara?
District. Earlier, my lord,
No,
district.
retired IAS officer was appointed as an administrator. That order copy was produced along with memo before this honorable court.
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಕ್ ಆಗಲ್ವಾ ಕಲ್ಸೂರ್
Please, I will inform, my lord. I will inform.
Relist on
28.
Please.
May I request one thing?
His name is Shivyogi S. Kalsad.
Please.
Cursor.
Please.
Please inform him.
Yes, my lord. Yes.
Kalburgi bench matter. Seal number 1 for further consideration.
Appearing for petition.
My bail petition only has merits, ma'am. I have not filed the discharge application. He has not filed the discharge application.
I need a submission, my lord.
Culture Mart.
Forward bench, passed over matter, serial number 2.
Please, please.
Already.
ಅವ್ರೇನೋ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ವಾ ಅಂತ ಹೇಳ್ತಾರೆ.
Allah, it is part of the order sheet, my lord. It is part of the criminal petition itself.
Part of the order sheet, your
ಯಾರು ಹಾಕಿರೋದು?
Seal number 2 has filed your lordship, discharge application.
A2 ಅಂತ ಹಾಕಿರೋದು A1 ಅಲ್ವಾ ಅಂತ.
On 13 June 2023, your lordship. Case number 2.
Can you verify?
Yes, my lord. I will verify by the next Friday, my lord.
Realist.
Yes.
The Kalburgi bench matter. Serial number 1.
Appearing for petitioner, madam.
ಏನಾಗ್ಲಿಲ್ವಾ?
What I've spoken to.
ಯಾರು ಮಾತಾಡ್ತಾರೆ?
This is a Kalburgi bench matter. Kalburgi bench.
No, but you had said you will talk to the.
Yes, my lords. Since the code of conduct is just expired, they need about 2 weeks' time to have that policy rectified, wherein all accident cases will be reimbursed to some extent, is what I've been told.
And I had suggested that you have a cutoff.
Right. Yeah, that's all been communicated. That with the same suggestions that this lordships has mentioned, the policy is being modified accordingly to that. 2 weeks' time is to be sought for.
Realist.
5th July. List number 1, passed over matters. Serial number 16. The Jai Prakash.
Address my arguments, 9 matters.
Third, this is the Kumbhara Sangha matter, madam. Last occasion.
Address my arguments, 9 matters.
Serial number 20. Serial number 20, H.N. Basuraju.
Realist.
28. Serial number 23.
Certain compensation was disbursed, and my lord, my respective submission is I'm limiting myself to the submission so far as the diminution value of the land is concerned. So far as the trees that were cut and whatever is awarded by the trial court, my lord, I am not pressing on that.
What is the order passed with the trial court?
My lords, may kindly see at page 29,
20.
my lords, paragraph 22. That is the.
ನೀವೇನ್ ಹಾಕಿಲ್ವಾ ರಿಟ್ ಪಿಟಿಷನ್?
We are also filed one writ petition for enhancement of the compensation.
ಎಲ್ಲಿದೆ ಅದು?
That is
Connected
connected matter itself. It is connected.
23.1 is there.
You filed 2 petitions.
One by the KPTCL and another by me for.
ಎರಡಿದೆ ಇಲ್ಲಿ.
ಇನ್ನೊಂದು ಸಮೇತನು same similar grounds of corridor area.
So far as the first 2 petitions are concerned, I have only limited submission matter. And my lords may kindly see in that table.
Area occupied for electric line. Area occupied for erecting tower. For cutting 18 neem trees, for cutting 1 jali tree, for cutting 6 teak trees.
There is some, I have only 2 submission. One, there is a calculation error. Because whatever we have paid, that has not been deducted completely. One, I'll just put it before my lords. Kindly see, my lords, that at paragraph 11, it is an undisputed fact that I have paid 1,20,154 rupees. My lords, 13,067, 19,262 and 87,825.
So you will be satisfied if the amount that is already paid is taken into consideration.
That is one submission is that, my lords, the trial court has not deducted the entire amount of this.
Whatever you have paid.
Whatever I've paid must be deducted from the total, whatever the trial court has calculated, my lords. For example, my lords, for example, in 18 neem trees, 76,000 is taken after deducting certain amount of 120. I'm saying the greater value can be taken, whatever the trial court has awarded, and deduct completely, totally from what I have paid. The balance I will pay. Number 1. So far as the corridor area is concerned, the line drawing, my lords, 50% is what diminution value they have taken. My lords, 30% is been taken as consideration from the division bench now, my lords, which have the batch of writ appeals, my lords, were connected. And the division bench in 2023 has held that, my lords, 30% is the diminution value for land.
The conditions imposed for the usage of that corridor area.
Because other crops can be used. My lords may kindly see in that my lords, para 15 of that judgment, my lords. They can grow even from 14 onwards, my lords. 14 and 15, my lords.
It is for the landowners or claimants to establish by placing cogent material on record that they would be deprived of using the land wholly or part. So there's no hard and flexible rule that it's 30%. If they can establish that they can't use the land.
They can. My respectful submission is that, my lords, in those cases, they were already not, there was no cutting of trees. Here, my lords, we have cut the trees, given him compensation. In future, my lords, he can grow other commercial crops which cannot be trees. That is the judgment, my lords. That's the basis in which 30% has been awarded in all the cases.
There's somebody showed me the notification of the union government.
That would not be applicable because that is prospective in nature. So far as those matters, my lords, which are covered prior to that notification, I have produced.
Is the same, isn't it?
No, my lords. The determination is different from the time when those were placed by the Union of India. Those notifications become prospective in nature, and those petitions which are prior to this notification coming into effect and lines were drawn.
The notification.
I have produced, my lords. I filed a memo before, my lords, with those notifications. Notifications. ಅದಿನ್ನ ಕಮ್ಮಿ ಆಗತ್ತೆ 15% ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ. I am arguing in benefit of the farmer today.
For a change.
No, my lords.
85% of the land value, market value has to be. Here, they are not giving the market value. They are giving the SR value of
The notification. I'll just clarify. The notification says 80% for tower area, not for corridor area. For tower area. And here
Actually, you referring to which notification? 15th October 15th.
The first notification itself.
No, the government of India is 15th October, isn't it?
Yes, my lords. Kindly see, my lords, item number 1 and 2. That has been adopted by state of Karnataka also, my lords, and by the board.
Compensation at 85% of land value as determined by the district magistrate or any other authority based on circle rate or guideline value or stamp rates for the tower base area.
Tower area.
85%.
Not for, yes.
Then next.
My lords, so far as corridor.
This is 15%.
Yes, my lords. And this has not been challenged. Now, going by.
This has no statutory force.
Yes, my lords, it has.
This is only a notification. Is it traceable to any statute?
It is an order. It is an order passed.
This is a guideline.
Yes, my lord.
This can't be determinative of.
No. The guideline has been adopted by way of a notification, and that notification is published in the Gazette.
Under which power, under which act is that notification issued?
Under the Electricity Act, my lords. We have adopted that.
Where's that notification?
Yes, my lords. I will produce that. Notification also. I produced this order, but I will produce the notification adopting the same. And they become prospective is my respectful submission.
Where do you get it from this guideline? It's it's not, it's prospective only.
My lords may kindly see. No, that is from General Process Act. It is.
ನಿಮ್ ಬೇಕಿದ್ದಾಗ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಆಗುತ್ತೆ, ಬೇಡಿದಾಗ ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ ಆಗುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ. In fact, to the benefit, my lords, in this, I am not even talking about the tower. Here, 100% compensation is given so far as tower area. I am not even questioning that. I am only saying, my lords, may consider.
Not questioning because it is only 4,000 rupees.
I am not, my lords.
Yeah.
So far as the area is.
What is the area occupied by the tower?
1.75.
1 point?
$1.069, my lords.
0690.
1 gunta.
What is the
1.069 gunta.
guideline value for this 1 gunta?
3,750.
ಯಾವ ವರ್ಷದ ನೋಟಿಫಿಕೇಶನ್ ಇದು?
ಆ ವರ್ಷದ
ಯಾವ ವಾರದ ಆಕ್ಷನ್?
ಅವಾಗ್ಲೇ ತಗೊಂಡಿರೋದು ಇದು.
ಎಷ್ಟಿದೆ ಗೊತ್ತಿದೆ? ಗೈಡ್ಲೈನ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ಗೊತ್ತಾ?
ಅಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ has considered it. Kindly see at paragraph 14, my lords, of the judgment of the award. Market value of the land is taken at
1,879.
ಅಲ್ಲ, market value.
Market value ಅಲ್ಲ, land value.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
It's on page number 12 of the judgment.
No.
But para number 13.
Kindly see, my lords, in the middle, in para 12, the petitioner's land situated at Ramoji Halli village, and in the year 2011-12, the market value of the land comprised of coconut plantation was at rupees 1.5 lakhs. The respondents do not dispute this guideline market value.
ಅಲ್ಲ, ಇದು para 13 of the order of the trial court.
Yes, my lords.
The market value of the land is taken at rupees 1,50,000 per acre.
Not market value, there is a land.
50% of the market value comes to 75,000 per acre.
Illa, kindly see the calculation. The market value of land is taken at 1,50,000 per acre.
What basis?
Kindly see, my lords, at para 12. Undisputedly, the value of the land diminishes as soon as electric lines is drawn across the land, and that nobody would come forward to purchase that land. Therefore, the owner will be rendered helpless even if he intends to sell this land in case of necessity. For this reason, the owner has to be paid compensation. The petitioner has produced the details of the market value of various types of lands in Ramoji Halli village for the year 2011-2012 as per Exhibit P6.
This is the guideline value?
Yes.
Guideline value as on that.
Yes. And this has been considered. I don't dispute it.
Because you can't dispute it.
I cannot dispute it. And therefore, my lords, I am not on this question of determining the market value before my lords, when it has already been determined by the trial court.
This determination was made for the first time in, when was this made?
2012.
So I'll apply the 2013 Act and say double the market value.
No, my lords, when the lines were drawn, that is when the market value have to be taken.
Determination is when?
No. The
Under section
determination,
24.
this is under section 16, seeking for enhancement, not for determination. It is not under the Land Acquisition Act where the determination.
When did you determine?
I determined when the lines were drawn and drew a measure and paid him.
When was that?
My lords, that was paid in 2012 itself. 11-12 when the lines were drawn.
Issued on 3/12/2008. Thereafter 2012, the third check was.
Yes.
2008.
Yes.
So 1.5 ಲಕ್ಷ ನಿಮ್ ಪ್ರಕಾರ ತಗೊಂಡಿದ್ದಾರೆ.
ಅಷ್ಟೇ 1,20,000 ರೂಪಾಯಿ.
1 ಗುಂಟೆಗೆ ಸರಿ ಹೋಗುತ್ತಲ್ಲ ಹಂಗಾರೆ ಇದು?
ಹೌದು.
ಅವತ್ತಿನ ವ್ಯಾಲ್ಯೂ ಆ ತರ ಇತ್ತು. ಇವತ್ತು 55 ಲಕ್ಷ ರೂಪಾಯಿ ಇದೆ ಒಂದು
ಅವತ್ತಿಂತಾನೆ ಕೊಡಕ್ಕಾಗೋದು.
ಆದ್ರೆ
ಮಿಕ್ಕಿದೆಲ್ಲ ಸರಿ.
It has to be taken under the Land Acquisition Act. Market value has to be calculated.
That is a market value. That is a market value, isn't it? This Exhibit P6.
SR value. That is a SR value. The market value for as of 2013, it has to be, collation has to be added and multiplier has to be as per Schedule 1. It has to be calculated, and there 50% demolition value has to be awarded. That would be the full compensation as per the.
Solatium adella borodu when you lost the land completely. You are retaining the land. Where is the question of you getting solatium?
Not even utilizing. They are not able to utilize.
ಅದಕ್ಕೆ ಬೇಕಾದ್ರೆ ಕಾಂಪನ್ಸೇಷನ್ ಜಾಸ್ತಿ ಮಾಡಿ, but how can you ask for 30% solatium? ಅದೆಲ್ಲ ಹೆಂಗ್ ಬರುತ್ತೆ? You are being paid extra for the trees.
Trees, full damage they have to pay. While drawing the line, they have cut off the trees.
ನಿಮ್ ಪ್ರಕಾರ ಯಾವ್ದು ಕಮ್ಮಿ ಆಗಿದೆ?
Corridor area is been not included.
ಇದ್ಯಾವ್ದು
Area is 36 guntas,
69,000 ಏನಕ್ಕೆ ಕೊಟ್ಟಿರೋದು? 69,000 ಕೊಟ್ಟಿದಾರಲ್ಲ.
69,000 ಕೊಟ್ಟರೆ ಲೈನ್ ಏರಿಯಾ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಾರಿಡಾರ್ ಏರಿಯಾನು ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ತೀವಿ.
ಲೈನ್ ಏರಿಯಾ ಕಾರಿಡಾರ್ ಎರಡು ಒಂದೇ ಅಲ್ವಾ?
ಇಲ್ಲ ಲೈನ್ ಏರಿಯಾ ಅಂದ್ರೆ ಬರೀ ಲೈನ್ ಇರೋದು. ಕಾರಿಡಾರ್ ಏರಿಯಾ ಅಂದ್ರೆ ದ ಅಡ್ಜಸೆಂಟ್ ಲ್ಯಾಂಡ್ ಅಡ್ಜಸೆಂಟ್ ಏರಿಯಾ ಆಫ್ ದಟ್ ಲೈನ್ ಮ್ಯಾಗ್ನಿಟ್ಯೂಡ್ ಬರುತ್ತಲ್ಲ.
ಏನಾಗತ್ತೆ ಸ್ವಾಮಿ, once they will determine a corridor area where the line is drawn, there will be some extra areas before the line. That is for our purposes. But where the line is drawn, my lords, that is where the compensations have been given in all the cases. And my lord's judgment also where enhancement of compensation is given is on line area, not on corridor area.
It's on corridor area.
And kindly see, my lords,
What is
here
the difference?
difference, my lords, if this is, for example, my lords, in this mazer,
36 guntas.
36 guntas is the line area. The corridor area comes to 130 something, 128
It's double.
double.
Set off will be there.
It is
for
double
every
of that
electric
area.
line set off.
In that corridor area also you impose restrictions.
Yes.
Yes, restrictions would impose on corridor area. They will not be able to utilize that corridor area. They'll be utilizing it
ಎಷ್ಟು
in a limited purpose.
128.49.
In 128 guntas.
Guntas.
Previously, it was a line area is 36.57 guntas.
So I'll take it as corridor area.
My lords.
ಆಮೇಲೆ
ಅದನ್ನ 30% ಅಂತ my respectful submission. would
ಫಾರೆಸ್ಟ್
be.
ಕೇಳ್ತಾರೆ.
50% there is a series of cases where 50% is also taken.
But ಇವರ ಡಿವಿಷನ್ ಬೆಂಚ್
50%. 50%.
30% ಅಂತ ಹೇಳಿದ್ದಾರೆ.
30% ಅಂದ್ರೆ ಇನ್ನೊಂದು ಕೇಸ್ 2020 50%.
ಇನ್ನೊಂದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಅದು.
ಯಾವುದು ಇದು?
ಲೇಟೆಸ್ಟ್ ಆದ್ರೆ ಅದನ್ನೇ ತಗೊಳ್ತೀನಿ.
Latest to 2023.
I'll take 30%.
This has been stayed by the Honorable Supreme Court. My lords, this has been stayed by the Honorable Apex Court. I'll produce that also.
ಹಂಗಾರೆ ಇದನ್ನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನೋಡೋಕೆ I'll follow this.
My lord, this has been stayed. This judgment has been stayed by the Apex Court. ನೀವಾ?
ಇದು ಹೋಗಿರ್ಬೋದು.
ಇಲ್ಲ ಇದ್ದೀರಲ್ಲ.
The appellants have also gone and the deputy CL have also gone.
ಹಂಗಾರೆ ನೀವು ಹೋಗ್ಬಿಡಿ.
ನಾವು ನಮ್ ತುಂಬಾ ಚಿಕ್ಕ ಅದರಲ್ಲಿ ನ್ಯಾಷನಲ್ ಹೈವೇ ಪಕ್ಕದಲ್ಲಿ ಅವ್ರ ಡೆವಲಪ್ಮೆಂಟ್ ಹೋಗುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿದ್ದು. ಅಷ್ಟ್ರಲ್ಲಿ ನ್ಯಾಷನಲ್ ಹೈವೇನ ಎಕ್ಸ್ಪಾನ್ಷನ್ ಆಯ್ತು, 6 lanes ಇತ್ತು. ಆದ್ರೆ ಇಲ್ಲಿ ಮಾತ್ರ ಕಾಂಪನ್ಸೇಷನ್.
I'll take 30% at 1.5 lakhs per acre.
Yes, my lords.
How much will it be per gunta?
My lords,
1.875.
3,750 rupees per gunta, my lords.
3,750.
50 per gunta.
The others are okay, neem trees, jali trees,
I am not.
That is the argument. Themselves admitted to give that compensation.
ಇಲ್ಲ ಈ ವ್ಯಾಲ್ಯೂಗೆ ತೊಂದರೆ ಇಲ್ಲ ತಾನೆ, ಕರೆಕ್ಟ್ ಇದೆ ತಾನೆ ಅದು.
ಆ ವ್ಯಾಲ್ಯೂನೇ ತಗೊಂಡು ಅವ್ರು ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
But ಸರಿ ಇದೆ ಅಲ್ವಾ, you accept that?
We have accepted their compensation to the head of the respective trees.
What is your claim?
My claim is much higher than that, but what the tribunal, after deducting the respective compensation, what they have awarded, in other trees, the tribunal has awarded at para number 22, 2,04,000 rupees.
ನನಗೆ ಇವಾಗ ಯಾವ್ದ್ರಲ್ಲಿ ಇಂಟರ್ಫಿಯರ್ ಆಗಬೇಕು? ಈ ಮೂರು ಸರಿ ಇದೆ ಅಲ್ವಾ ಟ್ರೀಸ್ದು?
ಅದು ಡಿಡಕ್ಟ್ ಮಾಡಿದಾದ್ಮೇಲೆ ಬೇರೆ ಟ್ರೀಸ್ಗೆ ಕೊಟ್ಟಿರೋದು ಇದು.
So, I mean, I'll give a clarification. My lords may kindly note this, my lord. The details of payments. Till now, KPTCL has paid 1,20,154, my lords.
1,20,000?
154. In that, my lords.
This includes land, then the corridor area.
Yes.
And also the trees.
No. I have paid till now, my lords. It can be deducted from everything overall, is my
No,
respectful
but this
submission.
money that you have paid is only towards trees, correct?
My lords,
Good towards the damages at that point of time.
yes, my lords, I have paid 1,20,154, not 1 rupee more than that. Now, my respectful submission
This is only in respect of the tree.
in respect of the trees.
What is this tree that is now awarded for cutting of 18 neem trees, 1 jali tree and 6?
It is more than that. My respect. I'll just clarify, my lords. In each, I've just made a note. My lords may kindly see, coconut trees were also cut by us. Now the trial court has awarded 27,000 for coconut trees. ಅದಿಲ್ಲ, ಅದು ಡಿಡಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನ ತಗೊಂಡಿಲ್ಲ ಪ್ಯಾರಾ 22 ಅಲ್ಲಿ. ನಾನು ಹೇಳ್ತೀನಿ, ಅಲ್ಲಿ ಪ್ಯಾರಾ 18 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. Paragraph 18 of the judgment, man. Coconut trees aged 10 years at the time were cut. So coconut trees, the trial court grants 27,000, but the deduction is only towards 58,000. So let us remove the deductions. Deductions ಬಿಟ್ಟು 27,000 ಲೆಕ್ಕಕ್ಕೆ ತಗೋಬೇಕಲ್ವಾ ಸ್ವಾಮಿ?
ಇದಕ್ಕೆ ಸೇರಿಸ್ಬೇಕು, ಇನ್ನು
ಸೇರಿಸ್ಬೇಕು, ಅದನ್ನ ಸೇರಿಸ್ಬೇಕು. ಅವಾಗ ಟೋಟಲ್ ಅಲ್ಲಿ 1,20,000 ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಾವು ದಿ ಬ್ಯಾಲೆನ್ಸ್ ವಿ ವಿಲ್ ಪೇ ದೆಮ್.
So this is coconut tree 7. Some rupees 27,000 will be added. Should be added.
First. I will just give that list. Coconut trees is 27,000 as awarded by the trial court. Neem trees is 90,000. Jali tree is 5,000. Teak trees is 60,000. Bunny trees is 4,400. Now, total of all this, my lords, with the compensation, as my lords would determine, of 30% for the corridor and tower area. Tower area, I am not touching, it's not disputed. Total of all this is 1x figure. From this x, my lords, 1,20,000 shall be deducted and awarded to them. That will simplify their case.
In Maharashtra, they have cut down several trees, different types of trees. For that, what they have cut down and what they have admitted in the merger and what they have awarded.
You tell me what they have cut down first. According to the merger.
ಇಲ್ಲೇ ಇದೆ ಪ್ಯಾರಾ ಜಡ್ಜ್ಮೆಂಟ್.
They have cut down coconut trees of about
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಾ, ಒಂದು ಚೀಟಿ ಕೊಡ್ತೀರಿ ನನಗೆ, ಏನೇನು ಕಟ್ ಮಾಡೋದು?
This matter was dismissed for a while and thereafter it was restored about 400 years after 3 years and there is no documents which is left out.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ?
Records in Majar.
ಇದೆ
Majar ನಲ್ಲಿ
R1.
different types of.
Look at the record and prepare.
They are not produced the Majar.
R1, exhibit R1, my lords. That has all the details of the trees that has been cut.
ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ರೆ ನೋಡ್ಬಿಟ್ಟು ಗಿವ್ ಮಿ ಎ ಲಿಸ್ಟ್ ಆಫ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ವಂತೆ.
Records ಬಂದಿದೆ, ನಾನು
ಇದೆ.
ಶೀಟ್ ನಾನು ನೋಡ್ಕೊಂಡೆ. ಇಲ್ಲ ವಾಪಸ್ ಹೋಗಿರ್ಬೇಕು. The connected matter, another one connected matter is there, which is single. I have filed for another of the compensation. Where only line area is considered and corridor area is not considered.
ಅದ್ರಲ್ಲಿ ನಾವೇ ಲೈನ್ ಮಾಡಿಲ್ಲ. Fourth respondent has brought
ಯಾರು ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್?
that will power
ಕಾಸು ಕೊಡೋದು ಯಾರು, ಅವರ ನೀವ?
ಅವರೇ ಕೊಡೋದು. That liability fixed on them.
ಇವ್ರನ್ನ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲಿ ಮಾಡಿದರೆ ಇಲ್ಲಿ
ಇವರೇ ಅದರಿಂದ ಪವರ್ ಡ್ರಾ ಮಾಡ್ತಿರೋದು ಇವ್ರೆ.
ಪವರ್ ಡ್ರಾ ಮಾಡಿ ಲೈನ್ ಯಾರು ಹೇಳಿ, ಅವ್ರು ತಾನೇ ಕೊಡ್ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ.
ಅಲ್ಲ, ಇವ್ರಿಗೆ ಸಪ್ಲೈ ಕೊಡ್ತಾ ಇರೋದು ಇವರೆಲ್ಲ.
ನಿಮ್ಗೋಸ್ಕರ ತಾನೇ ಲೈನ್ ಡ್ರಾ ಮಾಡೋದು ಅವರು.
ನಾವಲ್ಲ. The self execution with a permission. Entire work has been done by them.
Transmission line is owned by whom?
Yes.
Now that we have owned by us, that they are reflecting the power, that we are not liable to.
If the transmission lines are owned by you, if they are laid on your instructions by somebody else.
That we have given a permission to draw the line under the self execution, including all costs incurred by them only.
The transmission line is ultimately owned by whom? No matter who executes the work.
That maintenance, that
Can they take that transmission line and go back now?
that if they are not injecting power, that they may remove also. Because of the
They
power
sure?
change. Yes, not that wind power, not that they are injecting the substation. Up to substation, but they are injecting. That is not line, we are not.
Where is the agreement between you and them saying that the transmission line belongs to them and not to you?
That we have said that we taken a defense is so far as that we are not drawn the line. Line drawn by the fourth respondent.
But for your benefit, alwa. You pay the money and recover it from them.
They are the party.
So
The
I,
liabilities also the trial court fixed
So-
against them also.
so
Now
there's,
that ground has not been raised in this.
there is admittedly a contract between you and them. They're still supplying power to you. I'll pass a judicial order because they are no, they are served and they remain unrepresented. I'll ask them to pay the money, you recover it from them.
That I will get your exact picture is concerned, not that. Because of that, even that they have not raised ground in this petition, that we liable to pay.
ಒಟ್ನಲ್ಲಿ ಏನ್ ಮಾಡೋದು ಕೊಡಬಾರ್ದು ಅಷ್ಟೇ ನೀವು
ನಾವು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ, ಕೊಡೋ ಕೇಸಲ್ಲಿ ಕೊಡ್ತಾನೆ ಇದೀವಿ.
ಕೊಡೋ ಕೇಸಲ್ಲಿ
ಹೌದು.
ಜಾಗ
ಈಗ
ತಗೊಳ್ಳೋದು.
ಇದ್ರಲ್ಲಿ ನಮ್ದು ಪಾರ್ಟ್ ಇಲ್ಲದೆ ಇದ್ದಾಗ ನಮ್ಮನ್ನೇ ಕೊಡು ಅಂದ್ರೆ ಹೇಳಿ ಕೊಡೋದು.
ಇದು ನೋಡಿ 2013 ಮೇಲೆ ಆಗಿದ್ರೆ ಐ ಅಪ್ಲೈ ದ 2013 ಆಕ್ಟ್ ಮೇ ಬಿ ದೆನ್
2013 act of the
2017 ತಾನೇ ಇದು.
ಹೌದು.
I'll borrow the principle of the 2013 act and say you will pay factor 2 land value.
No, that is a land acquisition act ಅಲ್ಲಿ.
I'll borrow the principle.
That will not be applicable, my lords. There are judgments of the division bench of the Madras High Court. Of course, my lord's judgment is there so far as the policy is to directed to consider that policy of incorporating the Land Acquisition Act principles. But that has been stood the test with the Supreme Court as well as division bench of Madras High Court.
No test ಮಾಡಿ ನೋಡಿ. Find out as to when is the date of the cutting of the tree of your taking over the land. If it's 2013 and afterwards, I'll apply the 2013 act.
2012 I can give a guarantee that 2012. Can't say.
Next year.
Because the last act ಕೊಟ್ಟಾದ್ಮೇಲೆ ನಾವು cut ಮಾಡಿದ್ದೀವಿ.
28. See number 30.
My lords, this also can be posted on 28. I'll give a memo of calculation.
Yes.
My lords are shocked, accommodation maybe.
Matter the Tahsildar decided the matter because I think first declared issue. Yes, madam.
My lords, it
No,
may be,
admittedly, the order of the district judge was to take action after the disposal of civil suit.
please, my lord, the suit was
Civil suit is
not,
not yet decided.
it's not yet
Now
decided.
can you decide the regrant application?
My lord, that happened before the suit was filed, my lord.
Now that the suit is filed. this
Now the
order
suit
can't
is
stand.
filed and the suit, now there are a lot of impleading applications and so many other things are going.
Order of regrant can't be sustained.
Please, my lord.
Let's set aside this order and direct him to take
Status
action.
quo may be maintained, my lord. Status quo may be maintained, my lord.
You said there are other civil litigations.
It's going on, my lord. It's for judgment, my lord. There may be a direction for that and orders may be passed, my lord.
Order, there is already status quo granted in this matter. That may be
That may-
continued.
That may be continued.
Where is the counsel for the Tahsildar?
Manjesh, HH.
He was here. Sometime back.
Get him. Get him.
See number 37. Shri A.V. Gangadharappa.
ಏನ್ matter?
The way not that it is a power supply was serviced, not that it has been used for the education institute. Where without not that they are claiming charitable, that they have not produced the certificate not totally. Therefore, applicable tariff 2B, that our contention. Their contention is 2A. That earlier not that vigilance inspected, not that where that they have filed a FIR. While ultimately not that they have filed a B report, saying that it is not a theft, however, it is a misuse of electricity.
Realist.
28. See number 38. Srimati Shubha S.
Realist.
28. See number 39. Srimati Rakshita DJ.
Realist.
Sir, Mandela, 28. See number 40. Shri Manmohan PN.
Time ತಗೊಂಡ್ರಲ್ಲ? Time ತಗೊಂಡ್ರು.
Forty-one urgent. See number 42. Shri T. Sheshgiri Rao.
Last time I told you to argue, isn't it? Not ready. So.
Sorry, madam. Serial number 41, and for the petitioner was not, has not taken an adjournment. Serial number 41. WP 10676 of 2020,
Somebody took time in the morning,
not from the petitioner.
maybe responded.
That was not on the also.
Next time I'll remember.
28. 20.
43 adjourned, seal number 44, Shri B. N. Jayadeva.
List.
28.
Yes.
45 adjourned, seal number 46, Shri Shirish Krishna.
The compensation, huh?
Para 17 of the judgment.
17.
17, para 17 and page 77.
$25 coconut trees, 1 jali tree, 8 neem, 4 trees.
My lord, as far as coconut trees, my lord, there is no reduction towards cost of cultivation.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ the rate of?
Same year ತಗೊಂಡಿದ್ದಾರೆ, para 16 ಅಲ್ಲಿ ಇದೆ.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ amount?
Amount is 2,12,500.
Na per tree ಎಷ್ಟು?
Per tree they have taken 10 rupees.
10 rupees.
Yes, my lord. They are saying admittedly, in the year 2010-11, the rate of per coconut was 6 rupees. But so far as 2016-17 is concerned, it is 10 rupees and 10 rupees is taken.
10 rupees per coconut. What is the value of the tree as a whole?
The price of the tree is taken at 10 into yield of the tree per year is taken as 125. So 10 for 17 trees, my lords, 17 into 125 into 10 and multiplier of 10 is added to that.
Correct ಆಗಿದೆ ಅಲ್ವಾ?
Cost of cultivation not being reduced from the price of the coconut.
ಒಂದೇನಾ? That's all.
My lord, my lord, what happens is, what now, my lord? So far as all these fruit bearing trees.
This 10 rupees is calculated, take into consideration the cost of cultivation also.
No, that is my submission.
10 rupees is fixed on the basis of cost of cultivation
The rate of coconut in that year,
and the profit that he would make. Sum total is 10 rupees.
including profit.
Yes,
Now, when the loss, that is the expenditure incurred for raising those coconut has to be deducted.
if I am selling 1 coconut at 10 rupees,
Yes, my lord.
I'll factor in the cost of cultivation, my profit, and then determine that 10 rupees. Where is the question of again reducing the
But when I add that multiplier of 10, there is a.
multiplier of 10 is added as a multiple of the annual income that I get.
Correct, that is the profit that he's going to make.
Yes.
And therefore, my lords, so far as the income of the tree is concerned, if cost of cultivation, the principle of capital, the principle, my lords, I would say, I'll give it to my lord's discretion, what would be the percentage of cost of cultivation. But all I am saying is that, my lords, the capital method of calculation for all these, fruit bearing trees, my lords, there is a component of something which has to be deducted. That component of cost cultivation is something, my lord. Dodaka's judgment has been upheld by the division bench in that same judgment, my lord. They refer to Dodaka's judgment that has been upheld. My respectful submission is that, my lord, Dodaka's judgment says that the cost cultivation has to be deducted. My lords may take this contention, or my lord's discretion may say that it may not be 30%, but it can be any percentage that has to be deducted, is my respectful submission.
For the damages suffered by the respondent, the district judge has awarded the following sums as compensation. Para 17. It is a case of KPTCL that the trial court was not justified in arriving at the valuation of the coconut trees by taking into consideration only the price of coconut at rupees 10 and ignoring the cost of cultivation. It is therefore submitted that out of the sum of rupees 10 per coconut tree, necessarily the cost of cultivation of at least 30% would have been deducted. This argument of KPTCL cannot be accepted for the simple reason, when the value of a coconut is fixed at rupees 10 by the farmer or by any authority, obviously the cost of cultivation and other costs incurred, including and the profit, is taken into consideration while fixing the rate of the coconut. In other words, once the rate of coconut is fixed, it takes into its fold the cost of cultivation also. I am therefore of the view that the determination of the value of the coconut at rupees 10 per coconut and arriving at the value of the coconut tree at rupees 1 into 125 into 10 into 10 would be correct, and the consequential assessment of the value of the coconut trees at rupees 2,12,500 cannot be found fault with. Consequently, there being no merit, the petition is dismissed.
Laying on a judgment which was relied on Rotaka's case and held that cost cultivation up. And even the 2023, where this also relies upon Dodaka's case. And my lord, the 2023 division bench also relies upon the Dodaka's case. And in Dodaka's case, my lord, that is where it says that cost of cultivation is to be applied.
The reliance placed on the decision of Dodaka would be of no avail, since in that case, the price of coconut itself was determined at rupees 5 per nut, giving a margin to the cost incurred for cultivation and other expenses. Since in the instant case, as on the relevant date, the cost of the coconut itself was determined as 10, which as stated above would include the cost of cultivation. He said judgment will have no application.
Seal number 47, Shri Jagan Mohan MT.
List. 47 and 48.
48. 28. Seal number 49, Shri B.R. Satyanali.
ಊರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಸಾತೇನಹಳ್ಳಿ ಊರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
He's in abroad.
List
2 weeks. Seal number 50, Shri Shankara DC.
Next, Sir H. Page number?
Residential colony and enter and straight highway all comes within 100.
You objector ನೀವು? You are the objector.
May I make submission, my lords?
So all your objections were found to be incorrect. Next year, page, yes. Hmm. ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಇದು 3.
ರೆಸಿಡೆನ್ಷಿಯಲ್ ಕಾಲಮ್ ಇದೆ 94/4.
ಇಲ್ಲಿದೆ, ಹೆಂಗ್ ಗೊತ್ತಾಗತ್ತೆ ಅದರಿಂದ? ಹಾ. 88 ಬಾರಿಂದ ಒಂದು ಗ್ರೀನ್ ಲೈನ್ ಇದೆ, ಅದು 94.40 meters ಇದೆ. ಏನದು? ಅಲ್ಲ, ಟೆಂಪಲ್ಗೆ ಹಿಂಗ್ ಬರಕ್ಕಾಗಲ್ವಲ್ಲ, ಮೇನ್ ರೋಡ್ ಇಂದ ಹೋಗಿ ಬರ್ಬೇಕು ತಾನೆ. ಏರಿಯಲ್ ಡಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲ, ನಿಯರೆಸ್ಟ್ ವಾಕಬಲ್ ಡಿಸ್ಟೆನ್ಸ್. ಇಲ್ಲ, ರೋಡ್ ಇಲ್ವಲ್ಲ, ಅಲ್ಲಿ ಬರೀ ಜಮೀನ್ ಇದೆ. ಸೊ ನೀವು ಆ ರೋಡ್ ಬಂದ್ಬಿಟ್ಟೆ ಬರ್ಬೇಕು. ಸೊ ಅದಿಲ್ಲ. ಆಮೇಲೆ ಎಲ್ಲಿದೆ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಕಾಲೋನಿ? ಎಲ್ಲಿದೆ? ಆಗಲ್ವಲ್ಲ. ತಾನೆ. The petitioner is challenging an endorsement issued by the excise authorities, by which the objections raised by the petitioner have been examined, verified, and thereafter overruled. Learned counsel for the petitioner seeks to argue that the distance of the proposed CL2 license content, that the place where the
CL7 license,
where the CL7 license premises is situated is within 100 meters of a temple. He places reliance on a Google map, which is produced as annexure G1. It is to be noticed that as per the Google map, the aerial distance is no doubt 94.40 meters. But the said temple cannot be accessed from the proposed license place directly, and in order to access the temple, necessarily a person would have to traverse by the road and thereafter enter into the temple, which would make the temple beyond 100 meters. The authorities were therefore justified in considering this objection and overruling the same. I find no reason to interfere with the order passed by the trial by the authorities, and the petition is therefore dismissed.
please minutes.
Seal number 51, the MRE remitter.
Advocate appearance of ಎಷ್ಟಾಗ್ಲಿ?
Try to reach my lord, could not be.
ಎಷ್ಟಾಗ್ಲಿ ಹೇಳಿ ಅಷ್ಟೇ.
My lord, I have, my lord, I could not contact my.
Then you're giving me discretion.
Giving my lord with the hope that my lord, the bar is aware, my lord, your lordship is kind-hearted, my lord. You'll show leniency, my lord, a stern warning, my lord. To be diligent in future.
ಈ diligent ಆಗಿರೋದಕ್ಕೆ ಹೆಂಗ್ ಆಗಿರೋದು?
In MA, there was no, at that time, there was no suit was pending, my lord. Thereafter, my lord, only thing is, my lord, kindly see this, my lord, for a moment, my lord, the observation made by the Tahsildar. It pays 162, my lord.
Yes.
Second para, my lord. ಅದರಂತೆ ಹಿಂದಿನ ತಹಸೀಲ್ದಾರ್ ಅವರು ಪ್ರಕರಣವನ್ನು ಕಡತಕ್ಕೆ ತೆಗೆದುಕೊಂಡು ಉಭಯತರರಿಗೂ ದಿನಾಂಕ 9/1/2016 ಈ ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ಹಾಜರಾಗಿ ತಮ್ಮ ಹೇಳಿಕೆ ದಾಖಲೆ ಪುರಾವೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ WP ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ ಆದೇಶದ ದಿನಾಂಕ ಸೊ ಅಂಡ್ ಸೊ ಅಂತೆ ಶ್ರೀಮತಿ ಶೊಂಬಮ್ಮ ಹಾಗೂ 5 ಜನ ಇತರರು ವಿರುದ್ಧ ಏರ್ಕ್ರಾಫ್ಟ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಸೊಸೈಟಿ ಹಾಗೂ 27 ಜನ ಇತರ ಪ್ರಕರಣದಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಅವರಿಗೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶಿಸಿದ್ದು ಹಾಗೂ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ WP ನಂಬರ್ ಸೊ ಆದೇಶ ದಿನಾಂಕ ಸೊ ಪ್ರಕರಣವನ್ನು ಇತ್ಯರ್ಥಗೊಳಿಸಿರುತ್ತಾರೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಪ್ರಕರಣವನ್ನು ಮುಂದುವರಿಸಲಾಯಿತು.
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ was to act in accordance with the order of remand passed with the district judge.
No, my lord. You kindly see this order, my lord.
This entire,
There was no any observation, my lord.
this entire regrant proceedings was on the basis of the order of the district judge.
Yes, my lord. But
How can
kindly
you-
see,
can you ignore
for
the
a moment, my lord, for a moment. Only, my lord, misreading of the judgment, my lord. A bona fide mistake, my lord.
Deliberate misreading.
My lord, page 9, my lord. This matter was. ನೀವೇ ಹಾಕಿರೋದು ಇದು. ನೀವೇ ಹಾಕಿರೋದು. Lord, matter was, my lord, para 2, today learned counsel for the respondent number 7 files a memo along with copy of the memo dated so and so filed before the Tahsildar Anikal Taluk. Anikal praying to keep the proceedings in abeyance till disposal of so and so.
This OS 161/2015 was the one.
Yes, yes, my lord. Next paragraph, my lord.
Filed.
Yes, my lord.
So you were aware of the fact that the OS had also been filed.
Yes, my lord. Next para, my lord. Memo filed by the learned counsel for the 7th respondent is taken on record. Writ petitions are dismissed as having become infructuous with liberty to the petitioners to approach the Tahsildar as and when he review the proceedings, my lord. As and when he reviews the proceedings, that's where, my lord, I presume, my lord,
He was aware of the fact that OS 161/15 was filed.
yes, my lord,
Also aware of the fact that the district judge had said that he will consider this after the suit was disposed of.
this is the only argument, my lord, I could, my lord. make.
Okay, one last chance, ಎಷ್ಟು ಹಾಕ್ಬೇಕು ಹೇಳಿ?
I leave, my lord, I leave. I could not contact.
To you, why are you asking him? 8 ಎಕರೆ ಅಂತೀರಾ, ನೀವೇ ಹೇಳಿ ಎಷ್ಟು ಹಾಕ್ಬೇಕು?
I have no interest in that, my lord. Property.
No, I have interest, therefore I am telling you. How can you do this and get away with it?
I start warning and, my lord, I leave cost with regarding to the cost, my lord.
Reason wise, if I pass a judicial order, it will reflect on his record. Therefore, I am giving you the chance, that is all.
But by that's, my lord, I could, my lord, could not try to, my lord, contact the.
Then
His
I'll
transferred
pass-
and.
This will leave a mark on his service records.
Her.
Or ಯಾರ ಹೆಸರು?
That's what.
He is rather infamous for this, alva?
That's what.
My lord, kindly have it next Thursday, my lord. Senior counsel is being engaged in this matter, my lord. Kindly have it on next Thursday, my lord,
For what?
for our arguments, my lord.
All that I am saying is the Tahsildar will take into consideration this matter after the disposal of the suit. And the disposal of regrant proceedings in the light of the order of the DJ was incorrect.
Please, my lord. But
Nothing else.
we are in possession, my lord. That may be protected, my lord.
Said there will be an order of status quo which is granted here, which is
We are in possession, my lord. Let that come on record, my lord.
there is
we
an
are-
order of status quo here, the same order will continue to disposal of the
Because
suit.
what has happened is they have done 14 sale deeds, my lord, because of which they keep interfering with my possession, my lord.
All of them will be lispendence, isn't it? You have filed a
Please, my-
suit.
Please, my lord.
Until the suit is decided, your rights are not decided.
They're all hand in glove with the police, local police, my lord. They come with the
Therefore,
police
I say
and
maintain status quo.
please, my lord,
It's just-
and the direction not to interfere with my possession, my lord.
I'll simply say maintain status quo, that is all.
And police shouldn't interfere, my lord. They'll come with the police, my lord. The police, they come for all the other works, my lord.
I can't grant you an anticipatory injunction. I can only say, very well. These facts are not in dispute. The Tahsildar passed an order of regrant in favor of, in whose favor was it granted first? 2010? In favor of the petitioner. This was. Original order was 1971, first it was granted. No. 5/2/2010. To the petitioner. This was challenged by filing an appeal in MA number 32/88 alva? In MA number 26/20
2010 by respondents 3 to 8. The said appeal was disposed of by the district judge in the following terms. Page 83 and 84. As could be seen from the said order, respondents 3 to 8 were directed to approach the civil court within 3 months to get their rights determined as to whether they were the legal representatives of the Baravardars of the scheduled lands. And after their dispute regarding their entitlement as legal heirs was decided, the successful party was permitted to move the learned Tahsildar for considering the regrant applications. And the Tahsildar was directed to dispose of the same. So it is therefore clear. The district judge also noticed that in the event respondents 3 to 8 failed to approach the competent civil court to get their rights adjudicated upon, the petitioner was at liberty to move the Tahsildar seeking for regrant. Next point. It is therefore clear that the order of the district judge essentially stated that the regrant proceedings were to be taken up for consideration only after respondents 3 to 8 filed a suit for adjudication of the rights, and only if a suit was not filed would the Tahsildar get the jurisdiction to consider the application for regrant. As against the said order of the district judge, both the petitioner as well as respondents 3 to 8 preferred writ petitions in WP 6252-60/2011 and WP 4111/2010. This court, by an order dated 22nd of February 2013, dismissed both the writ petitions. This court also extended the time to approach the civil court as permitted by the district judge within 3 months from the date of the order. It is therefore clear that respondents 3 to 8 became entitled to file a suit within 3 months from the date of the disposal of the writ petition, that is from 22/2/2013. Next paragraph. Respondents 3 to 8, however, proceeded to challenge the said order of the learned single judge by filing a writ appeal in writ appeal 2475/2013. The said appeal was also dismissed by the division bench on 10th of July 2014. However, while dismissing the writ appeal, the division bench extended the granted respondents 3 to 8 to 3 more months time from 10th of July 2014 to approach the civil court. Next paragraph. The respondents 3 to 8, however, did not file the suit within 3 months. And thereafter, the petitioner herein sought to revive the proceedings by approaching the Tahsildar. At that stage, the petitioner contends that he became aware of the order of he became aware that respondents 3 to 8 had in fact approached the Supreme Court after being given the representation. SFA was filed later. That's why I said, thereafter he came to know ಅಂತ ಹೇಳಿದ್ದಾನೆ. Next N ಅಲ್ವಾ?
119.
The special petition filed by the respondents 3 to 8 was dismissed by the apex court on 27/2/2015. And while dismissing the SLP, the Supreme Court extended the time to file the suit by 1 more month. We extended by
But
1 month more. It is stated that pursuant to the said order, the respondents 3 to 8 have filed the suit in OS number 161/2015. You know the date? And it is also not in dispute that the said suit is pending adjudication.
26/3/2015, my lord.
26/3/2015. The Tahsildar, though aware of the fact that the district judge had directed respondents 3 to 8 to approach the civil court to get their entitlement adjudicated as the LRs of the Baradwadars, and despite being aware of the order passed by the division bench as well as by the Supreme Court, has nevertheless passed the impugned order, re-granting the land in question to respondents 3 to 8, and at the same time rejecting the claim of the petitioner. It is apparent from the order that the Tahsildar, being fully aware of the fact that he was required to await the decision of the suit that was to be instituted by respondents 3 to 8, has nevertheless proceeded to adjudicate upon the re-grant proceedings and passed an order in favor of respondents 3 to 8. This order, on the face of it, is illegal and apparently done with ulterior motives. The Tahsildar was basically complying with the order of the district judge, which required her to await the decision of the civil court's determination regarding the entitlement of respondents 3 to 8. Despite this specific order by the district judge, which was confirmed even up to the Supreme Court, the Tahsildar has proceeded to pass an order on the merits of the claim of respondents 3 to 8, even though their entitlement was yet to be adjudicated by the civil court. This procedure out with the Tahsildar requests to be deprecated in the strongest possible terms. Next paragraph. In my view, since the order of the district judge directing response 3 to 8 to approach the civil court and thereafter approach the Tahsildar has become final by virtue of the order of the apex court, the proceedings taken up by the Tahsildar and passing which is committed in the filing of which is committed in the impugned order cannot be sustained, and the same is accordingly quashed. The respondents 3 to 8 would be at liberty to approach the Tahsildar to revive the re-grant proceedings after their suit in OS 161/2015 is adjudicated and their rights as a legal heir of the Baradwadars is determined. Having regard to the fact that the Tahsildar has acted deliberately in violation of the order of the district judge and also the orders passed by this court and the apex court, in my view, it would be appropriate to award a sum of rupees 2,50,000 as costs to be paid by the Tahsildar to the Karnataka State Legal Service Authority. The second respondent Tahsildar, the Tahsildar was being arrayed in her individual capacity as a second respondent. Through her counsel, however, submits that the order was passed by the Tahsildar on a misunderstanding of the order passed in WP 6390-6395 by 2015, in which it was stated that the petitioners therein were at liberty to approach the Tahsildar, and the Tahsildar was required to consider the same when so approached. He submitted that since the Tahsildar has acted pursuant to the order passed in the above petition, there is no mala fides on the part of the Tahsildar. This submission cannot be accepted simply because even in the order passed in WP 6390-6395 by 2015, this court had taken note of a memo dated 25/8/2015, which had been filed before the Tahsildar, in which a prayer was made to keep the proceedings in abeyance till the disposal of OS number 161/2015, filed by respondents 3 to 8 on the file of the junior civil judge Anekal. Thus, even according to the order upon which reliance is placed, respondents 3 to 8 themselves informed the Tahsildar not to proceed with the matter till the disposal of OS 161/2015. Despite this memo of the petitioners, the Tahsildar has ventured to embark upon an adjudication and has passed the impugned order. In the light of this blatant and brazen attitude of the Tahsildar, there is no justification to accept the argument of the counsel for the Tahsildar to waive or restrain from imposing any costs. The petition is therefore disposed of in the following terms. 2.5 lakhs. I gave you the chance. I was at 5. Ready, ಬರ್ತಾರೆ ಬಿಡಿ, application ಹಾಕೊಂಡು ಬರ್ತೀರಾ? I have directed him not to take up the proceedings till the disposal of OS 161/15. Either way, even until OS 161/15 is decided, it won't be decided. The interim order of status quo granted, the pendency of this petition shall continue till the disposal of OS 161/2015.
And lots of direction to dispose of the suit within a.
ಯಾವ ಸ್ಟೇಜ್ ನಮ್ಗೆ ಏನ್ ಗೊತ್ತಿಲ್ವಲ್ಲ.
It's at arguments agide Swami. They have to pass orders. They've been postponing from many months.
The ಯಾವ ಕೋರ್ಟ್ ಅದು?
Anekal.
ಯಾವ ಕೋರ್ಟ್ ಹೇಳ್ಬೇಕು ನಾನು? I can't direct.
Principal Civil Judge and JMFC Anekal.
Principal Civil Judge Anekal,
Third
room
edition.
OS 161/15 is stated to be pending. He is requested to make every endeavor to dispose of the suit at the earliest, subject to the cooperation of both the parties. Court ಕೇಳ್ಕೊಂಡು ಮಾಡಿ.
Seal number 51, Shri M.R. Hiramathad.
ಏನ್ ನೋಟಿಸ್ ಇದು?
Eviction of the unauthorized occupant. For one of the act. Petitioner society has been purchased the property from the respondent APMC Melod in the year 1962 and 60.
Purchased.
Sale deed or
It is not purchased, your lordship. It is a conditional sale deed
ಎಲ್ಲಿದೆ ಅದು?
allotted to the petitioner, your lordship.
Where is that conditional sale deed? ಎಲ್ಲಿದೆ ಹಿರೇಮಠ ಅವರೇ?
Sir, X1 in my objections, your lordship.
What is annexure A?
Actually, it is sale deed dated 64.
There are two sale deeds which has been allotted to the petitioner for the purpose of agricultural activities has to be followed up in the said premises, your lordship. they have violated the condition on which the sale deed has been executed.
No, madam, annexure A is, do you accept the sale deed?
The condition sale deed dated 29/3/1965. Executed by the first respondent in the favor of petition marked as annexure A.
It is the same. There's no conditional sale deed, it's a sale deed. How can you cancel the sale deed unilaterally?
Definition doesn't. Definition doesn't include the sale deed.
Subject to the condition that the society executes the registered agreement to the effect that the land will revert to market committee if it is not used for the purpose.
In the sale deed, where is the recital? Then you'll have to go over to the civil court to enforce this contract.
OS has been already filed before the civil court, that is in OS number 54/19.
Yaar accurate.
A joint memo, we have already, both, it has been sent to the
Again, these proceedings have been issued.
Your Lordship. However, the suit claim was settled outside the court between the respondent and the petitioner, and a joint memo was filed in the.
Where is the joint memo?
3/2/2001, whereby the petitioner.
Page number. So you filed the suit in OS 54/97.
Your Lordship, respondent filed the suit.
ಏನಂತ ಆಯ್ತು? R5.
Where the petitioner agreed that he utilized the property for the purpose for which it is given, or to sublease the property only for the purpose of agricultural allied activities. Here permission.
Where is the memo? So your prayer for cancellation of the sale deed was not granted.
Even though the matter has been settled by filing the joint memo, again, they have before this honorable court.
Where is the joint memo? Order sheet ಕೊಟ್ಟಿದ್ದೀರಾ ಕೈಗೆ? Where is the joint memo? Ma'am, I think you have made a terrible mistake. How can you?
And for respondent number 2, Your Lordship, 1 and 2 has to be.
Who appears for R1 and R2? Once you execute a sale deed, how can you cancel it? And if a suit is filed and you get it dismissed as settled of court, the sale deed becomes final. How can you again issue a notice? ಯಾರ ಅಪೀರ್ ಅಂತಾರೆ APMC ಗೆ?
ಕಿಶೋರ್.
Relist.
52 and 52 to 54 urgent. Seal number 55.
In 55, I appear for the petitioner. And the petitioner made as a contractor. But the KPTC made as a hard for some tender work. And the petitioners have granted the tenders. And they have completed the work. Civil work, and they have awarded the civil work. But for the purpose of civil work, and they have purchased some jelly and so like that, whatever the material is required, they have purchased it. And according to the condition, tender condition, but they have to pay the royalty at the existing rate. But accordingly, they have issued the bill, but they have given the bill to the concerned authorities. The concerned authorities, instead of deducting the royalty amount, which is applicable at that point of time, they have imposed 5 times penalty on the royalty amount. But that is illegal. And the sum of the contractors, even the petitioners have challenged that imposition of 5 times penalty. But annexed, yes, is the order passed by this court. But page 36, after considering all the aspects, this court has held. At page 36, order that relates to PW department. PW is granted liberty to deduct the royalty amount as agreed in clause so and so. Agreement, it is made clear that any deduction in excess is impermissible under law. But except royalty, they cannot deduct. In spite of this amount, they have deducted the royalty amount. Therefore, I have given the representation to return that amount, which is excessively collected by them.
Yes, Devraj.
That royalty that we are entitled. But earlier that on account of the minerals, where that the circular has been issued by the Mines and Geology Department to correct the penalty, unless that they have produced as the licenses. That based on that, we are collecting the penalty and depositing the government. That in this case, that before filing of the writ petition in that is order which has been passed, whatever that amount we have collected, we have deposited to the government. That what my submission that in the last hearing itself, the government has to take that call. Even in the petitioner also given a representation as per my instructions, where that it is stated in the grounds that when that we approaches the respondent says that already deposited. He gives a representation also to the fourth respondent, that is annexure M.
Yes, madam.
The instructions for the.
ಇಲ್ಲ ಮ್ಯಾಂಡಮಸ್ ಕೊಟ್ರೆ ನಾನು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ
Because I have to, along with this order, I have to give the representation.
ಇಲ್ಲ ಅದ್ ಕೊಟ್ರೆ ಅದ್ 3 ತಿಂಗಳು ಆಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ 6 ತಿಂಗಳಾಗುತ್ತೆ.
Direction ಬೇಕಾಗುತ್ತೆ, specific direction.
Next week maybe I will.
Don't ask for time again, or else I'll ask somebody to be present.
The order was passed on 12/4/2021. Before that, 7/4 and 6/3 we have deposited before the government.
They have collected, I have produced that statement.
Next week, madam, don't make a note of it. Tiga one time kelbidi.
28. Seal number 56, Sri Authorized Ballard.
Pray for respond number 5, madam. What is the next E?
The wine shop from City of Mangalore to different place where it is challenged before my lords for the reason that the distance between the SCST colony, which is on the opposite side of the road, is less than 90 meters as per the earlier spot inspection. Thereafterwards, one more spot inspection is done, my lord.
Who are you?
Lord, we are the residents of the colony, my lord, which is established some 60 years ago. SCST association, the first petitioner number 1 is the association of the SCST. Petition number 2 and 3 are the residents of the colony, which is established opposite to the present shop where the shop is now situated. Lord, your lordship can kindly see, my lord, the earlier report, spot inspection report.
What is the reason given now regarding your objection?
Lord, they don't say, my lord, they say that it is kept in abeyance. ಇಲ್ಲೇ ಇಡಲಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಆಮೇಲೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಬಿಟ್ಟು ಓಪನ್ ಮಾಡ್ತಾರೆ.
Please read page 26, third paragraph.
ಸುಗ್ರಿ ದೂರಿನಲ್ಲಿ ತಿಳಿಸಿರುವ ದಿನಾಂಕ ಸ್ಥಳಕ್ಕೆ 13/10/20.
Read from second paragraph, ಸದರಿದ್ದೂರು ಮನವಿಯ ಬಗ್ಗೆ ದೂರಿನಲ್ಲಿ
ದಿನಾಂಕ 12/10/22 ಸುರತ್ಕಲ್ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಯವರು ಹಾಗೂ ಪಂಚನಂದಿ ಸ್ಥಳಕ್ಕೆ ಕಟ್ಟಡದ 100 ಮೀಟರ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಯಾವುದೇ ದಲಿತ ಕಾಲೋನಿ ದೇವಸ್ಥಾನಗಳು ಹಾಗೂ ಮದರಸಗಳು ಇರುವುದು ಕಂಡುಬರುವುದಿಲ್ಲ. ಮುಂದುವರೆದ ಸಗ್ರಿ ದೂರಿನಲ್ಲಿ ತಿಳಿಸಿರುವ ಸ್ಥಳಕ್ಕೆ 13/10/22 ಜನಾರ್ದನ್ ಸುರತ್ಕಲ್ ಪಶ್ಚಿಮ ಸುರತ್ಕಲ್ ಪೂರ್ವ ವಾರ್ಡ್ಗಳು ಮಾರ್ಕೆಟ್ಗಳು ಜಿಲ್ಲಾ ದಲಿತ ಹೋರಾಟ ಸಮಿತಿ ಜಿಲ್ಲಾ ಉಪಸಂಚಾಲಕರ ಸ್ಥಳದಿಂದ ಸೇರಿದ ಸಾರ್ವಜನಿಕ ಸಮಾವೇಶದಲ್ಲಿ ಮತ್ತೊಮ್ಮೆ ಪರಿಶೀಲನೆ ನಡೆಸಲಾಯಿತು. ಈ ವೇಳೆಯಲ್ಲಿ ಪ್ರಸ್ತಾವಿತ ಸಂಬಂಧಿತ ಪ್ರಧಾನ ಬೋಧನೆ ಕಟ್ಟಡದಿಂದ ದಲಿತ ಪ್ರವೇಶಕ್ಕೆ ಸಾಮಾನ್ಯವಾಗಿ ಪಾದಚಾರಿಗಳು ನಡೆಯುವ 100 ಮೀಟರ್ ದೂರದಲ್ಲಿ. ಆದರೆ ಅಲ್ಲಿ ಪ್ರಸ್ತಾವಿತ ಸಂಬಂಧ ಕಟ್ಟಡದಿಂದ ದಲಿತ ಕಾಲೋನಿ ನೇರವಾಗಿ ಅಳತೆ ಮಾಡಲು ಅಳತೆ ಮಾಡಿದಾಗ 90 ಮೀಟರ್ ಇತ್ತು. ಆದರೆ ಸದರಿ ದಾರಿ ಮಧ್ಯದ ಕಬ್ಬಿಣದ ಬೇಲಿ ಮತ್ತು ರಸ್ತೆ ವಿಭಾಜಕ ನಿಂತದೆ ಹಾಗೂ ಸದರಿ ದಾರಿಯು ಪಾದಚಾರಿ ಮಾರ್ಗವಾಗಿರುವುದಿಲ್ಲ. ಸದರಿ ದಾರಿಯಲ್ಲಿ ತೆರಳಬೇಕಾದರೆ ಕಟ್ಟಡದ ಬಳಿ ಇರುವ ಮಾರ್ಗದ ಬದಿಯಲ್ಲಿ ಹಾಕಿರುವ ಕಬ್ಬಿಣದ ಬೇಲಿಯನ್ನು ಹಾಗೂ ರಸ್ತೆಯ ವಿಭಾಜಕವನ್ನು ಹಾದು ಹೋಗಬೇಕಾಗಿತ್ತು. ಇದು ಕರ್ನಾಟಕ ಅಬಕಾರಿ ಸಾಮಾನ್ಯ ನಿಯಮಗಳು 67ರ ನಿಯಮ 5ರ ಪ್ರಕಾರ ಅನ್ವಯಿಸುವುದು. ಸದರಿ ನಿಯಮದ ಪ್ರಕಾರ ಪಾದಚಾರಿ ಮಾರ್ಗವನ್ನು ಅಳತೆ ಮಾಡಿದಾಗ ಪ್ರಸ್ತಾವಿತ ಸಂಬಂಧ ಕಟ್ಟಡದಿಂದ ದಲಿತ ಕಾಲೋನಿ ಪ್ರವೇಶಕ್ಕೆ 100 ಮೀಟರ್ಗಿಂತಲೂ ದೂರದಲ್ಲಿ ಪ್ರಸ್ತಾವಿತ ಸಂಬಂಧಪಟ್ಟದ ನಿಯಮ 5ರ ಎಲ್ಲ ಅಕ್ಷರವಾಗಿ ಕಂಡುಬರುತ್ತದೆ. Lord, there is a judgment, my lord, of this honorable court, my lord, Chinese judgment.
What is the rule? Let us see the rule. So according to you, if you measure directly, it is 90 meters. But if you go through the normal pedestrian way, it is more than 100 meters.
But Lord, the judgment which says.
Let us see the rule. Judgment can't be in contravention of the rule, isn't it?
General condition looks 19.
ನಿಮ್ ಕಾಲನಿಯವರು ದೂರ ಆಗ್ಬಿಡುತ್ತಲ್ವಾ? ಒಳ್ಳೇದಲ್ಲ ನಿಮ್ ಕಾಲನಿಯವ್ರಿಗೆ ಹತ್ರ ಇದ್ರೆ ಎಲ್ಲರಿಗೂ ಅನುಕೂಲ ಆಗುತ್ತೆ.
ಸ್ವಾಮಿ, ಆ ರೂಲ್ ಮಾಡಿರೋದು ರೀಸನ್
I think you should show your mental strength by saying we will not fall for all this.
Rule 5, and restrictions on in respect of location of shops. No license for sale of liquor shall be granted to a liquor shop or premises selected within a distance of 100 meters from any religious or educational institution or hospital or any office of the state government or central government or local authorities, or in the residential locality where the inhabitants are predominantly belonging to scheduled caste, or within a distance of 220 meters from the middle of the state highways or national highways. That may not be.
Subclause 3, my lord, kindly be. Clearly says, my lord.
Pedestrian ordinary reaches.
Reaches.
Yes, Madam, but judgment I have, which I am relying on, yeah. Sorry, I have only one copy, my lord.
Entry ಮಾಡಿದೆಯಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ.
Start.
Mark it, my lord. Sorry.
Which paragraph? ಏರಿಯಲ್ ಡಿಸ್ಟೆನ್ಸ್ ತಗೋಬೇಕಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
and 44, it might start from 44.
ಇಲ್ಲ, ಅದು ಆ ತರ ನೀವು ಹೇಳೋ ತರ ಬರೋದಿಲ್ಲ. The facts of that case, para 52.
That is in my favor, my lord, the judgment.
Is a finding of fact, but
Yes, that is true, my lord, but my perception to my lord is that, my lord, a normally person wouldn't come 100 meters to reach the shop. If it is beyond, under 90 meters, my lord, I mean, if it is less than 90 meters, because your lordship may kindly see the earlier.
this is a national
survey
highway.
report. Kindly see the earlier survey report, spot inspection.
But
It says,
the Tahsildar has given a report. There are 2 spot inspections. In both of them, they have said 100 meters. I can understand bribing one person. Three officials.
In fact, my lord, this is against me, my lord, as per their own
my lord says. that
admission,
it
my
is-
lord, it's a national highway authority.
ಅದಕ್ಕೆ ಅವರು 3 ಜನ 4 ಜನ ಸೇರ್ಸಿದೆ. ಎಲ್ಲರೂ ಎವ್ರಿಬಡಿ ಶುಡ್ ಬಿ ಹ್ಯಾಪಿ ಅಂತ. ಒಬ್ಬರೇ ಆದ್ರೆ ಮೊನೋಪೊಲಿ ಆಗ್ಬಿಡುತ್ತೆ ಅಂತ.
No, my perception to my lord is how, if it could be 90 meters, my lord, subsequently, how can it
No,
be 100
you
meters?
were
Measurement, my lord, could be.
you were powerful in getting the 90-meter radius distance measured. They were powerful in getting 100 meters.
ಅದೇ ತಾವು ಇದನ್ನ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಿ 90 meters ಅಂತ ಹೇಳಿದ್ರೆ then they
They
cannot
close
shift it to that place.
The petitioners are,
There cannot be 2 reports, that is what is.
the petitioner is a society which is objecting to the grant of license to the question respondent,
Respondent number 5.
to the
5,
5th
my lord.
respondent,
Completed.
on the ground that the license which the 5th respondent has obtained in respect of a premises is actually situated within 100 meters of the SC/ST colony. And therefore, this is a clear case of contravention of Rule 5. In the impugned endorsement, it is forthcoming that 2 spot inspections were conducted on 12th of October and 13th of October. And the petitioner, the representative of the petitioner was also present. And in their presence, the distance between the premises and the colony was measured and it was found that it was situated beyond 100 meters. And therefore, the objections raised by the petitioner could not be considered. Rule 5, subclause 1 imposes a restriction for sale of liquor in a shop or premises which is situated within a distance of 100 meters from any locality where the residents are in predominantly belonging to scheduled caste or scheduled tribe. Subsection 3 of section 5 states that for measuring the distance of 100 meters specified in subrule 1, the distance should be measured along the nearest path by which the pedestrian ordinarily reaches. This would indicate that the aerial radius would not be of any consequence, and the distance which a pedestrian would have to travel is the manner in which the distance is to be construed. The authorities, the impugned order also indicates that even the Tahsildar has submitted a report that the premises to which license was granted was not objectionable and there were no prohibited structures within 100 meters. In the light of the clear finding by the authorities that the premises of the 5th respondent was situated beyond 100 meters, no fault can be found with the impugned endorsement. The petition is therefore dismissed.
Grateful.
Bill number 57, Shrikant B.
Connected to the scheduled property,
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
electrical connection ಕೊಡ್ತಾರೆ. 2018, there's been several representations that is validated. Page number 30, next 15.
30.
ತಾವು ತಿಳಿಸುವಂತೆ ಸಾವಿರವು 2009ರಲ್ಲಿ ನಾವು ಸಂಪರ್ಕಪಟ್ಟು ಆಗಿನ ನಿಯಮಾವಳಿ ಪ್ರಕಾರ ನಂಬರ್ 3.1 ಪ್ಲಸ್ 0.6 ಬೇಕಾಗಿತ್ತು. ಅದರಂತೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಲಾಗಿದೆ.
ಹಾಗೂ 2017ರಲ್ಲಿ ತಾತ್ಕಾಲಿಕ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಕಲ್ಪಿಸಿದ್ದು. ಅದು 2010ರ ನಿಯಮಾವಳಿಯಂತೆ EHT ಮಾರ್ಗ ಕೆಳಗಡೆ ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಿಸದೆ ಇರುವ ಷರತ್ತುಗಳು ಹಾಗೂ ನೀವು EHT ಮಾರ್ಗ ಕೆಳಗಡೆ ನಿರ್ಮಿಸುವುದನ್ನು ಖಚಿತಗೊಳಿಸಿದೆ. But in fact, the property was purchased in the year 2014 and he has constructed in the year 2018. As per the circular 2019, Lordship kindly peruse the objection filed by the respondent. Page number 13, annexure R3, my lord.
Yes.
As per this circular, the respondent has refused the provide the electrical connection. ಈ ನಿಯಮಾನುಸಾರ ಹಾಲಿ ಇರುವ ಕಟ್ಟಡಗಳಿಗೆ ಇರಬೇಕಾದ ನೀರು ಮತ್ತು ಸಮಾನಾಂತರ ಅಳತೆ ಈ ಕೆಳಕಂಡ ಇರಬೇಕಾಗುತ್ತೆ. All these schedule has been complied by the petition, and that photography has been furnished along with the mail transaction with the respondent. Page number 3. Rest of the petitioner's house, other residents have been provided the electric connection. Page number 63. ನನ್ನ ಮನೆಗೆ ಮಾತ್ರ ಕೊಡುವುದಿಲ್ಲ, ಅದನ್ನ ಮಾರ್ಕು ಮಾಡಿದ್ದಾರೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ದಿಸ್ ಕಮ್ಯುನಿಕೇಶನ್ ಹ್ಯಾಸ್ ಬಿನ್ ಮೇಡ್ ಟು ದಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಏನು ದೇವರಾಜ್? ಇಲ್ಲ, ಅಕ್ಕಪಕ್ಕದ ಮನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ತಾನೆ?
ಹಿಂದೆ ಕೊಟ್ಟಿದ್ದಾರೆ. But I given a tabular when that power supply has been sanctioned. My statement of objection.
Now, do you think this is fair that what applies as a yardstick to them?
Subsequently, that regulations which has been amended. New Act 2003 Act came into force.
Where is the regulation?
61, my kind of bill.
Regulation?
Regulation.
ಕೊಡ್ಬೋದು. 2019ರಲ್ಲಿ ಸರ್ಕಲ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ. But in fact, the petitioner completed the house in the year 2018.
Next R3 ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
R3 ಸೆಕೆಂಡ್ ಪೇಜ್ ನಂಬರ್ 14 ನಲ್ಲಿ ಯಾವುದೇ ಕಟ್ಟಡವು ರಸ್ತೆ ಮತ್ತು ವಿದ್ಯುತ್ ಮಾರ್ಗದಿಂದ ಸುರಕ್ಷತಾ ಅಂತರವನ್ನು ಬಿಟ್ಟು ನಿಯಮಾನುಸಾರ ನಿರ್ಮಿಸಬಹುದಾಗಿದೆ. ಆದ್ದರಿಂದ ವಿದ್ಯುತ್ ಮಾರ್ಗದ ತಂತಿಯಿಂದ ಸುರಕ್ಷತಾ ಅಂತರ ಇರುವ ಕಟ್ಟಡಗಳಿಗೆ ಮಾತ್ರ ತಾತ್ಕಾಲಿಕ ಶಾಶ್ವತ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ನೀಡುವುದು. ಮುಂದುವರೆದು ಸುರಕ್ಷತಾ ಅಂತರವಿಲ್ಲದ ಕಟ್ಟಡಗಳ ಸಮೀಪ ಅವೈಜ್ಞಾನಿಕವಾಗಿ ಬ್ರಾಕೆಟ್ ಮಾಡಿ ತಂತಿ ಸ್ಥಳಾಂತರಿಸುವುದು, ತಂತಿಗಳಿಗೆ ಪೈಪ್ ಅಳವಡಿಸುವುದು ಸುರಕ್ಷತಾ ದೃಷ್ಟಿಯಿಂದ ಸರಿ ಇಲ್ಲದ ಕಾರಣ ಶಾಶ್ವತ ಪರಿಹಾರ ಕ್ರಮವನ್ನು ಮಾತ್ರ ಗ್ರಾಹಕರಿಗೆ ತಿಳುವಳಿಕೆ ನೀಡಿ ಸುರಕ್ಷತಾ ಅಂತರವನ್ನು ಕಾಯ್ದುಕೊಂಡಿರುವ ಕಟ್ಟಡಗಳಿಗೆ ಮಾತ್ರ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ನೀಡಿ ಮುಂದೆ ಉಂಟಾಗಬಹುದಾದ ಅಪಘಾತಗಳನ್ನು ತಡೆಯುವ ನಿಟ್ಟಿನಲ್ಲಿ ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವುದು. But in fact, there is a gap between the EHT and the roof of the petition house. There is a 22 feet. In fact, they have inquired about it.
ಎಷ್ಟು ಬೇಕಾದ ಈ
ಅಡಿ ಮೇಲೆ ಇದೆ from the roof of the petition house.
ಇದರ ಪ್ರಕಾರ R3 ಪ್ರಕಾರ ಎಷ್ಟಿರಬೇಕು?
R3 ಪ್ರಕಾರ ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, annexure C ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ 3.7 plus 0.33 ಮೀಟರ್ಗಳಷ್ಟು ಇರಬೇಕಾಗಿದೆ.
ಅಲ್ಲ, this is 66 kV ನಾ?
Yes, 66.
So ಎಷ್ಟಾಗಬೇಕಂದ್ರೆ how many meters?
That 33 kV 3.7 meters plus added 0.3 meters for every additional 33 kV.
So 4.1.
4.1.
ಎಷ್ಟು ಅಡಿ ಆಗಬೇಕು ಅವಾಗ? 12 feet ಅಷ್ಟೇ ಅಲ್ಲ?
12 feet.
22 ಅಡಿ ಇದೆ ಅಂತಾರೆ.
That they are saying that we are not maintaining, BESCOM is not maintaining the high tension line. KPTCL is maintained.
And you very fast.
We are sought for that measurements and report also. Where that annexure R6 which they have sent, that less than so far as that measurement, but they refer that the measurements also has been conducted, but that report has not been furnished. I'll secure that report, the exact measurements it is concerned.
22 ಇಂದ ಬೇಕಾ? ಇನ್ನೂ ಟೈಮ್ ಬೇಕಾ ಅದಕ್ಕೆ?
ಅಲ್ಲ, ನಾನು ಇದನ್ನ ಓದಿದ್ಮೇಲೆ that they are referring that in the inspection report also measurement.
ನಿಮ್ಮ ಕರೆಂಟ್ ಇಲ್ವಾ?
19 may kindly look at.
ಆಮೇಲೆ earlier connection while demolishing that building, you have surrendered that meter, and while constructing the new building, they have provided a temporary connection. After the completion of the construction, they have disconnected that temporary connection also.
Annexure R6 may kindly look. The report I will check it.
I'll impose cost on you for 4 years.
That because of that, unless a clearance is given by the maintenance, that we are not
No.
maintaining a high tension line.
The fact that you decided to give me a connection to all others.
Plus
Sir.
all others that earlier to that where that in the 2010 regulations came into force. In the 2010 regulation that earlier vertical and horizontal distance has to be maintained. But subsequent to 2010, 61 says that there is a prohibition to construct under the overhead line. That I read that in the 61. Clearance from the building of the line voltage exceeding 650 volt.
The photograph that he has produced indicates the house in front, the house by his side. All of them have electricity except this house.
That all of the electricity the earlier that vertical and horizontal.
So they are
distance
safe
has to
now.
be maintained.
So they are safe. The old
Yes.
buildings are safe. New building is unsafe.
That new building that on account of the restrictions in the regulations.
Adike, so only this new building is unsafe now. All other buildings are safe because it was at a time when the regulation was different.
That we have to follow the rule, not that where that is in law it is there.
I will say that you are selectively applying the rules, therefore you will have to pay costs.
But that is not the selective limit that it is a selective limit that when 2010 it came into force that applies this. Based on this only that the annexed R3 circular has been issued to the all the.
When he surrendered his earlier connection
Yes.
and started a new construction, did you inform him that this was the requirement if you do this?
That we have intimated.
Elide.
That I'll produce that records also. I'll bring that record.
ತಿಂಗಳಿಗೆ
That as well as the report which has been measurements made by the KPTC.
ತಿಂಗಳಿಗೆ ಎಲೆಕ್ಟ್ರಿಕ್ ಬಿಲ್ ಎಷ್ಟು ಕಟ್ತೀರಿ ನೀವು? ತಿಂಗಳಿಗೆ ಅಲ್ಲ ನಾರ್ಮಲಿ ಎಷ್ಟು ಕಟ್ತೀರಾ? 2,000 ರೂಪಾಯಿ per month for the past 2 years.
That we are not denying. We are secure the report from the KPTCL. The KPTCL has not made a party.
For 2 years, I'll impose 2,000 rupees per month.
That cannot be because of the way that they are constructing electrical accident. Then they come forward saying that it is a compensation. So we have maintained that to that extent that it is a distance, all those things.
When will you secure the
The next
distance?
week itself a report that I'll secure. Because they have conducted a measurements also, vertical, all that report, but they have not stated clearly that the reference is there. That is the way I have secured that report.
We list 28. Seal number 58.
May kindly be fifth may kindly. Again, I should not ask.
Seal number 58. Srimati Shubha S.
Petitioner Miller. This matter pertains to granting compensation for cutting of trees and drawing lines.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಇದರಲ್ಲಿ ಎಕರೆಗೆ 2 lakhs ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ. ಕೊಟ್ಟು there were coconut trees, mango trees and other trees.
It will start from page number 19 of the judgment. 54,500 per gunta is considered in this at page number 21.
ನೀವೇನ್ ರೇಟ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ ನಾವು ಹಾಕಿಲ್ಲ. Every aspect has been considered. The Honorable Supreme Court judgment and judgment of this Honorable Court has been discussed in detail. And it will start from para number 19.
Alright.
That here on the basis of the guidelines issued by the Ministry of Power, we have calculated and 2 lakhs per gunta has been granted, madam. But we learned
What is the extent of the land?
4.5 guntas we have utilized, madam.
And you granted at what rate?
2 lakhs per acre, madam. 2 lakhs per acre and amount is fixed, my lord. As I was explaining, 85,000 for tower B, madam. There is a tower and we have granted as per the guidelines issued by the ministry and we have granted, madam. But here the learned judge, without taking the amount granted, now kindly come to page number 19, madam.
19.
Running page number 30, madam.
Yes.
Internal page number 20 of the judgment. 19, my lord, the learned trial judge says, in order to apply the aforesaid analogy, it is important to assess the market value of the land. It is the contention of the petitioner that the market value of this land is rupees 1 lakh per junta, but he has not produced the SR guidelines value of his land. However, he has relied upon the judgment in RA number 132 of 2021 dated 11/2/2022, passed by Principal District Court, Tunkuru. On perusal of the said judgment, it appears that the said judgment was rendered in respect of land situated at Mallenahalli village, Nittur Hobli, Gutti Taluk. Whereas in the present case, property of the petitioner was situated in Jelabuni village, Kelur Hobli, Gutti Taluk. Therefore, though both the lands are situated within the jurisdiction of Gutti Taluk, Tunkuru district, the said lands are substantiated at different properties, and therefore the judgment in RA number 132 of 2021 relied by the petitioner is not applicable on the case on hand. However, this court in similar miscellaneous petitions in which the respondent has drawn the high tension 66 kV electric transmission line, the property value of the land is assessed at rupees 54,500 per hectare. In order to maintain the uniformity and assessing the diminution of land value, this court thinks that justice would end if the amount of rupees 54,500.
Have you challenged the other, have you challenged the order passed in respect of the other cases in which 54,500 per gunta is fixed?
Have been, my lord, it would have.
It would have been ಅಲ್ಲ, yes or no? ಇಲ್ಲಾಂದ್ರೆ ಒಬ್ಬರಿಗೊಂದು ಕೊಟ್ರೆ ಎಲ್ಲರಿಗೂ ಅದೇ ಕೊಡ್ಬೇಕು ತಾನೆ?
Correct, correct.
So ಇದ್ರದ್ದೇನು
On the basis
ಇಲ್ಲ
of-
ಎಲ್ಲದನ್ನು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರು, ಇದೊಂದೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು.
ಇದು ಒಂದೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು for other grounds also, madam. The other grounds is, the learned judge has again reassessed the value for mango trees, my lord, and we have already paid 4 lakhs. My lord, we find it that.
he has granted 25,000 towards 10 coconut samplings.
We had granted 636 rupees for coconut sapling, my lord.
Hmm.
But the learned judge, without any documentary evidence, without any evidence at all, has taken into consideration 2,500, which is highly exorbitant, my lord.
ಏನದು ಬರೀ 10 ಮರಕ್ಕೆ ತಾನೆ?
10 saplings.
1,300 ರೂಪಾಯಿ 13,000 ಜಾಸ್ತಿ ಕೊಟ್ರು.
2,500 ಸಾವಿರ ಕೊಟ್ಟರು.
663 ರೂಪಾಯಿ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದನ್ನ ಡಿಡಕ್ಷನ್ ಮಾಡಿದ್ದ. ಸೊ ಇಟ್ ಬಿಕಮ್ಸ್ 3,100. ಅದು ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಮೇಲೆ ಮ್ಯಾಂಗೋ ಟ್ರೀಸ್ ಆಲ್ಸೋ ಪೇಜ್ ಕಂಟಿನ್ಯೂಷನ್ ಮೆಥಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 22. In this case, the respondents have cut 14 badam mango trees. In this respect, the petitioner has claimed compensation at rupees 50 per kg and 500 The respondents have already paid total compensation of rupees 4,57,611. Calculation is shown towards cutting of 14 mango trees, my lord. The learned judge has assessed, my lord, again in the next paragraph, in the next page, my lord.
You paid how much?
We have
paid-
paid 4 lakh, my lord, 4,57,611. For 14 mango trees. Continuation, my lord, in the next page, the learned judge has made a complete recalculation and arrived at 6,12,500, my lord.
125 per kg per year, 50 rupees per kg.
I feel it, but after coming to a reassessment, now 4 lakhs na deduction ತೋರಿಸಿಲ್ಲ. Just before paragraph number 24, my lord, deducting the cost of cultivation.
You had calculated rupees 25 per kilo, na?
We have
20,
He has calculated 50 rupees per kilo.
50
Yes.
rupees per kg, 125
Deducted
kg
the cost of cultivation
per
at
year.
30%.
I am not challenging that, my lord. Now,
So 6
deduction ತೋರಿಸಿಲ್ಲ ಅಷ್ಟೇ. The final, now my lord can directly come off to the findings at the last page, my lord. Page number 28, my lord. The petitioner is entitled for enhanced compensation of 73 lakhs. That also I will not, I'll just leave it, my lord. If 25,000 for coconut saplings can be reduced, my lord.
Hmm.
Adu. Further, the petitioner is entitled for enhanced compensation of rupees 6,12,500 towards cutting of 14 badam trees, mango trees with interest at 8%. Idralli 6 lakh ali 4,57,000.
Whatever is paid by you, I will direct them to deduct.
Yes, ma'am. Yes.
ಅಷ್ಟೇ, ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ I'll confirm.
Others and all I leave off, my lord. 5,000 banana plants ಗೆ ಪರವಾಗಿಲ್ಲ, 5,000 curry plants ಗೆ ಪರವಾಗಿಲ್ಲ, 10,000 eucalyptus tree ಒಂದೇ ಒಂದು, that is little exorbitant. Further, my lord, further the petitioner.
Substantive ಏನಾರು ಇದ್ರೆ ಹೇಳಿ, ಚಿಕ್ಕದ್ ಬೇಡ, substantive ಆಗಿ.
ಒಂದು, my lord, 40,000 they have enhanced.
For what?
40,000 was cutting of 8 Hercules trees, my lord. ಅದೊಂದು ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಮಾಡಿ.
ಸ್ವಲ್ಪ ಬೇಡ ಮೇಡಮ್, ಏನ್ ಕಮ್ಮಿ ಏನಕ್ಕೆ ಮಾಡ್ಬೇಕು ಹೇಳಿ ಫಸ್ಟ್.
Without any basis, they have, just like that, they have enhanced.
ಯಾವುದು?
Hercules trees.
And according to there were no Hercules trees there?
There are, my lord, and they have already granted compensation. ನಾವೇನೇನ್ ಕೊಟ್ಟಿದೀವೋ ಅದು ಡಿಡಕ್ಷನ್ ತಗೊಳ್ದಿಲ್ಲ.
ಇಲ್ಲ ಮಾಡಿದಾರಲ್ಲ.
ಇಲ್ಲ ಅಡಿಷನಲ್ ಅಂತ ಹೇಳ್ತಾ
Market for Hercules tree for the purpose of making domestic furniture. Therefore, market value is at the higher end. 5,000 ತಗೊಂಡಿದ್ದಾರೆ as against 1,500.
ಅಡಿಷನಲ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅದನ್ನ.
ಕಮ್ಮಿ ಮಾಡಿದ್ರೆ ಸಾಕು. Others I am not challenging. Mango trees, coconut.
The district judge, in respect of the lands which were acquired and in respect of the trees which are cut for laying the transmission line, has awarded the following sums, page 38 and 39. Learned counsel for the petitioner submits that the amounts awarded towards cutting of 10 coconut saplings and the award of rupees 40,000 for Hercules trees are on the higher side and therefore requires modification. She also contends that the amounts awarded for the 14 badam mango trees are also on the higher side and required to be reduced. She ultimately states that the trial court has not passed any order for deduction of the amounts that have already paid as compensation. In my view, the arguments advanced by the learned counsel petitioner cannot be accepted. The district judge, on consideration of various factors, has examined the matter in great detail and has come to the conclusion that the petitioner was entitled to a sum of rupees 25,000 towards 10 coconut saplings and has determined the value of each saplings at rupees 2,500. Taking into consideration that coconut saplings provide an annual income for a long period of time. Similarly, the district judge has determined the value of badam mango at rupees 50 per kilo as against the rupees 25 determined by the petitioner. In my view, this assessment of badam mango at rupees 50 per kilo cannot be said to be exorbitant, and therefore the same request be confirmed. As far as the award of rupees 40,000 towards 8 Hercules trees, the trial court has taken into consideration that there is demand in the market for Hercules tree for the purpose of making furniture, and therefore it would be reasonable to assess the value of each tree at rupees 5,000 per acre. In my view, this reasoning cannot be found faulted at all. However, the argument of the learned counsel that the tribunal has not taken into consideration the amounts that have already been paid and it has not directed the amounts already paid to be deducted request to be considered. It is made clear that out of the total compensation payable under the impugned award, the sums already paid by the petitioner shall be deducted and the remaining amount shall be made over to the respondents. Subject to the above, writ petition is dismissed. Okay. Rest I'll continue, repeat next week.
4:30 PM matter.
Serial number 20, second list ಅಲ್ಲಿ ಇದಕ್ಕೆ ಬರೋದು ನೈಟ್ ಶಿಫ್ಟ್ ಬರೋದು ಲೇಟ್ ಆಗುತ್ತೆ ಡಿಸ್ಮಿಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ serial number 20 72/21 ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್
5 ಸಲ ಕೊಟ್ಟಿದ್ದೇನೆ ನಾನು.
ಫೀಸ್ ಕೊಡಿ ಸರ್ ದಯವಿಟ್ಟು
5 times ನಲ್ಲಿ ಕೊಡಲ್ಲ.
ಫೀಸ್ ಕೊಟ್ರೆ
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ ರೀಕಾಲಿಂಗ್ ಆಯ್ತಾ, ನಾನು ರೀಕಾಲ್ ಮಾಡ್ತೀನಿ. ಸಬ್ಜೆಕ್ಟ್ ಟು ಯು ಕಂಪ್ಲೇಂಟ್ ವಿತ್ ಆಫ್ ಸಬ್ಜೆಕ್ಟ್ಸ್. ನೀವು ಮಾಡಲ್ಲ, ತಿರ್ಗಿ ಮರ್ತು ಬಿಡ್ತೀರಾ ನೀವು. ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೇನೆ, ಸೈನ್ ಮಾಡಿದ್ದೇನೆ. ಸೈನ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ಸೈನ್ ಮಾಡ್ಬಿಟ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ. ಎಲ್ಲ ದಿವಸ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಬಚಾವ್, ಇಲ್ಲ ಅಂದ್ರೆ 26.
Serial number 76, Shri Ravi Kumar.
No, sir. We continue with the argument, but one subsequent development. One of similarly situated horticulture department, the same one of their colleagues, he had approached the Karnataka Administrative Tribunal, seeking for regularization. That application was dismissed, and they had filed a writ petition, which was heard and reserved. And on 20th, yesterday, my lords, it was pronounced. So it was dismissed. His writ petition, my lords, was dismissed, where similar issue was considered, but it's not yet released. I just want to bring it to the notice of the court by the same colleague of the petitioners. He chose to approach the tribunal.
Let us see.
Please, my lords. But I just, I'll argue this matter because my lords, for at Uma Devi's case, we were but there's no detailed consideration. There, the entire thing was those 4 conditions irregular. He was not able to furnish. The tribunal had rejected on the case that you are not able to show that you are recruited as against a sanctions post or with regular recruitment. And then the tribunal had dismissed it. Then his writ petition, my lords, got dismissed. But the way my lords are looking at it insofar as the 1990 GO, including the background to the Dharwad PWD, that consideration is certainly not there. But it might have a bearing because he's similarly situated to the petitioners. I will, my lords have Umadevi case, please. Lords, from para 7, my lords have already seen that. That these 2 aspects. Then how the matter was referred, my lords, in para number 10, there is an order of reference. Finally, my lords, I just want to read 2 paragraphs, para 12 and 14, before I come to 52 and 53, my lords.
Yes.
In spite of this scheme, there may be occasions when the sovereign state or its instrumentalities will have to employ persons in posts which are temporary on daily wages as additional hands, or taking them in following the required procedure to discharge the duties in respect of the post that are sanctioned and that are required to be filled in terms of the relevant procedure established by the Constitution, or for work in temporary posts or projects that are needed permanently. This right of the union or the state government cannot but be recognized, and there is nothing in the Constitution which prohibits such engaging of persons temporarily or on daily wages to meet the need of the situation. But the fact that such engagements are resorted to cannot be used to defeat the very scheme of public employment, nor can there be a court say that the union or the state governments do not have the right to engage person in various capacities for a duration or until the work in a particular project is completed. Once this right of the government is recognized and the mandate of the constitutional requirement for public employment is respected, there cannot be much difficulty in coming to the conclusion that it is ordinarily not proper for the courts, whether acting under Article 226 of the Constitution or under Article 32 of the Constitution, to direct absorption in permanent employment of those who have been engaged without following a due process of selection as envisaged by the constitutional scheme. I'm just placing emphasis on the last, without following the due process of selection as envisaged by the constitutional scheme, because that is where irregular and illegality comes in.
But that's why I was repeatedly saying that
The government order, whether it can be interpreted. Lords, I'll just
sanction for
Please, my lord. Lords,
continuing them.
I have already said this, my lords. I will be fair to the court too with regard to the actual position. Lords, there have been cases where courts have ordered regularization, attained finality in Supreme Court. Some have been regularized, and there are big the multitude of rather I can use the word multitude of employees in that same batch out of 36,300. Hardly, my lords, a few of them would have got regularized, maybe till around 200, 250, because there are 2 schemes. 100 people were there in those schemes, and then subsequently, my lords, individual orders were there. Now, there have also been cases like this where most of the cases will get dismissed. Like I just referred to yesterday, there was one dismissal. So, in none of the cases,
this point is being considered.
in none of the cases, my lords, the entire it was just that the 4 conditions are there. Most of the cases, it's always been like this. After Umadevi, we issued a circular, 4 conditions with regard to sanction post and the intervention of the Then in most of the cases, they were not able to show any documentation on the basis of which they were appointed and all that. And on inter partes, my lords, there have been judgments where the state has succeeded and they have attained superannuation. This has happened. But apart from this batch of employees, the regularization petitions have most have been filed from autonomous institutions where they have completed 5 years, 10 years, 20 years. And my lords have seen the printing press case. These kinds of petitions have been coming. And from BMCRI or some other institutes where autonomous institutes also, my lords, have been engaging. So those are the kind of petitions. But at the end of the day, my lords, insofar as the interpretation after Dharwad PWD and we issuing the government order and then the Umadevi's case, the fact of the matter, though I have argued this point, my lords, before another bench where but it was which was also referred to that is at 12611 of 2023. But the court granted relief, but again asked us to reconsider in view of the light that interim orders will not apply to them because earlier we had reconsidered. So there is no judgment, my lords, which considers this entire history on the basis of which, especially for this batch of employees. So now that we have brought them under the 2013 Act and they're at the age of attaining superannuation, any order, my lords, passed, my lords, directing us to regularize, again will set the clock back insofar as the state is concerned with regard to the financial resources is concerned, how to balance it.
The
At the s-
2012 Act, according to me, recognizes the fact that
Please, my lords, if my lords are placing that interpretation, but subject to me, my further submissions, my lords, I'll try to persuade it in the way, I'll just project what the state wants to actually put across, my lords. But in case my lords are considering it, my lords, and giving them relief also, why I'm putting this as a caveat on behalf of the state is that some balanced approach, my lords, because at the end of the day, my lords, the entire state resources, suppose one regular, I'll just give an example, my lords.
understand so if you can come out with some via media where your burden is reduced at the same time, their lawful rights are benefited, I'll consider. But
Lords, if my lord, I will be fair to the court also, my lords. If it's sent back to the government also, my lords, that at this point in time, it should be through a court order itself, my lords. But what I'm asking is that it could be a balanced court order, is what I'm saying. So that
what do you think would be the right balance?
Lords, right balance, I'll take my lords through this.
Regularization is a must.
Lords, that's what my lords.
The benefits that arise out of regularization, to that extent, maybe there can be some kind of curtailment of the benefits.
My lords, the use regularization, my lords, again will give rise to parity claims in thousands. That is our problem. It's the when we say regularized, without bringing them under that and trying to
what other relief can I grant them? Suppose I don't regularize them.
Please, my lords.
What is the relief that you think I can grant them?
Continue
the status quo.
ಇಲ್ಲ ಅಲ್ಲಲ್ಲ ಅಂದ್ರೆ ಬಂದಿದ್ದಾರೆ ಇಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿ ಏನಾದ್ರು ಅಪಾರ್ಟ್ ಫ್ರಮ್ ವಾಟ್ ಎವರ್ ಎಕ್ಸ್ಗ್ರೇಷಿಯಾ ವಿ ಆರ್ ಪೇಯಿಂಗ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದ 2013 in one case my lords were pleased to grant but they had service, still they had service left out. In one case Supreme Court has given 4 lakhs per petitioner, but I know, my lords, that might in the entire scheme of things it might look like a pittance at the end of the day, but law also could be laid down, my lords, and subject to, I'll continue the argument, my lords, so that my lords can my lords, I was at paragraph number, I finished 12, my lords. Can I read 14, my lords? Yes. This is the parity argument, my lords, which gets rejected. During the course of the arguments, various orders of the courts, either interim or final, were brought to the notice of were brought to our notice. The purport of those orders, more or less, was the issue of directions for continuation or absorption without referring to the legal position obtaining. Learned Counsel for the state of Karnataka submitted that chaos has been created by such orders without reference to the legal principles, and it is time that this court settle the law once and for all, so that in case the court finds that such orders should not be made, the courts, especially the High Court, would be precluded from issuing such directions or passing such orders. The submission of learned counsel for the respondents based on the various orders passed by the High Court or by the government pursuant to the directions of the court also highlights the need for settling the law by this court. The bypassing of the constitutional scheme cannot be perpetuated by the passing of orders without dealing with or deciding the validity of such orders on the touchstone of constitutionality. While approaching the questions falling for our considerations, it's necessary to bear in mind and to bring about certainty in the matter of public employment. The argument on behalf of some of the respondents that this court having all once directed regularization Dharwad PWD, all those appointed temporarily at any point of time would be entitled to regularization, since otherwise it would be discrimination between those similarly situated, and in that view all appointment made on daily basis temporarily or contractually must be directed to be regularized. Acceptance of this argument would mean that appointment made otherwise than by regular process of selection would become the order of the day, completely jettisoning the constitutional scheme of appointment. This argument also highlights the need for this court to formally lay down the law on the question and ensure certainty in dealings relating to public employment. The very divergence in approach in this court, the so-called equitable approach made in some as against those decisions which have insisted on rules being followed, also justifies a firm decision by this court one way or the other. It's necessary to put an end to uncertainty and clarify the legal position emerging from the constitutional scheme, leaving the high courts to follow necessarily the law thus laid down. So, my lords, what I'm submitting on the basis of this paragraph is that even before the Supreme Court, claims of parity were made on the ground of Dharwad PWD case, stating that some were regularized, some are not being regularized. Lords, at the end of the day, the cutoff was 1/4/2006 when Umadevi came in, when there was a shift in the law with regard to the right of regularization. Earlier, it was Dharwad PWD which was holding the field. Multiple orders were passed on the basis of that. Then finally, my lords, there were conflicting judgments. Even after Umadevi, my lords, from the research, we have both ways, my lords. It is if the court wants to regularize, my lords, there are a set of precedents. If the court does not want to regularize, also there are a set of precedents. So this is how it is, my lords. We have equal number. It is equal.
We right in saying that Umadevi's case only pertains to those recruitments which are made without adopting any procedure at all. Please, not to all employments made by the state in view of that government order.
Please, then the history before the government order, how these people actually became daily wages my lords may have to be traced.
No, the fact remains that they were daily wage employees.
Please, my lords.
The fact remains that their appointment was without following the due procedure.
Please, my lords.
You had a right to discharge them the moment Dharwad case came up.
Please, my lords.
But you gave them this status
Please, my lords.
of continuing as employees.
Please.
By virtue of that particular clause.
240.
So therefore,
240 days.
that is the procedure that you follow to retain these people.
Please, my lords. No, that is the follow to retain this principle as daily wages. They never came into MREs.
Therefore, you were aware of the fact that they were irregularly appointed.
Please.
But had put in more than 240 days.
Please.
And therefore you decided to continue them.
Please, that could be the correct
So
position.
whatever the appointment was at best irregular,
Please.
which became regular on the completion of 240 days.
Please, my lords. In this context, my lords, maybe that because what happens is if without reference to the government order and the history of how the government order of 1990 and the subsequent events, if any my lords regularization is awarded, it will be like it might affect my lords other cases where
I will make the distinction that the GO that I want to interpret
please, my lords.
grants sanction to the post that they were holding.
It could be one way of looking at things. It could be.
Therefore, Uma Devi's case will not come in the way of regularizing them.
Still, the right of regularization flowed only 142.
But since Uma Devi says
Please,
that they ought to be sanctioned posts,
please, my lords.
you conferred sanction on those posts by virtue of that government order.
No, my lords. My lords
Until
can
then, there was no sanction.
please, my lords. My lords can say that for the purpose of satisfaction of point number 1, that was first one of the 4 matter, the first parameter. The sanction is based on the interpretation of the government order dated so and so. But
then
at the end of the day,
Uma Devi's case won't come in the way.
Uma Devi's case, my lords, will not come in the way insofar as sanction. If my lords take that interpretation, still, my lords, I'm trying to persuade it otherwise.
Trying to put forward my thoughts.
Please,
Once
please.
the sanction is there,
Please, my
or
lords.
this deemed sanction,
Please,
or sanction which can be inferred, then all that remains is 10 years service,
10 years service, my lords. My lords,
which
all
either way they add.
my lords, as on Uma Devi, they had. And the fact that we continued them, Uma Devi was 2006, 2013, they even from 2006 till 2013, they continued, my lords, to be daily wages. That is also a fact. If some of them were not, but they were not formally brought to monthly rated establishments. In 2013, that is 7 years after Uma Devi, from 6 to 13, my lords, they continued. It is not that the state even discharged them at that point in time. 2013, the Daily Wages Protection Act was brought into force, and then their right to continue till superannuation continued. But the only thing is, in this batch of petitions, my lords, if it is, we have the petition code. Lords, we have a certain batch of petitions. This is in respect of the horticulture department. So
prepare a synopsis for me highlighting the entire history of this.
Please,
It
my
will be
lords.
easier for me.
I'll do that, my lords. And I also felt that for the assistants, my lords, there are both views regularizing this. But that is now everybody knows about it, because once we go to SCC and give Uma Devi, we get both ways, both for and again.
Purti Kotpudi, I'll try to
Please, my lords.
create a path of somewhere where
Please.
these people can be taken care of, or else this will continue forever.
Please, my lords. One, since my lords have already spent some time on this, my lords, and it's been parted for too long, and we will also assist the court. I'll also assist the court, so that some finality, my lords, whether it's right or wrong from the state's perspective is different, but some finality could be. And only thing is, it should, and it will cover only these cases with regard to 84 to 1990 batch, my lords, because that
This
is
case only considers those people.
these are all 84 to 90 batch.
1784 Admale.
84 to before the government order came into force. The other batch my lords who were taken as daily wages after 1990, their rights are different. That's we are not concerned
There was
with.
a ban, therefore you couldn't have recruited them at all.
Please, my lords.
After the government order.
Government order, my lords, there was nothing. Thereafter, it was a regular thing. I'll give a synopsis, my lords, but I might require a week's time, my lords.
I've told you broadly what I think,
Please, my lords.
but I'm only trying to think what is the way that I can restrict the burden on the state.
Please, my lords. We'll be grateful, my lords, if my lords.
But what is it that I can reduce? As it is, you are paying them under 2012 lakh, that ex gratia payment, subject to 20 months.
Please, my lords.
And even if you give them all the benefits, at the time of retirement, what back wages, yeah, they would not get. Please.
But the other benefits, how much would be the burden for you if I were to?
No, my lords, only in this case, the burden will be one. But the moment this gets decided, there are similarly situated claims. That was 13,600 out of them in different departments. Matters are pending.
All of them are between 1784 and this 90.
Between 1784 and 1990, we have 13,600 employees. And out of that, my lords, there is a batch which has retired. Persons, they're all most of them are on the fag end of retirement. Matters are pending, my lords. There have been matters that are pending across in different courts, at division bench, at single bench, and somewhere they succeed, somewhere the state is succeeding. That's what is happening.
So regular pay scale from the day of the regularization.
Please, my lords.
And terminal benefits.
Please, my lords. The pension though, namge alle, because that is where it hurts me.
How do you get over that? What is the alternative?
Lords, I'll verify. If suppose, no, it all depends, my lords. Again, suppose I'm told my learned friend was actually agitating that some of them are actually retiring now. So if you fix again a cutoff, then one person might be more lucky than the other. That is how it might happen. I'll just get back to my lords based on. ಅದೇ ಮಾಲ್ತಿದಾಸ್ ಕೇಸ್ ಅಲ್ಲಿ
ರೆಗ್ಯುಲರೈಸ್ ಮಾಡದ್ಮೇಲಿಂದ ಸಂಬಳ ಫ್ರಮ್ ದಿ ಡೇಟ್ ಆಫ್ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಏನು ತೊಂದರೆ ಆಗಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಿರೋದು ಪೆನ್ಷನ್ ಎಲ್ಲ ಕೊಡೋದಕ್ಕೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ
ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೆನ್ಷನ್ ಎಲ್ಲ ಅರ್ಲಿಯರ್ ಆಗಿ
ನಿಮ್ಮೊಬ್ಬರು ಕೊಟ್ರೆ, ಈ ಒಂದ್ ಬ್ಯಾಚ್ ಕೊಟ್ರೆ 13,000 ಜನ ಬರ್ತಾರೆ, ನಮಗ್ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೊಂದು ದಾರಿ ತೋರಿಸ್ಕೊಡಿ ನಂಗೆ.
As per their affidavit filed before this honorable court, in this case, 1,255 vacancies are there. As of today also, they filed the affidavit and.
13,000 ಕೇಳಿ, 1,200 ಆಯ್ತು. ಇನ್ನು 11,000 ಇರ್ತಾರಲ್ಲ, ಅವ್ರು 11,000 ಜನಕ್ಕೆ ಪೆನ್ಷನ್ ಕೊಡ್ಬೇಕಲ್ಲ. ಅದಕ್ಕೆ ಒಂದು ಹೇಳಿ ನಂಗೆ. ಏನ ಬೇರೆ ದಾರಿ ಇದೆಯಾ? ಪೆನ್ಷನ್ ಬದಲು ಬೇರೆ ಏನಾದ್ರು ಲಂಸಮ್ ಪೇಮೆಂಟು ಆತರ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಹೆಂಗಿದ್ರು 20 months ಅನ್ನ ಕೊಡ್ತಾರಲ್ವಾ? 20 months you pay, right? Under the
it comes to around 5 lakhs maximum. There's a limit.
Salary differences may not be there.
ಅದನ್ನೇನಾದ್ರು ಲಂಸಮ್ ಮಾಡಕ್ಕಾಗತ್ತಾ? ಯೋಚನೆ ಮಾಡಿ ಹೇಳಿ. At the same 50,000 per year.
Please, my lords. It's 4,99,000 total ex gratia that they get. Maximum limit is that. Most everybody will have that under the Daily Wages Act from 2000.
If they are regularized, what is the amount that they'll get?
No, regularization is
Pension. 50% of the pension, alva?
50% of the basic. Plus dearness allowance also will.
What is the regular salary that they will get if they are regularized?
These persons will get 24,000.
24,000.
24,000.
Not 17,000 my lords is the basic. They are getting that basic, which is the lowest of time class in terms of the 2013 Act.
Regularization, what will be their pay?
Same thing, my lords. Regular, if suppose today they are regularized, and suppose they are superannuated tomorrow, that will be the same thing. Suppose he superannuates after 2 years, then he will have increments.
Suppose I say they are regularized with on the completion of 10 years.
Please, my lords.
From that day, if you calculate what is the pay that they will get?
My lords, then increments and everything.
No arrears.
Please, only notional fixation.
Notional fixation. From
Please.
today, they will get that.
No, my lords, then 10 years from the date, it should be from Umadevi thereafter, my lords.
If I were to interpret 68/1990
Please, my
and
lords.
say 10 years from the day when they complete the service
Please, my lords.
as daily wages,
Please.
from that day they'll be regularized. Notionally, you will give them all the benefits,
Please,
but the financial benefits will flow from the date of the order.
I'll do all the different calculations and just
Mention if there's some real problem, which I think there is.
Please.
If you can give me an alternative. If
Please,
the-
my lords, I will do multiple calculation and then pass it on just to bring it to the notice of the court. Whether from 10 years after their from the date of the appointment or from 1990, if we take it from 10 years, what would be the, if they are given a notional pay at that point in time, and with increments, what as on the day of superannuation, what would be there, and we'll find out also out of the petitioners how many people have more service left out, so that if they are fixed at a particular pay scale, how much increment they will get. I'll just make those calculations.
This is most of them, 90% of the petitioners are going to retire within 2 years. Within 2 years.
ಅದಕ್ಕೆ ಆ ಪೆನ್ಷನ್ ಏನ್ ಮಾಡ್ಬೇಕಂತ ಅಷ್ಟೇ ನನ್ಗೆ, if there's an alternative to pension where I can reduce their burden, then I'm thinking some lump sum payment given to all of you in lieu of pension because of the financial constraint that they're thinking, but that should be voluntary. I can't, I pass an order, then you go file an appeal.
Please, my lords, that
Then this
I
thing-
get it. It'll be unending, my lords, and it will not be fair to them also and to the court also.
So if there's no consent coming. from
Consent,
the-
then it,
which I don't think it will come, but nevertheless, if it comes,
please,
then it'll be easy for me to persuade them.
please.
Or else I'd say pension, you know what to do.
And then consequences have to follow. If my lords fixes the date of regularization, all consequences follow. Only thing is back pages, my lords will say, no
date of the
financial,
order, I
from the date of the order. So my lords have to leave it at that, and we'll have to.
Pension subject to what you say, what the
Please,
government
Mr.
can say, I'll,
Please.
if the government is reasonable, I'll ask them to be reasonable and pass an order.
Please, my lords.
Or else I'll go with the flow and say,
The flow, please. I'll just come back to my lords.
If they give the consent, no problem with that. Otherwise, if the
ನೋಡೋಣ ಇರ್ರಿ.
judgment is passed, then,
ಅವ್ರ ಕೈಲಿ ಆಗಲ್ಲ, ಬಟ್ ನೋಡೋಣ, let us see whether they'll come out and show some magnanimity.
No, my lords, it is not my magnanimity, it is, I have
I
to.
understand, but I feel, I really feel sorry for these people. I don't think this is the way we should treat a citizen. This is, no, not as a, forget about all that philosophy. Just the basic fact that we're exploiting them like this is not fair. Their entire lifetime of
Please.
adult life.
Please.
They wasted now. They can't go anywhere. And now to say that this is all you're condemned to be forever, that pricks my conscience to a very large extent. That's why I'm struggling so much to
Please.
see that there's some balance worked out.
Please.
You can't exploit a person for 30
Lords,
years.
I get it, lords, because before I came this side, I've been appearing for the petitioners also on that side. In
that's what-
regularization matters also.
That's what is hurting me from that day. That's why I'm really thinking so hard on this.
Please.
Something which does not cheat them of their labor. Not
Please.
that they're very virtuous people and all that.
Please.
But for having made them work for 25, 30 years.
No, lords, I'm not able to get the mind of the court. I'll see, lords, what best can be.
These people, petitioners appointed 1980 for 85, 86. Now 2024, more than 40 years, my lord, now.
That's what I'm trying to tell him.
And they're coming for work morning in the.
If it was just a question of these 100 odd people, I won't have been worried. If this order has an effect on 30,000 people, I'm a bit apprehensive. ನೀವು ಆದ್ರೂ ಕೆಲಸ ಮಾಡ್ತಿದ್ರಿ, ಸರ್ಕಾರ ಡೈಲಿ ವೇಜರ್ ಅಲ್ಲ ಹಂಗಲ್ಲ, ಒಂದ್ಸಲ ಒಳಗ್ ಬಂದ್ಮೇಲೆ ರೆಗ್ಯುಲೈಸ್ ಮಾಡೇ ಮಾಡ್ತಾರೆ ಅಂತ, ತಪ್ಸ್ಕೊಳಕ್ ಆಗಲ್ಲ ಅಂತಾನೆ. That is the hard part. They were the lucky 300. When do you want it?
Lordship, may I mention one matter?
Yes.
In serial number 63, there is an interim order, Lordship, that may be.
Will you extend?
Great.
1st of July, 4:30, Monday, 4:30.
Put up, sir.
Sir,
Put up is 65, sir.
28ನೇ ತಾರೀಕು ಸರ್. ಸರ್ 28.
28
ಹಾ.
ಅಲ್ಲ, ಒಂದ್ 2ನೇ ತಾರೀಕು ಹಾಕಕ್ಕಾಗಲ್ಲ ತಮ್ಗೆ.
ಸರ್ ಅವ್ರು ಪಿಟಿಷನರ್ ಹೇಳ್ಬೇಕಲ್ಲ ಸರ್.
ಅಲ್ಲ, ಹೇಳಿದ್ದೀನಿ ಅವ್ರಿಗೆ, ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ.
ಸರ್ ಆಯ್ತು, ಇದು ಆಗೋಗಿದೆ ಆಲ್ರೆಡಿ.
ಹೌದಾ? 28
28 ಹಾಕಿ.
ಆಯ್ತು ಬಿಡಿ. ಆದ್ರೆ ಹಾಕಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಬೇಡ ಅಷ್ಟೇ.
ಅದು
Sir,
28
ಆಯ್ತಾ?
63.
1ನೇ ತಾರೀಕು 4:15.
Sir, court officer 63, when will it be?
28ಕ್ಕೆ ಬರುತ್ತೆ.
Sorry, sir? I couldn't hear you.
28 ಅಂತ.
22nd, is it?
28 ಮೇಡಮ್.
28, thank you.
2 ವಾರ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಂಪ್ಲೈ ಮಾಡೋದು.